Yesterday, my lord, I moved this memo yesterday. Lordship directed to be listed today. The papers were bulky, so scanning was delayed, so it could not come up today. Maybe take about 2:30.
Thanks.
Which roast? In fact, I've already served a copy on Mr. Krishna yesterday.
VDAs.
Please, I already served a copy yesterday itself on Mr. Krishna. We'll take up 2:30.
My submission also same, my lord.
Give it.
My submission also same, my lord. The recovery is expected today, my lord. Yesterday I have moved memo, my lord. But that is today, but not today.
What is the
9 crore 20 lakh
tax?
Yes, my lord.
Tomorrow it will come.
No, my lord. Expire. The date is expired today, my lord. 73 lakhs.
State or central? State or central? Hem Kumar? Is Hem Kumar?
Lords.
I'm sorry. Some recovery is saying urgent. He wants it at 2:30.
Award matter, my lord.
Huh? Don't say covered. Emergency 2:30 means only emergency.
If they furnish a
Otherwise,
copy,
come tomorrow.
if they furnish a copy, I can.
Advance in the already file agya.
Huh?
2 weeks before I file.
That is there, but why? You want it tomorrow? We can take it
It
tomorrow.
can be called tomorrow, my lord, because 2:30, my lord.
Yeah.
2:30 before court hall number 10, we have few matters listed.
So we'll have it tomorrow. If anything happens, we'll reverse it. If anything happens between today and tomorrow, I will
But if
reverse
they give me the copy now, my lord, I can instruct the officer.
You give an extra copy immediately.
Okay, I will give.
We'll have it tomorrow.
My lords,
My lords, KLR matter.
my lords, my 7 rule 11.
One of you shout, I'm not going to take any memo. You please do
My
one by
lords.
one. I'm not going to run away here. Yes.
My lords, my 7 rule 11 CH-6 matter, my lords. It was rejected. I've filed a CRP, my lords. My lords, I'll be forced to lead evidence, my lords, if this is not taken up.
Matter.
Matter is in the trial court. It is listed on 26th, my lords.
On 20.
26th, it is listed, my lords.
Then let us see. I'll have it on Monday before the regular court.
My lords may have it tomorrow, my lords.
No. I'm taking only emergency matters. If we have instructions, regular court will look after routine matters. Give it date. Good.
With my lord's kind permission,
Yes.
KLR matter, my lord, I'm for an impleading respondent. This honorable court, my lord, passed an order directing the appellant's possession not to be disturbed. But the truth is that I am in possession, plan sanction tagondidini, RERA approval agide, they are
Monday.
my lord, tomorrow, please, my lord, they have come to the site and they've stopped the entire construction work.
Monday we'll take it up. Thursday onwards, leave. Monday it'll come. Yes.
Monday, please.
Tahsildar, my lords, has passed an order for demolition. Lords, it is all compliant, my lords, and ready. But, my lords, now the RI, my lords, has passed and given a notice, my lords, for demolition tomorrow. Lords, that is why, my lords, for 2:30, my lords, I'm passing. My lords, I have given the reply. The Tahsildar passes an order saying that, my lords, I have not given any reply, my lords, insofar as the notice is concerned. Lords, it is a residential premises, my lords, of the petitioner.
On what ground they seeking for demolition?
Lords, that it is a Port Karab land, my lords, and it belongs to the government. Lords, it is a Port Karab land which belongs to the petitioners, my lords, ever since 2000. Lords, the government, my lords, says that it is a Port Karab land, it belongs to Sarkar, and it is encroached by us.
Let us see if the government, you just find out. You give him a copy.
Please, I'll give him a copy, my lords. My lords may take it at 2:30, my lords, because an order is passed, my lords, for demolition also. That is why, my lords, there is.
Find out. Let us.
I'll serve, my lords, the copy right now, my lords, to the other side also.
My lord, KLR matter, my land has been acquired. 5 untas has been left out, but even that 5 untas has been given to one construction company who is building the matter, construction. Therefore, matter is very urgent. May be taken up on 23rd, my lord, Monday.
It's tax matter, my lord, state of recovery. Kindly can be taken up tomorrow. Fresh matter.
Writ of demolition, my lord. As per the order of Disallowance Court, my lord, in the year 2019, Appellate have issued, my lord. Now, my lord, the Tahsildar issued notice for demolition, my lord. ಅದರಲ್ಲಿ ಖರಾಬ್ ಕಟ್ಟೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಈ ರಿಕ್ವಿಷನ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ Appellate ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಮತ್ತೆ ಈ ಡೆಮೊಲಿಷನ್ ಆರ್ಡರ್ ಇಶ್ಯೂ.
When is the date fixed for demolition?
Saturday, my lord. And tomorrow, my lord.
Tomorrow. Government, just find out. Fresh matter.
Fresh matter.
My lords,
Give an extra copy now.
KLR matter, memo for disposal, covered by judgment is a my lord.
No, that's
My
after
lords, there's a-
next week.
my lords.
Next week. Covered, all covered matters, KLR,
My lords.
will come next week.
Lords,
4 years ಆಗಿದೆ ಸ್ವಾಮಿ ಖಾತಾ ಕೊಟ್ಟಿಲ್ಲ. That's why I'm.
Huh?
4 years ಆಗಿದೆ ಮನೆ ಕಟ್ಟಿ ಖಾತಾ ಕೊಟ್ಟಿಲ್ಲ.
That urgent matters, only urgent I'm taking.
Urgent.
Lord,
No,
Four-
that's next
4
week.
years ಆಗಿದೆ
Next
ಮನೆ.
week, madam. I'm only going to take any demolition. Just wait.
For the Monday, so I filed a memo for disposal in this case. My last 4 days, its matter is listed.
KLR.
VDA matter. So kindly have it on Monday matter. Because the 83, 84, 73 was listed, but this
Yes.
was not reached.
Lordship, I am the proprietor of
Monday.
trading business. I received notice from Service Tax Department based on my IT
Fresh
return,
matter, fresh.
and it's fresh return, and I am not at all complaint Service Tax.
Tomorrow.
May I request for today 2:30?
How today we can take it?
my lords,
Tomorrow. You serve again,
my lords,
Fresh matter, my lord. Fresh matter. It may be taken up
Tax.
tomorrow. Please, my lord.
tax.
Matter.
Tomorrow.
my lords, there's a
Just
fresh.
wait, just wait. Yes.
Tomorrow or Monday, madam.
Tomorrow, fresh.
KLR matter, Your Lordship.
Fresh matter, my lord, next week. my lord.
Tax. Tax.
My lord.
And date good.
Lordship,
Lordship.
total 6 matter, my lord. It's a SC matter.
Ah.
My lord, we are the purchaser. Now the notice has been issued to hand over the possession, my lord.
What happened to your appeal?
Appeal has been restored, my lord. I mean, the appeal has been granted in the favor of grantee, my lord.
You challenge that order.
Yes, my lord.
Tomorrow.
Kindly have it today, my lord, because today is the last day, my lord. They have issued
For
a
what?
notice
Last day for what?
to hand over the possession. They have told us to hand over the possession on this date, my lord.
When was the notice issued?
On 10th, my lord. I had moved memo yesterday also, my lord, but the matter has not been put up.
Tomorrow we'll see. If something happens, I'll reverse it.
Please, my lord.
Tomorrow, fresh
Much
matter.
okay.
KLR matter, my lord. Next week, one date maybe. Quota 6 matter.
Next week, you just hand it over. You don't have to mention. Put up next week, whatever you want, you take it.
My lords,
Lordship,
wait.
KLR matter, Your Lordship.
my lords,
Lordship, KLR matter. Withdraw ಮಾಡ್ಕೊತಿದ್ದೀವಿ. Kindly have it on Monday.
Only urgent matters which can't wait till Monday, you mention.
Urgency.
Other memos will be given to the court officer of that court.
Your Lordship, KLR matter. I have filed earlier in application. This is the 4th time I was
Give it,
moving the
give it.
memo. Kindly have it on Monday, Your Lordship.
No, all
Because
that
the
will be-
urgency is the respondents are doing the POD in the suit scheduled property. Your
Let us
Lordship.
see, let us see.
Monday, Your Lordship.
No, that instruction as per the court officer of that court.
We have filed earlier in application also. This is
See,
the 4th time I was
demolition,
moving.
only matters like demolition, disposition I'm taking. Rest of it only before regular bench.
Lord's
Please,
tax
date
matter.
may be given, Your Lordship.
Tax matter, fresh matter,
Ah.
tomorrow.
Take it. Togo, fresh matter tax.
tax matter, my lords, fresh matter.
Togo,
Tomorrow.
KLR matter.
yes.
My lords, tax matter, my lords. Warrant is issued, my lord, despite my paying the amount in full. Today at the end of list, my lord. I have moved twice, my lords. Today at the end of list, my lord.
State or central? Central department or state department?
GST, I have heard the copies. They are also convinced, my lords. I don't know why they want to have a pound of flesh. Every amount is paid 7 years back, my lords.
Which state department or central?
State, my lords.
State. Him Kumar just,
GST copies also I sought, my lords.
you give an extra copy to him Kumar.
I will give, my lords. Right now, I will give it.
Now what is the, can it not wait till tomorrow?
8855, my lords. I will give, my lords. The rented council is fair enough. I have paid 7 years back, my lords. It is adding insult to the injury.
Can we have it tomorrow?
My lords, I am not unable to operate the account. It is seized for the last more than 1 week, my lords.
Tomorrow.
Lordships.
Fresh matters listed.
I'll
Tax matter, fresh matter, my lord.
Huh?
Tax matter. And it's a fresh matter. Previously also I moved the memo, which was not listed.
Give it, note of it.
Tomorrow, my lord.
Fresh.
My lord, this is a bank attachment, fresh matter.
Sir, Monday, Tuesday ಆಗುತ್ತೆ.
Either way of the original grantee. But my lords, that is now being not given to me, but my lords, it's being given to somebody else who's being claimed as a grantee. My lords. Lords, I will request you to have it tomorrow.
Tomorrow. You serve advance copy on PDA.
I served on VDA also.
Krishna.
I will do so.
You tell him it's coming tomorrow. If you give it to him now, he'll be able to take instruction.
My lords, customs.
KLR VDA, do it.
Tax man. fresh,
Lords,
tomorrow.
fresh tax
Tomorrow.
fresh tax
Matter, my lord.
Put it.
My lords, customs matter
Tomorrow.
can be listed for tomorrow. Counsel is traveling from Delhi, my lord.
That please, if that is the reason I'm rejecting.
No.
I'll reject.
No, my lord.
Yes, next.
Well, hold.
Huh? Tax, fresh. Give it.
My lands were gold has been seized by the customs official.
Fresh or old matter?
Old matter. Tomorrow.
Correct. Old matter, we don't know if it's going to reach. We're taking a
So
chance.
he's a professional artist, my lord.
No, that may be so.
Loss of job is.
If the matter reaches, I can take it up. Out of turn, I won't take it up. Now, if you are having outside counsel, you request them to come through online. I am comfortable for online. So taking a chance of coming. If they come, it doesn't reach, I'm not going to take it out of turn. So
But kindly have it tomorrow.
let us see. Depends on the date. You find out. If you want a specific date, you can give the memo and ask the court officer. Let us.
Have it on.
Special court FTM court matter. Filed under section 482. This charge here before charge was preferred, my lord, came to be dismissed. Division petition has been filed before the level session. Not stay has been granted, my lord, and notice has been issued to the complainant. Meantime, my complainant died. And my lord, the petitioner not unable to bring any legal response since she was alone, my lord. She had no children and husband was also died. Now, my lord, some of her relatives came under section 10302 of CH-7 before the magistrate court as a legal entity. And I have been deprived by the opportunity of Indian petition.
Thursday. Thursday. 26th.
On 2nd March, eviction notice is issued against this petitioner for eviction of their from their and giving 15 days time. Yesterday also we moved the matter 2:30. Eviction notice is issued on 2nd March.
But then you must give an extra copy to the government advocate now, because if you are taking at 2:30, they have to get instruction.
PDA also is there.
Huh?
PDA.
Who is giving the eviction notice?
PDA.
PDA. Okay, Krishna.
Krishna, please. That's all.
2:30.
KLR matter, my lords. Tahsildar has issued eviction notice, house property, my lords. My grant application is still pending. Tomorrow.
You give an extra copy to the government.
Please, my lords.
Lords, one fresh matter, SC/ST matter, my lord. Petitioner is the student who belonged to SC community, my lords, and he has completed his SSLC. Now he is pursuing his studies in next level, my lords. And in the meanwhile, government has issued a notification stating subcasting of the categories, my lords. In the meanwhile, KA has issued notification prescribing a specific date for uploading the category certificate, my lords. We have just seeking a mandamus. We have given our representation to the Tahsildar to issue category certificate, my lords. It is they are making so much of delay, my lords. We have some urgency in the matter. End of the list, my lords.
Oh, no.
We are just seeking for a mandamus, my lords.
That is the other court.
In the meanwhile, my lords, what is the urgency in the sense there is a last date for uploading the category certificate.
Is the last date?
My lords, 30th, my lords.
Monday.
And since we are just seeking for a mandamus to consider my representation,
Monday.
tomorrow, my lords, at least.
My lords, court all 6 fresh matter, my lords. Based on the rejection of the plaint, we have challenged it. Kindly give an opportunity, my lords. Kindly post it tomorrow, my lords.
What is the urgency for tomorrow? When is the last date?
It was rejection of plaint has already
Then
been given.
it will come on Monday. Give it.
It's a ADB matter, my lords, pending matter. They have acquired the part of my property, and now they have acquired the complete property without there being any notice, my lords.
Fresh matter.
Pending matter, my lords, 2025.
So, date.
SPLR matter. In this matter, my lord, the ADLR issued an endorsement stating that, my lord, the suit filed by the petitioner is suit was filed, the interim order was granted. It is not my favor, but if the A has not done the Puri and Bureau is concerned.
Monday.
Please. Matter, my lord.
Tomorrow. Fresh. Tomorrow. Yes.
The sole petitioner was expert. My lord has dismissed the petition was rejected. I have filed a lot of petitions also.
Give it. Date code. Let us see. Date code.
There are 63 residents, my lord, in a private layout. 3 side, my lord, is a gated community. 1 side is, my lord, government land. Earlier it was a private property. There are 5 of them, Lord, lawyers, including myself. Lord, we made a request to the minister and deputy commissioner, Lord, why are you closing the road? In spite of that, they closed the road, Lord. Only 2 feet, Lord, pathway we have been using.
No.
Now, Lord, we have given
KLR.
KLR matter.
Then your regular bench. I can't take up hearing matter.
Interim order, we sought for interim order, my lord, only to
Monday.
make use of the road, my lord.
Monday. Regular, it must come before that roast.
Lords, I appear for the respondent BDM, Lords. I have filed a modification of the interim order. What had happened is, this property is relating to the urgency is this, Lords. This property is relating to contiguous studio, my Lords, where, my Lords, formation of the road is going on. But, my Lords, there is an interim order passed by this court. Even with respect of the property to maintain the status quo, entire project is, my Lord, it's stalled, my Lords. Please, my Lords.
Serial number 9.
Lord, this is a batch of matters very old, 2017 and 18-19, where NCLT has passed the order and approved the plan, and whereby the impugned orders do not survive anymore. So, and I got 2 more memos for fresh matters. Not give it this week or next week.
Serial number 9.
Yes.
Serial 9, my lord.
My lord.
I seek for, my lord, on next week, my lord.
At
24th.
At request, relist the matter on.
My lord, serial number 14.
Yes.
My lords, Samir Gupta. My lords, 24th may be given.
At request, relist on.
My lords, serial number 36, my lords, same on 24th, my lords.
Relist on.
Well, that's next page. Serial number 49, my lords.
Yes.
That's this matter, my lords, was with regard to section 153A of the Income Tax Act. My lords had heard it. My lords wanted to hear it again, my lords, on a particular date, but it didn't reach, my lords. Any chance, my lords, where I can
May
be
reach today.
Please, my lords, I will not.
Yes. Yes.
Serial number 59, not reporting the assignment matters. There is urgency matter, serial number 59 matters. It's a case of Exparte order number 130. Vehicle and goods are both under seizure. Requesting for a remand so that I can produce the details and get the vehicle seized. Exparte order matters. Requesting for a remand. Can it be taken at 2:30 or at end of the list matters?
We will take it in fresh matters list tomorrow. Yes, Hem Kumar.
Emmanuel. Please.
List in fresh matters list tomorrow.
Serial number 80. Learned friend Jyoti Madi asked me to seek an adjournment on her behalf. Readings are complete.
Relist the matter.
On 26, on learned AHG is available. 26.
Who's appearing?
Not there online now, but he's requested that if the matter is being adjourned to 26th of March. And it's a Thursday. Thursday, he made a request because he is in Bangalore. It's a
Delhi. Huh? You take a chance. 26.
interim order.
26. Interim order in operation extended till the next day. Yes.
Well, 85, serial number 85. It is listed several times and not reached now. In the bank attachment, service tax case. I am in actually Andhra Pradesh. And the entire service rendered in Andhra Pradesh. My office is in Andhra Pradesh.
List in fresh matters list tomorrow. You just inform the others.
Serial number 91. The batch of matters challenging tax orders such in the motor vehicle taxation. There are other similar matters with identical facts. I'll furnish a list. They may all be listed together.
List along with the PP numbers also date.
Interim order.
Some date may be
Order
fixed.
in operation is extended to the next 7th.
Serial number 93.
774.
Google matter. But they have it on 25th. Somebody has been informed. 25th. So they understand the ASD will appear in this matter on 26th. But they have it on 25th, 26th, and 25th at 2:30.
Hmm? 25th. 26th actually is the MP MLA roster. So I don't know. Anyhow, 25th I'll take.
25th.
Give to the respondent.
My lord, serial number 1, my lord. I appear for the petition, my lord.
Yes.
Well, in the present petition, I have challenged in order of the BDA at annexure E, my lord, wherein my application given pursuant to the order of writ appeal passed in the Kempegowda layout case was rejected for dropping of acquisition of my land, my lord, 3 acres in survey number 94.
Serial number?
Serial number 1, my lord.
No, at page and the table.
Please, my lord, please, my lord. Annexure E, my lord, in serial number. Serial number 13, my lord. 13. 13, my lord.
What have they stated?
They have stated, my lord, high rise vertical development ಯೋಜನೆಗೆ ಮೀಸಲು ಇಟ್ಟಿರುವುದರಿಂದ. And that is a common order passed in upon several applications, my lord.
Yes.
My lord, as per the writ appeal order, my lord, the status of the land has to consider at the time of the acquisition, my lord. Annexure A is the Mahajur, my lord. At the time of acquisition itself, the layout were formed and the house were constructed, my lord. Annexure A, my lord. RCC ಮನೆಗಳಿರುವುದು, ತೆಂಗು, everything is stated, my lord. And as of now, there are more than 25 houses are constructed, my lord. They are residing therein. It's a layout and 94 sites are formed, my lord. I have produced the layout plan also and along with the sites who are allotted.
Yes.
Yes. Lordship would kindly see annexure A. What my learned friend said that there are RCC ಮನೆಗಳಿದಾವೆ. Lordship would kindly mark the second serial number in that note. RCC ಮನೆ 50 by 60. That is one house. Lordship would kindly see this. This is the status of the land as on the date of the preliminary notification. Lord, the present petitioner, Lord, has filed this present writ petition, not challenging the award, but he himself has alienated all the properties. Not he has no locus standi, not the first instance to approach challenge the acquisition proceedings. Not if
Sale is before or after?
not sales are some of them are after, not some of them are before. Not even if those revenue site holders not want to claim any equity or not any allotment of a site by the Bangalore Development Authority, not it is not that not this particular land will have to be given to them. Not your lordships are aware not that even in Junjamma's case, not any revenue site holder, if we have acquired and he becomes eligible as per Junjamma, not they will be allotted sites in the very same layout or in a subsequent layout, only to see that not a person who has put in some amount of his efforts not will not be roofless. Not that cannot be. Not this particular property not has been reserved for vertical development. And Lord, we have considered that.
And as on the status of the land, this will not come in any of the guidelines. This is not a garden and nursery land. They cannot claim that my land is a garden and nursery land because they themselves admit that they have formed a sites and they have allotted it to somebody else. Totally built up. The Mahazar is clear. No educational and charitable institutions are there. Not under no circumstances, they would file with, come within the guidelines, the directions issued by the Honorable Division Bench. They conveniently don't produce that guidelines here. They skip that page. Only the revenue site holders,
Now, correct. Now, in consonance with the conclusion you have arrived at,
please,
the resolution,
yes,
take your stand
yes,
for whatever in the context of the representation. We'll consider.
Please. They themselves admit, may I make this submission. Lordship should kindly see.
No, correct. So finally we'll have to dispose it off, isn't it? So now you will have to make a classification, produce the satellite pictures.
Yes.
And then as on that date.
Yes.
And then whatever, is there any built revenue
Please,
site holders? How you are going to classify? You take your stand. If at all somebody is eligible, then as you say, it may not be in the same land. If they're eligible.
Not at their instance.
Correct.
Not at the petitioner.
No, that is there.
Yes. If anybody who claims, there are certain restrictions for those revenue site holders.
Correct.
Why it's why the landowner
have to fulfill the test.
They'll have to fulfill the test of that they don't have a site, and there are certain other guidelines, other ones are issued. But since any one of them, only those who fall within those will be entitled.
Correct.
But the person who has sold the property cannot come before this court and ask for stalling of the acquisition.
No, correct. Now what we could do is we could verify if there are any built-up structures.
Yes, as on the preliminary notification. Please.
And then we can pass an interim order on that. Meaning their claim may be considered in terms of the scheme if they are site holders.
Please.
So we'll have it next week. Just find it.
Please.
So we can dispose it off at that stage.
Yes.
How many people you can get your information from your local engineer and take a stand. We'll pass direction and dispose it.
Well, if I'm not wrong, it's sorry, I should not. This is not completely built up as what they are containing.
Correct.
One
So accordingly, we'll pass.
Yes, I'll place those records before you.
So when do you want it?
You may have it next week any day.
Relist the matter in the same stage on 23rd.
Please.
Yes.
Obliged.
This matter is under service tax measures and challenging unnecessary rectification order, which is at page number 40.
Page
number 40.
Yes.
The rectification order passed by the Additional Commissioner, especially the allegation is that short payment of service tax, and he extracted the table of how the short payment is happened. Please come to the para 2, the operation portion, table 3 in the paragraph 15.3 of the said order is proposed to be amended.
Para?
The para 2, the rectification order itself. Page number 40.
Yes.
Yeah. The allegation is that there is a short payment of tax and he extracted the table from the original order, which you only passed that original order. Then the rectification order dated is 11th January 2023. Please come to page number 60 minutes. Now this page number 60, this is the appellate, so which is the higher court. So the exact whatever the allegation made by the rectification, the original order, has been decided by the higher authority already. Please come to page number 64.
Page?
Page number 64, the same. And there in the findings and discussions, 7.1 para number, on verification of the documents like Form 26 says invoices, ledger, extracts, VAT returns. It is noticed that the applicant has paid the service tax based on that there is short payment of tax on someone and excess paid 20,000 and the amounts they mentioned for year respectively. Further, he records the documents have been revealed the same. Hence, on reconciliation, there is no short payment of tax. So this is the higher authority is recording, the appellate authority. So after disposing,
Now, this appeal is filed against the order in rectification.
order in original. But this when it is coming, my lords, please come to page number 60 again, order in appeal. The dated is 29/5/2023. That is much after the rectification order.
Page?
Yeah, page number 40, the rectification order, the dated is 11th January 2023. And the appellate order dated 29/5/2023. That is after rectification order, my appellate order is coming, which is higher authority deciding on the same matter. Then, in the eyes of the law, the rectification order passed by the original authority does not hold good this first contention, my lord. And also, please come to page number.
No, now correct.
No, page number 3, my lord. Just I will take 1 minute. Page number 43. I have brought to this to the appellate authority again. I have brought this to the appellate authority 28/7/2025. That is after I receive my bank freezing intimation. Now, when I wrote to the appellate authority, they clearly recorded. Please go to para 4. In view of the
Page
44. The appellate authority again reiterating that 40 and 44. This is a one page order they gave the appellate authority. So what I requested, the rectification is passed. Rectification order is passed. Further, it is stated that rectification OIO so and so was passed by the adjudicating authority prior to the instance of the aforementioned OIA. After issuance of OIA, so I mentioned from the records available in this office, it is noticed that this was not brought to the notice of then the commissioner of appeals either by the adjudicating authority or by the appellate during the appeal proceedings, nor any appeal was filed against the rectified OIO. Hence, in view of the above fact, I am directed by the commissioner of appeals Mysuru to inform that there is no mistake apparent on record while passing the above record order in appeal.
So let us see. Just now you'll have to take a.
My lord, I'll have to take a stand. If not, my lord, in view of the fact that the rectification order has been passed without giving hearing opportunity, and one more thing, the rectification is passed before the Commissioner Appeals has passed, my lord. Now the Commissioner Appeals have passed an order in the month of May, my lord. January rectification order has been passed.
Correct. Now,
rectification order may be set aside and remanded back to the officer.
No, correct. Now, once the rectification order is passed,
please, my lord. It should have been challenged before the Commissioner Appeals.
If it is a negative order,
please,
it merges with the order in original.
Original, yes, my lord.
Now that order, in effect, has been superseded by the appellate order.
Please, my lord.
Isn't it?
Please.
So the appellate order holds force as on date.
As on date.
And the order of rectification can be construed to have been superseded by the order in original, and you can look into it.
My lord, it can be construed, my lord, but the rectification order was never placed before the Commissioner Appeals to be at least be considered, my lord, on the factual aspects.
Okay, correct. But now now whatever grounds he has raised in the rectification has culminated in that adverse order.
Please, my lord.
Now, if he is giving up whatever if he seeks now not to press any grounds as raised in the
My lord, here the rectification is on the motion of the assing officer, not on the motion of the assessee.
So it has to be
assing officer himself has.
So it has to be reconsidered.
It has to be reconsidered, my lord, in view of the Commissioner Appeals, which has given a finding, this thing. So let it be remanded back to the officer by setting aside the rectification order to reconsider. Let opportunity be provided to the assessee. Let him produce the documents and the CIT appeals order and satisfy the assing officer that this short payment, whatever the amounts, has already been considered by the CIT appeals on merits.
Yes, legally speaking, technically speaking, once the higher authority decides the matter, the lower authority passed by the order, whatever, it will become null and void.
So you place some.
However,
No, if you want, we will remit it back. If you feel you have a good case on law, then you give some authority letters.
Okay. And also there is what learned.
We'll send it back.
You can send it back, and there is a and the fact that rectification of the past without any opportunity of being heard. And in light of that, and considering this aspect, to this specifically, my last can give the direction.
Yes.
Considering the appellate authority has decided, please consider that and pass the order that mention can be there.
Yes.
Please, section 70 for rectification of mistake and subsection 4 clearly emphasizes that the opportunity of personal hearing has to be used.
Now, the rectification was passed without hearing you. Please.
Yes, sir. It is not brought to my notice, and that is what it is required by the appellate authority also. Even for the appellate authority, they should have brought to the knowledge of the appellate authority before, because he is passing the rectification, and nor he has brought to my knowledge.
You are not aware of this?
I was not at all aware, and the bank account has been, they have sent to from three banks, the notice has come, only then I was.
The petitioner has called in question the validity of the order of rectification dated 11/1/23 passed by respondent number 2, raising a demand of service tax of 2,98,405 along with interest and penalty for the financial year 2014-17. Petitioner has also challenged the legality of the recovery notices issued at Annexure G. It is the case of the petitioner that the where is your list of dates?
The list of dates in
Page number 5, man.
page number 5.
5, man. In page 5.
The case of the petitioner that so-called notice was issued by the Joint Commissioner Central Tax alleging short payment of service tax based on the alleged difference between gross value on basis of income tax returns vis-a-vis declarations under the service tax return. Full stop. On 23/9/2022, it is stated that order in original came to be passed. Full stop. The petitioner, counsel for the petitioner submits that an appeal was filed against the order in original on 22/12/2022. And the appeal came to be disposed of by order dated 29/5/23. 29/5/23. It is submitted that in the interregnum, the revenue sought for a suo motu rectification, and the order in original came to be rectified by virtue of the order at Annexure
A.
By virtue of the order at Annexure A dated 11/1/2023. Full stop. This is the case next. Is the case of the petitioner that where the power of suo motu rectification is invoked, there could not be an enhancement of the liability of the petitioner without an opportunity of hearing in light of section 74 subclause 4. Full stop. It is submitted that the petitioner was not aware of the order of rectification that was passed without notice to the petitioner. It is next. It's however submitted that the order in original itself, which is the subject matter of the appeal proceedings, came to be set aside.
Came to be, I mean, that has been taken care in the order in appeal.
What happened in the appeal?
Appeal, whatever the short payment that we alleged, And that we have participated before the appellate
came
authority
to be modified by order of the appellate authority, wherein the appellate authority has considered the aspect of shortfall of payment of tax. Full stop. Next. It is submitted in light of the order in appeal having been passed subsequently. The order of rectification may have to be ignored. Next. Third counsel for the revenue submits that the order of rectification may require to be revisited as the aspect of rectification order passed was not brought to the notice of the appellate authority. Full stop. Next. In light of the facts as made out and noticing that the order in original came to be modified in law by virtue of the order in appeal by order dated 29/5/23, the order of rectification that is passed without opportunity to the petitioner would be an order passed in violation of the legal mandate of 74 subclause 4. Accordingly, the order of rectification at annexure A is set aside. Matters remitted to respondent number 2 to reconsider the proceedings, while the respondent number 2 is also to take note of the order in appeal at annexure H. Order in appeal at annexure H. The contention of the petitioner that the order in appeal results in merger of order in original, and accordingly the order of rectification may have to be reworked is an aspect to be looked into by respondent number 2.
consequential action of the bank attachment.
The consequential next. In light of the above, the action of attaching the petitioner's bank account subsequent to the demand raised consequent to the rectification order would be set aside, required to be rescinded by appropriate instructions from the department forthwith.
Let the
Now,
assessee appear on some date.
the petitioner to appear before respondent number 2 without further notice on. Yes.
What this issue involved in this case is refund of amount deposited during the investigation period. GST amount, which is
Fresh matter. State or central?
That's for respondents. For respondents 1 and 2, I'll accept notice. For respondent number 3, my lords, DGGA.
DGA accepts notice for 1 and 2. Then council G1 accepts notice for the third response. You have made some deposits.
During the investigation, the forcefully recovered some amount. This issue is already covered by the 2 judgments which are delivered.
Who has recovered? Who has recovered? Which respondent has recovered?
DGJ has recovered.
DGJ has recovered.
DGJ has recovered.
Then why should I grant refund?
Because jurisdiction officer is state.
I think this matter I have also dealt with.
Please, in one matter.
Yes, sir, chemicals and bundle technology.
Bundle technologies. Where Malaj, the officer sat in the premises of the associate and.
So department G1 claim, not department.
G1.
G1 claimed the self-ascertainment. Isn't it? Such argument take note, it was self-ascertainment.
Yes.
Huh?
Yes.
They would have made the payments through DRC3, which Malaj, the heading itself says it's voluntary payment.
Then you have to take your stand.
No, DRC 03 chala.
So you take your stand in writing.
Yes.
There are only 3 methods of payment in under GST. One is generally through GSTR 3B, that is monthly payment. If there is a confirmed order, then they create a liability in the liability register. Like second option. Third option is only DRC3. Whether you forcefully collect or voluntary pay, only mode is only DRC3. But they force the assessee to pay for DRC3. This amount was collected 5 o'clock in the morning, madam.
Let us see. You take a stand in writing.
Respondent 1 and 2, Malaj, merely said, Malaj, the proceedings are pending before respondent number 3. It is not finalized. Till it is not finalized, we are unable to sanction any refund.
Pleadings to be completed within 2 weeks. Relist the matter. Date. Here. Yes.
Your Lordship, this is a service tax matter. Your Lordship, may please come to page number 9.
No, take me to the order only.
Your Lordship, we have filed 3 refund application, pursuant to which so-called notice was issued, for which we have replied. However, it has been more than a decade. Till now, no refund order has been passed, either sanctioning or rejecting the refund.
They have not passed any order.
No, Your Lordship. Your Lordship, I will refer to a small compilation.
My lord, if I may, my lord, the directions, the petition may have become infectious because, my lord, according to my information, my lord,
they passed
the orders.
Just give a copy to them.
I'll give a copy. My lord, on 7/1/2026, that is.
Your Lordship, the writ petition was filed in 2025.
No, correct. Now, what has happened? You have sanctioned or rejected?
No, my lord, it has been rejected. Now, I believe, my lord, the writ petition, this writ petition becomes infectious. They may have to challenge this order in appeal.
So
The dispatch dated on 8/1, my lord.
No, that's okay. Now, we reserve liberty for you to challenge this. We'll keep it open. We'll notice that your assertion that you are communicated only now. The present petition has been filed.
Your Lordship, in the order,
Now
Your
that
Lordship may kindly refer to para 26.
correct. Now that's on merits. You take it.
Yes, Your Lordship, it has been written that there has been a delay on the part of the taxpayer for more than 5 years to file the refund application. But we have filed the refund application within the time limit. There has been no delay on the part of the petitioner to file the refund application.
No, but now if it's an appealable order, you'll have to file an appeal. We'll keep open.
But either they can file an appeal. If not, if they have, if what my learned friend is saying that they have to, let them file a writ petition saying that the factual findings, what has been recorded, is mistake. It's a order where they have to challenge it. Now the order has been passed.
The petitioner has sought for issuance of writ of
So, since the order is served upon us today, may today's date be.
I'll make an observation. The petitioner sought for issuance of writ of mandamus to direct respondent number 1 to adjudicate and sanction the petitioner's refund claim pertaining to the period October 2011 to March 2012, July 2012 to September 2012, and July 2014 to September 2014. During the proceedings, pendency of the present proceedings, the learned Council of the Revenue files along with memo copy of order in original and submits that the refund applications for the periods which is subject matter of the writ petition has been rejected by order in original dated 7/1/2026. Next, in light of the same, the further adjudication in the present petition would not arise, keeping open all contentions of the petitioners insofar as the impugned order in original dated 7/1/2026. The petitioner submits that the court take note of the submission that the order in original was not communicated to the petitioner and has come to the knowledge of the petitioner on this day when matter is when copy is served by learned counsel for the revenue, that is on 17th March 2026. Said aspect is taken note of. Accordingly, the petition is disposed of. Liberty is reserved to challenge by way of appropriate proceedings the order in question is dated 7/1/2026. Aspect regarding limitation to be taken note of while taking note of the observations of the court made above. Accordingly, petition is disclosed. All contentions are kept open. Yes.
My Lordship, GST that fine amount has been paid. They also confirmed it. So that
Has been confirmed. They made payment as per DRC 03. Penalty and interest component has been paid. Department has confirmed that they've received that.
What is the writ petition filed?
For cancellation of
for
registration being cancelled, my lord, they challenge the registration being cancelled.
So the
so now we
payment
can
is
revive
paid
it.
and they can revise.
They made all the payments, my lords. On the last date, they had not made certain payments. My lords had directed me to verify if all payments have been made or not. There were certain shortfalls. They made those also.
So it can be set aside.
Set aside.
The petitioner filed the present petition seeking for setting aside of the order of cancellation of GST registration as passed at Annexure A. What is the ground for cancellation?
Sir, ground
Sir,
for cancel.
What is the ground of for cancellation?
They have not, means payment was not made for some time, my lordship. So they have cancelled it and they have not informed the cancellation. We were doing a business and further when we approached it, they asked us to pay the money and come. By the time it was cancelled and it was not restored. The same business I am having till date, my lordship.
The show cause notice at Annexure D would indicate that the ground made out for cancellation of registration was failure to furnish return for continuous period of 6 months. Learned counsel for the petitioner submits that now you have filed the return, is it?
Returns has been filed, my lord. Returns not filed, my lord. Interest and other payments have been filed. They have to unlock it to file the returns. So since they have cancelled it, I'm not able to file it.
Learned counsel for the petitioner submits that all tax dues, interest and penalty for the years, for the period during which return was not filed has been paid.
Has been paid.
Said fact has been affirmed by the counsel for the revenue. Full stop. In light of the same, it would be appropriate to set aside the order at Annexure A with a direction to the petitioner to regularize the lapse by filing of returns for the period for which returns were not earlier filed. All other contention. Full stop. That's all, isn't it?
That's it, my lords. In fact, their only claim was that they've already made payments. We just had to verify whether those payments were made or not, my lords.
Next, accordingly, taking note that petitioner has quantified his liability and paid the amount, and what would remain is only filing of returns for the period of default. Petition is disposed of. The order of cancellation of registration at Annexure A is set aside. Registration is directed to be revived, and petitioner to file returns for the period of default. Accordingly, petition is disposed of.
That's all.
This is in Chinmaya Trust issue.
Yes.
For the period 15
16 and 16, 17.
Yes, Arvind.
My lord, it can be sent back.
The petitioner, Chinmaya Trust. Petitioner. So what
Also
is your
Exparte.
claim now?
We are-
Exempt or you're not liable to pay or what?
Not just certain periods out of the 15, 16, 16, 17. Even if you take the extended period of time, it is barred by limitation.
Barred by limitation.
And second thing is, during the COVID period, they have issued the notice. Let it go back and then let them verify. If they have to pay, let them pay.
Addition to that, it's Exparte, my lord. They have not appeared.
The petitioner has sought for setting aside the order in original dated 13/1/2023 at annexure A. The case of the petitioner that the order in original has resulted in a liability for payment of service tax solely based on data received from the income tax department. Submitted that the coordinate bench in WP 1154 of 2023 and other connected matters wherein service tax liability was sought to be imposed on the basis of inputs from the income tax department had set aside the orders and remitted the matter back for reconsideration before the competent authority. Further submitted that petitioner was unable to take his stand insofar as the show cause notice is concerned, and if an opportunity is given, petitioner would demonstrate that the claim by the department is time barred. Full stop. Repeat para 9, 10. Nine and 10. Next. Taking note of the above observations, the order in original at annexure
A
is set aside. Matter is remitted to the stage of reply to show cause notice. Authority to take note of observations made in the order dated 3/7/2024, passed in WP 1154 of 2023 and connected petitions as extracted supra, and in specific to take note of the observations at para 10 of the order as may be applicable. All other contentions are kept open. Next. Petitioners at liberty to make out fresh reply to the show cause notice. Next, petitioner to appear before the respondent number
Only one respondent. Commissioner.
sole respondent on without waiting for any further notice. Accordingly, petition is disposed of.
Serial number 60 also same issue, my lord.
Serial number
60, same issue. Covered by the same judgment.
Just wait. In the fresh matters, I take it.
My lord, serial number 25 also same issue, my lord.
60/25 mark. Just
Serial
wait. I'll
number
take
20.
it. We'll see. I'll take it up.
16/4 is the date, my lord.
Huh?
Your lordship fixed 16/4.
My lord, serial number 25 also same issue, my lord.
Just wait. Yes.
Filed the affidavit, my lord. This is the same vehicle release matter, my lord. Filed the affidavit. Lordship had directed me to file the affidavit, my lord. Filed the affidavit.
You can't start. I filed an affidavit. I don't know what you're talking.
I'm sorry, sir.
You must start with your case.
This is the matter
For
of
me, for you, it's one case.
And this is the case of the vehicle and goods release, my lord. On the last occasion, I had argued that this is a case where 108 has been invoked, despite the appellate authority holding that 130 is not applicable and 129 is applicable, and I made the payment of the penalty. Lordship had directed me to file an affidavit, my lord. So I filed the affidavit. May I read, my lords?
Yes. Yes, M. Kumar.
Please.
Para 4, my lords.
Got us. They have now paid 200% of the taxes as redetermined by the first appellate authority. Malaj only wanted to, with regard to the remaining amount, what sort of security has to be furnished was to be decided by this honorable court. Malaj may kindly see the note that I have given now. I'll skip serial number 1, Malaj. Serial number 2, Malaj, only to show the bona fides of the petitioner. Malaj, on 31/1/2020, Malaj, they have made payment of 10 lakhs before the advisory audit 2 upon an inspection being made. Again, Malaj, on 25/9, they have made a further payment of 20,09,000 under section 122 for the difference in stock and non-accounted outward supply. And Malaj, the serial number 3, paid towards liability admitted taxes basis on discrepancies recorded in statement dated 10/12/2020 deposited before DGGI Mangalore, which amounts to around 50 lakhs. And Malaj, subsequent penalties that is levied, which is in sum of 79 lakhs, 47 lakhs, then 4 lakhs and 4 lakhs 6,000. Only to show, Malaj, they are in the habit of evading taxes, not disclosing the proper turnovers. So, Malaj, I would only impress upon this court, Malaj, to direct them to furnish a bank guarantee for the remaining amount. And vehicle may be released. And the proceedings before the additional commissioner may be permitted to be continued, Malaj. In fact, the very same driver, Malaj, has paid penalty on 5 occasions. That I thought I will not bring it to the notice of this court because it is on the individual driver that the penalty has been levied.
What is the value of the goods?
16 lakhs.
16 lakhs. Conveyance?
Conveyance is not valued, my lords. Conveyance is recorded. So,
that's total in WP number 4273. The total penalty, that is fine and penalty that is levied, Malaj, is 25,46,644.
in 4225, my lords could find these details at page 58. That the goods value is 16 lakhs, and the conveyance is Ashok Leyland goods carrier. The conveyance is not valued, my lords.
So about 25 lakhs.
Yes, my lords. My lords, all that this note that my learned friend has submitted would show that I have been making payments whenever demanded.
Yes, whenever there has been an inspection,
I'm not evading
by the DGGI or inspecting authorities, Malaj, these payments have been made, not voluntary payments.
I'll make myself.
Please.
Whenever the demand has a reason, my lords, either I have contested that or I have made the payments. And as things stand, as I have stated in my submission, my lord, there is no appeal pending against, in my case, there is no pending adjudication. Everything stands concluded. When that is the case, I am making a submission before this court also that as far as these two conveyances are concerned, I have already made the payment of penalty. And if there is any further demand that may arise in the future, I am willing to make the payment, and I have stated that by way of an affidavit. When that is the case, my lords, my goods and conveyance may no longer be held under seizure, my lords. Because all that my learned friend has helped me in this by way of this note is to bring to the attention of this court that I have always made the payments. I have not evaded any payments.
Petition. Yes. Sought for setting aside of the order at annexure K.
CH-7 is only an interim order of stay passed by the revisional authority, staying the operation of the order passed by the first appellate authority.
Yes, sir. Annexure.
Page?
Page 114, my lord. My lords have taken 4225, my lords.
4273.
4273, page 116, my lords.
My lords, kindly take 4225. My lords would find the impugned order, stay order at annexure K, page 114.
The order at annexure key is the order staying the order of the appellate authority.
Order of the revisional authority. Revisional authority.
This is an order staying the operation of the appellate authority.
Staying the order of the appellate authority dated 28/1/2026. It is noticed that the order passed under section 130 came to be challenged before the first appellate authority, and the appellate authority had allowed the appeal in part in favor of the petitioner herein. Such order of the appellate authority was subject matter of revisional proceedings under section 108, and the order of the appellate authority came to be stayed as per the order at annexure K. Learned counsel for the petitioner submits that in terms of the order of the first appellate authority, the order passed under section 130 came to be set aside.
No, it came to be stayed. Came to be set aside.
Came to be set aside.
It came to be modified, Manoj. 130 order was set aside. Penalty was levied under 129(1)(a).
Came to be set aside, and the first appellate authority had modified the order in original by upholding the penalty, upholding the order passed under 129(1)(a). Full stop. Full stop. Next. It submitted that in so far as the order of the first appellate authority levying 200% of tax as penalty, petitioner has satisfied the same. Full stop. Next. It is further submitted that in so far as the revisional order, in so far as the order in revision, appropriate proceedings have been taken.
In so far as the order in original is concerned,
Revision.
We have only
hearing notice is no issue.
Correct.
It has come to be stayed by this court.
In which?
My lords,
Some other writ.
No, after issuance of the stay order, the hearing notice was issued, and lordship had directed on the earlier occasion that such proceedings shall remain kept in abeyance.
No, correct. So that revisional proceedings you have challenged by way of a separate writ, is it?
No, this writ, my lords.
This one only.
This, my lords.
Indian Procedural. Taken by challenging the same in the present writ petition, that is WP 4225 of 2026. The counsel for the petitioner would submit that the conveyance may be released. Goods and conveyances may be released, taking note that the liability imposed by virtue of the first appellate order of 200% of tax as penalty has been satisfied. And AGA Shri M. Kumar submits that on previous occasions as well, the petitioner had suffered certain demands that were raised by the department after having noticed certain lapses and discrepancies, and petitioner needs to be put on terms to ensure that in the event the revisional proceedings culminate in an order in favor of the revenue, and the order under 130 is revived, the revenue is required to have certain assets or security in order to recover and enforce the order to be passed. Next. However, taking note that the very revision proceedings is still to be concluded. And in terms of the order of the first appellate authority, petitioner has satisfied the same. It would be appropriate to dispose of. No, now what happens now? Just one.
Well, we have now issued a sumo motu revisional notice. They'll have to file the reply and participate in the proceedings. Then, my lords, it is left to the revision authority to take a decision whether the order passed by the first appellate authority has to be revised or the revision proceedings have to be dropped. It is for the revision authority to decide, my lords, because it is still at the stage of show cause notice. Whatever grounds, my lords, with regard to jurisdiction or limitation or whatever is available can be filed by way of a reply to the show cause notice.
Now, insofar as this conveyance now will pass some order.
Their main grievance is that
revision, all your contentions, including what you have raised here, will keep it open to be raised before the revisional authority, including jurisdiction.
My lords may kindly treat this as an interim order and keep the petition pending to hear them immediately on the main matter itself. They don't have jurisdiction itself to continue holding the
that can also be argued, my lords, by way of filing a reply to the show cause notice.
We'll ask the revision authority to take your jurisdictional aspect as well.
Please, then I'll be liberty may be reserved to me to come back.
Yes.
That is always available. That liberty.
Yes. It would be appropriate to put the petitioner on terms regarding his request for release of goods and conveyance. Next. In light of petitioner having satisfied the demand in terms of the first appellate authority, the revenue is directed to release goods and conveyances. The petitioner is to furnish an indemnity bond to make good any liability to the department in the event the revisional proceedings culminate in an order in favor of the revenue and the order under section 130 stands revived. Affidavit filed by the petitioner is taken on record. The undertaking by the petitioner in the affidavit is also noted. It is made clear that the petitioner is required to abide by the final directions that may be issued in the revisional proceedings, and any breach of undertaking could be construed to be an act of contempt. Accordingly, next. Insofar as a challenge made to the revisional order, all contentions of the petitioner are kept open to be raised before the revisional authority. Next. In terms of the above, petition is disposed of, all contentions are kept open. Now, what is the other one? Other writ petition?
Same, my lords. Only vehicle change. Same goods, everything is same, my lords. Only different vehicle.
Vehicle number changes, that's all.
So it could be a common order.
Common order.
Okay. Let them appear before the revision authority on a particular day in the month of April.
Correct.
And
now,
submit the reply.
Now the other one, separate order, separate proceedings are a part of the same.
Separate proceedings.
Separate proceeding. Next. One paragraph and
ಎರಡು separate vehicles, separate orders.
Insofar as WP 4273 of 2026, it is noticed that the petitioner had challenged. Now this annexure K in this writ petition 4273 is a different revision or number.
Different revision number.
Correct. In WP 4273 of 2026, petitioner had sought for stay of the order dated 30th 1/2026 passed by the revisional authority under section 108 of the Act. The revisional authority, by virtue of the order at annexure K, page
116, my lord,
had
stayed the order of the Appellate Authority dated 28/1/2026. Full stop. The first Appellate Authority had allowed the appeal filed by the petitioner. Page appeal order.
Appeal order, my lord, see that page number 86, my lords. 86.
Had allowed the appeal of the petitioner filed challenging
Appeals have been
invocation
partly
of-
allowed.
partly
Partly.
had allowed partly appeal of the petitioner challenging the invocation of section 130. In terms of the said order of the appellate authority, the order in original came to be modified by setting aside the order under 130 and upholding the order passed under 129 1A by levying.
I'm sorry. Setting aside the order penalty levied under section 130 and modifying that to a penalty under section 129 1A.
Setting aside the order passed under 130 and modifying modifying the order to a penalty under 129 1A.
1A.
By levy of penalty of 200% of the tax. Next, petitioner has paid the has satisfied liability that has flown in terms of the order of the first appellate authority. Next, taking note that the petitioner had succeeded in the first appeal proceedings and has satisfied liability, and taking note of the affidavit. It's a separate.
Common affidavit.
Taking note of the affidavit filed in WP, affidavit filed referred to in the order passed above, it would be appropriate to dispose of the present writ petition while directing release of goods and conveyance. The petitioner to file an indemnity bond, the revenue to release the goods and conveyance. It's made clear that the undertaking made in the affidavit would be binding on the petitioner, and any breach of the undertaking contained in the affidavit would be construed to be an act of contempt. All contentions are kept open. All contentions raised regarding the revisional proceedings are kept open to be raised before the authority. Next, in both the petitioner relating to proceedings of revision pending in both the above writ petitions referred to above is to appear before the respondent number
1.
Respondent number
1, my lord.
1 without further notice on. All contentions are kept open.
16th of April. 16th. 15th April.
This is Srihari's strategy, litigation strategy, to get the release of the conveyance and then go back to the revisional authority.
I was actually happy to have it.
No, let's see. Yes.
Total 3-acre 10 gundas land, PD respondent acquired. So 3-acre compensation has been this one. So my representation was given on 26/11/2025.
They have not paid compensation.
ಇಲ್ಲ sir. So now objection file ಮಾಡ್ತೀವಿ, preliminary notification ಗೆ objection file ಮಾಡ್ತೀವಿ. So intimation letter issue ಮಾಡ್ತಾರೆ sir. Respondent.
Learned counsel. Just wait. Learned counsel, BDA. Ajay Kumar M is directed to accept notice for the respondent. List the matter in the preliminary hearing list on. Yes.
Service tax order covered by this honorable decision in Chennai 21/23.
Just one aspect I would like to highlight in my lord. At page number 10 of the petition, I've just enclosed the table. The demand confirmed in the show cause notice, my lord, proposed in the show cause notice is 51,22,555. My lord has it page 10. The order confirms, my lord, so 139,91,370. But otherwise, maybe remanded back, my lord, but this kind of addition.
Yes.
Lordship may have it next Tuesday, my lord.
Lord Counsel
I'll
Arvind
just
Chavan accepts notice for the respondent. This is the matter in the same stage on
Tuesday 24th, my lord.
24th. Yes.
My lord, stay in the meeting and stay in the time.
No, next date we'll dispose it of.
Please, my lord.
So far as the purpose is concerned, basis assessment.
Income tax.
That's it. Probably it falls under DCAT 2 or 6.
Yes.
So far as the issue is concerned, basis assessment. They applied the questionnaire. I replied to them. Subsequently, the ITC order was passed on two aspects. One is on the business loss aspect, and the other one is unsecured loan aspect. I went in appeal, and in the appeal, the unsecured loan issues has been remanded back to everything officers now. And insofar as the business loss is concerned, that was not been considered as per
Insofar as
business loss is concerned. Lord, your Lordship can turn to page number 44, para 6.3. Relevant portion is 6.7, where the appeals, Commissioner Appeals decides that there are no questions, there are no materials placed.
page?
Page 45, 44 and 45. It starts from 6.3. And the non-consideration and the conclusive para, your Lordship can find it at 6.7, page 45. My submission is this, my lords, as per annexure C. Lordships would get at the 6.7 last three lines. Consequently, disallowance of loss made by the learned AO is confirmed. Hence, the ground number 2 of the appeal and its subgrounds are dismissed. This is with respect to business loss.
But finally, all these in your appeal, you have to take it up. Why should we intervene in?
My lord, your lordship can turn to page number 55 annexure C. My lord, there was the on 4/2/2026.
Page? Page?
Page 55. 53, my lord, for a moment. I was being asked to supply the material documents, my lord. I have submitted all relevant documents along with the written argument. But at the same time, my lord, insofar as the other components are concerned, I apprehend that there could be some transactional gap, and I requested for an adjournment and a personal hearing, my lord, as could be seen from annexure C, page 55. Lordship would get at remarks portion. Had it been the personal hearing would have been given.
So this request was made on
4/2/2026.
no, the request for adjournment
Please, my lord.
at annexure C
Please, my lord.
was made on
4/2/2026. The order was passed on 10/2/2026.
order at annexure.
Annexure A.
You wanted time insofar as to demonstrate regarding additions.
Please, my lord.
Yes.
Your Lordship, this is appeal. First appellate authorities order, no, it is appealable before the tribunal.
No, he's saying let it be sent to the same stage.
For giving personal hearing.
But may I submit, my lord? I have also.
Please. Paragraph number 6.7 is the conclusion, page number 45. Taking into the account the totality of the facts and surrounding circumstances, I am of the considered opinion that the appellant failed to establish the existence of binding forward or committed contracts. The explanation provided is not supported by any contemporaneous evidence or commercial justification. The loss appears to be solely tax motivated and devoid of any commercial substance, despite the fact that the recorded transactions caused it. Consequently, disallowance of loss made by learned Evo is confirmed. Hence, the question.
So now it will go back to the stage of the appeal.
Only for granting personal hearing, my lord. As per the submission made by the council, my lord, the personal hearing was sought for on 4th and it was not granted, and 10th order has been passed. Only to that extent, my lord.
But may I submit?
So we'll send it back. Now you raise.
Not my conclusion, my lord. Anyhow, the assessing officer has to consider the other unsecured loans. My lord. Let both the issues be transferred to assessing officer. That is my alternate prayer as page 12.
Now the order in original you take us to.
My lord, order in original. The 11th question is, my lord,
Assessment order.
assessment order. Assessment order.
It is not placed.
Then now, at the most now we can send you to the first appellate authority.
To that extent, my lord, let them appear and argue the matter person.
The petition is sought for
Read petition number.
setting aside of the order dated 10/2/2026 passed by the appellate authority at annexure A to the extent of disallowance of business loss only to that extent you are seeking.
Please, my lord.
So the order in the assessment order is in your favor in so far as one point. Or
One point, unsecured loans are concerned.
the appellate authority, you challenged only the business loss part.
Business loss part.
Huh?
Please, my lord. No, business, my lord, before the appellate authority, the commissioner of appeals, my lord, both the entire order was questioned. The commissioner appeals accepts my explanation with respect to unsecured loans, and he rejects explanation with respect to business loss.
Now just show that unsecured loans what he has mentioned.
My lord, at page 44, I mean 46.
Yes, read.
I have carefully considered the assessment order. The appellant's submission that the material on record, according to the submission of the appellant, the unsecured loans are added with learned above, include the following: loans brought forward from previous years, loans repaid within 1 year, the other loans for the year in question. It is settled that opening balances of the loans carried forward from the previous years cannot be considered as cash credits for the year under the appeal unless they were received in the relevant previous year. The learned AO did not bring any material on record to show that these loans were obtained during the year in question. However, the appellant also failed to mention that some of the loans are brought forward from the previous years to the learned AO during the assessment proceeding. Therefore, the addition in respect of the old loans is not sustainable, subject to the verification of the appellant's claim. Similarly, loans obtained through banking channels and the appellant's claim. Subsequently repaid via bank transfers cannot be considered unexplained cash credits without bringing adverse material on record. In this case, too, the fact that certain loans were repaid in the subsequent assessment years was not brought to the knowledge of the AO during the assessment proceedings by the appellant. It should be noted that with regard to the remaining loans, the learned AO did not make independent verification of the genuineness of the loan transaction and the credit worthiness of the loan creditors, even though the appellant had provided PAN and other identity information. To ascertain whether section 68 is applicable, though verification is required. In this in the case of remaining loans, the AO.
No, just 1 minute. Now, it has been remanded to the AO.
Yes, my lord.
So far as unsecured loans.
Yes, my lord.
is
It has been
remanded.
remanded.
So what we could perhaps say that now he contends that the finding regarding business loss is not sufficient by the appellate authority. But in light of it being remanded,
Yes, ma'am.
we'll say
This
let
issue may also be considered.
So the issue regarding business addition.
Business loss of rupees 8 crore 30 lakhs 59,246. Page number 42, para 6, second line. Page number 42, second line, my lord. Business loss.
Just read that para 6.
Para 6, the appellant's next appeal grounds and sub-grounds revolve around the denying the business loss of rupees 8 crore 30 lakhs 59,246. The appellant's submission, the factors that led to the disallowance are already described in this order and won't be repeated for the sake of brevity. The fundamental facts of the case are that the appellant was a sleeping partner in Rajesh Jewels, a billion trading firm during the relevant assessment year, while also serving as chairman of Rajesh Exports. During the assessment proceedings, the appellant also stated that he did not engage in any independent business activities. He claimed to have invested in stocks, bullion, and gold. The appellant also stated this. If conclusion it at para 6.7, Lord. It has been confirmed. And next ground relating to another addition of rupees 54 addition of rupees 54 crores 88 lakhs, my lord, in respect of section 68, it has been remanded.
Now what? Why this? Why you want the? On what ground you are assailing the finding of the appellate authority in case of business loss?
Because, my lord, it's a forward contract.
No, no. Why are you saying that the finding of the appellate authority is erroneous?
Lord, so far as had it been the opportunities would have been given, my lord, I would have shown from the documents whatever I have submitted, annexure B, my lord. I'm sorry, my lord, annexure C. That these are some of the documents that I have produced before the Commissioner Appeals. The list of documents are
Where?
Lord, serial number, the bottom page. Lord, there are 10 documents produced, my lords. And I would have produced more documents also.
That is that hash, each one of one document.
Please, my lord.
Your lordship, para 6, last 4 lines, my lord.
Yes.
The page number 42.
Yes.
Your lordship, after that, my lord, during the assessment present, the appellant provided purchase invoices and sales vouchers to prove the transaction. However, as noted by the learned AO, the appellant did not produce any bank statement or documents other than the purchase and sales bills. According to the learned AO, gold prices could not have dropped so dramatically in 1 year. 1 day under normal market conditions. The learned AO also stated that the assessee's claim for the loss is unfounded and absurd. Thus, the loss was not allowed by the AO. If they produce additional documents, let him examine.
The in last. Next. It is to be noticed that the assessment order came to be challenged by way of appeal on various grounds, and the appeal came to be allowed in part while upholding contentions of the petitioner relating to unsecured loans and remitting the matter back to the assessing officer along with certain observations. Next, petitioner, however, is aggrieved by that portion of the order relating to rejection of his contentions as regards business loss. The reference to such aspect is found in para 6 of the order in appeal. Next. the counsel for the petitioner submits that during the appeal proceedings, the petitioner requested for an adjournment on 4/2/2026, stating that he had, though he had filed written submissions, he was requesting for a personal hearing. Though such request was made on 4th of February 2026, the order in appeal itself is passed on 10th of February 2026 without affording such opportunity of personal hearing is the grievance by the petitioner. Next, learned counsel for the petitioner draws attention to observation made at para 6 of the order and submits that if the opportunity of personal hearing is granted, the petitioner would take note of the observations made at para 6 of the order in appeal and produce purchase invoices, sale vouchers, bank statements, and other documents in order to demonstrate his case of business loss. Noticing that the request for personal hearing was overlooked and an order itself has been passed on 10th of February 2026, it would be appropriate to set aside the order in appeal insofar as rejection of the petitioner's appeal as regards the ground of business loss and remit the matter to be taken up insofar as the aspect of business loss and reconsider the same, while upholding the order in appeal as regards the ground raised, considered, and adjudicated relating to unsecured loans. Accordingly, the order in appeal at Annexure A is set aside insofar as rejection of the petitioner's appeal as regards the ground of business loss and matters remitted to the AO for reconsideration. Such order is passed, also keeping in mind that the order insofar as unsecured loans is in favor of the SSE and there is already an order of remand to the assessing officer regarding such ground. Accordingly, the order at Annexure A is set aside.
Is modified.
Is modified. Insofar as the rejection of the ground relating to business loss and is remitted back to the AO while affirming directions of the appellate authority insofar as remission
Modified.
on the basis of adjudication on other grounds. Accordingly, petition is disposed of. Needless to state, upon remand, petitioner is at liberty to take benefit of all opportunity to place his case before the assessing officer. Learned counsel. Just 1 minute.
I will take notice for the respondent. My name may be shown.
Learned counsel Sanmati accepts notice for the respondents. Please. Yes.
The case, my lord, PD has allotted the land in the favor of Shah, my lord, in the year 2013, my lord. Page 16.
Now, what is your representation?
My representation is, my lord, in the year 2013, I purchased the property from my vendor, my lord, Girish. Thereafter, my lord, in the year 2019, the very same property, the BD has sold in favor of one Sheshamma.
Now I got to know that when I went to the bank to apply for a mortgage loan, my lord, there was a transaction EC, in the EC, the name of the station was reflecting, my lord.
Your vendor is the allotee.
My vendor's vendor, my lord, is the allotee. Original, please, my lord.
Okay, take out notice.
Please.
Learned counsel, BDA. Venkatesh C is directed to accept notice for respondent 1 and 2. Emergent notice to third respondent. Yes.
Much obliged.
But I am before your lordship, not against an order passed by the assessing officer, the respondent officer, by rejecting the reply, my lord, on a cryptic basis, saying the Supreme Court order is contrary to audit report. So therefore, I cannot rely upon Supreme Court order. But lordship, please kindly see.
First time.
81, page number 81. That the issue involved in this case is, after the completion of the construction, advances have been received and registration has been done in respect of a sale of a villa. Now, according to petitioner, there is no liability to pay GST on the said amount. Now, there is an audit report saying that completion certificate is dated on a subsequent date. So advances were received earlier. So therefore, you should have levied, you should have paid GST. Now, I filed detailed replies saying when the building construction was completed, when the architect's report was filed, when an application for issue of occupancy certificate was filed, and when an occupancy certificate was received. I also relied upon before the officer saying that in my case, completion certificate is not required in the law under the municipal corporation bylaws. So therefore, Lord, there is no liability under the act. Without looking into any of these aspects, he simply says the judgments relied upon are contrary to the audit report. So I can't rely upon because completion certificate is dated so on.
Yes.
I'll take notice, my lord.
Counsel.
Seek instructions.
Arvind Chavan accepts notice for the respondent. We list the matter in the same stage on
Next week, my lord, 24th. I'll try to take.
Yes.
Till interim order, not till then let them not. March.
I will
Then
not
let
precipitate.
them not.
Let there be oral direction, not to precipitate.
Yes.
The respondent BDA in this case, my lord, just been served a copy of the petition yesterday evening.
My lords, this is again pertaining to 49/5, my lords. There is a, my lords, the 10 guntas with regard to 10 guntas of land, my lords. This is 8819 of 26, my lords. Writ petition 8819 of 2026. My lords, there was, according to us, my lords, our name is not mentioned in PN and FN, no position taken, no compensation awarded. And OS we had filed at an undisputed point of time in 2009 against the BDA, and it has been decreed. And there is yet another writ petition filed, scheme lapse and Tahedi. That petition is pending, which your lordship will get it at annexure. It is at page 166, my lords. There was an interim order of stay in that. We had sought for a prayer to declare that the scheme has lapsed, and now that writ petition is pending. There was an interim order granted, my lords, in that case. Page 166, your lordship may take.
Same survey number.
Same. Alla, nave hakirodu. The same survey number. And OS is also decreed, which I have produced, my lords, which is at page 149, annexure M, my lords.
No, now you. No, what is the difference between this writ petition and that?
This, no, once, my lords, now they have issued annexure A, which your lordship will get it, my lords. Kindly see, my lords, annexure A at page 54, my lords. Decree ಇದೆ ಇಲ್ಲಿ ನಾವು ಲ್ಯಾಪ್ಸ್ ಸ್ಕೀಮ್ ಲ್ಯಾಪ್ಸ್ ಅಂತ ಕೇಳಿ ಇಂತಕ್ಕೆ ಅಲ್ಲಿ ಹಾಕೊಂಡಿದೀವಿ ಅದರ ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ ನೀವು ಅನಧಿಕೃತ ಒತ್ತುವರಿದಾರರು ಅಂತ ನಮ್ಮ ಹತ್ರ ಬಂದು ನಮ್ಮ ಜಾಗನೇ ಇವಾಗ ಮತ್ತೆ ಇದ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
Which is that other writ petition?
That is 166, my lords. Page 166. 59286, my lords. Interim order is in page 167. OS decree is in page 149.
Let us see, there's already another writ petition pending, same petitioner.
Yes, my lords.
So we'll direct maintenance of status quo, complete your pleadings. Now this notice, you'll have to hold it back. We'll club it along with the other writ petition. The petitioner submits that notice that annexure is issued with respect to property in survey number 49, though petitioner has filed WP 42986 of 2018 seeking lapse, and an order of status quo is already in operation. In light of this, respondent BDA is not to take any precipitated steps to annexure 8 till the next date.
My lords, can we have the status quo verified? It is only until next date of hearing.
Should have been extended.
I'm given to understand, my lords. I'll cross check and inform. Even otherwise, my lords.
It may be taken up on Monday, my lords. I'll also have it
But
verified.
let them not precipitate, my lords. They're coming. I'm given to understand, my lords. It is.
No, you can always move the matter. I'll reserve liberty for you.
Yes, my lords.
We are only saying don't take precipitated step pursuant to annexure A. You complete your pleadings, sir. We'll club it with that matter and we'll hear the matter.
Obliged.
Last. Pursuant to annexure A till the next date, relist along with WP number
52986.
52986
of 2018.
18 minutes.
52986 of 2018. Land Council so and so accepts notice for the respondent number 227. AG accepts notice for the first respondent.
Now, status quo until next date of hearing, a date may be fixed.
Yes, yes.
I'll finish my pleadings by then.
Relist on 6th of April.
6th of April. Achha. You want to move the other matter also? Excuse me. The other matter, 73. Make a mention.
Yes.
Serial number 73 is also same survey number, my lords, 49/5. In fact, day before yesterday it was there and your lordship had directed. Serial number 73, my lords.
Just 1 minute. I'll just take it up. After the fresh matters, I'll take it up.
Please, my lords.
Yes. Next.
Serial number 16, my lords, is a case of, our contention here is that it's a case of a faceless versus JAO. The respondent was issued the 148 notices from Uttar Pradesh. Whereas my jurisdiction lies in Mysuru. My jurisdiction lies in Mysuru because I shifted to Mysuru in 2016. And portal stood updated, information was available with the department that I am from Mysuru, I stay in Mysuru, my activities are in Mysuru. The income that arises for this relevant assessment is also from activities that happened in Mysuru. Therefore, the Mysuru officer has a jurisdiction. Despite that, the old assessing officer, before him, the jurisdiction lied on account of me taking PAN at that point of time under him. He has issued 148 and he issued 148 AD order on my Mysuru address. Despite, so therefore he knew. Therefore, my challenge is also to the 148 in this petition, my lord, on account of jurisdiction in him having not having adequate jurisdiction.
Your Lordship, the impugned orders are passed by the ITO Uttar Pradesh, my lord. Your Lordship, I am raising objection regarding the territorial jurisdiction, my lord. Your Lordship, as per the Supreme Court judgment in case of Balak Capital, my lord, the
Case of?
Balak Capital, my lord. Your Lordship, where the assessing authority, my lord, they have to upload the competent court in that state, my lord. Your Lordship, paragraph number 3, my lord. In this case, the Honorable Supreme Court has followed its earlier order in case of Principal CIT versus ABC Papers Limited,
Just read.
2000.
Just read.
Your Lordship, paragraph number 3, my lord, that extracted portion of the earlier judgment. In conclusion, we hold that appeals against every decision of ITT shall lie only before the High Court, within whose jurisdiction the assessing officer who passed the assessment order is situated. Even if the case of the assessee or cases of an assessee are transferred in exercise of power under section 127 of the Act, the High Court within whose jurisdiction the assessing officer has passed the order shall continue to exercise the jurisdiction of appeal. This principle is applicable even if the transfer is under section 127 of the same assessment years. Your Lordship, their contention is that they are in Mysore. Your Lordship, they have not sought for the transfer of case from Uttar Pradesh to Mysore, my lord.
No, but now, if this is the legal position, even if it's one without jurisdiction, you have to go before that High Court and then challenge.
No, I don't have any jurisdiction, any business in Uttar Pradesh.
Correct, but this is the observation.
Minutes, I have produced in my submission in the petition minutes, annexure Q minutes, page 161.
So correct, but then you examine these both judgments and you come back.
Please, minutes. Tomorrow minutes.
This appears to indicate wherever jurisdiction is of that High Court, where the order is passed by an officer within the territorial jurisdiction of that.
There are various judgments to this effect. I'll produce it before the court.
All other various judgments are not relating to income tax cases, my lord. All are in general, but this is related to income tax case only, my lord.
I have produced income tax judgments in the petition itself. I'll take this court through it tomorrow.
Realist, special bench. Next week. Realist the matter, same stage on 20. Yes, next.
Okay.
It is for the assessment years.
Yes.
The writ petition is for the assessment year 18-19. The challenges to the proceedings initiated pursuant to remand by the tribunal as being barred by limitation.
Yes,
my lords,
income tax.
PCIT 1 is the. My lords, just notice a couple of dates.
Yes.
My lords, the tribunal's order is dated 21st June 2023. My lords will get this at page number 257. June 2023. My lords, this order was received by the revenue on 24th July 2023. My lords will get that at page 312. My lords, at the top of page 312, the Honorable ITAT order. Does my lords have it?
Yes.
The Honorable ITAT order was received in the office of the PCIT on 24th July 2023. Now, my lords, in terms of my lords, just one point before that, my lords may just notice the ITAT order at page 257. My lords, on the flip page at 258, what happened, my lords, was my issue, the entire contention before the tribunal was the transfer pricing officer has gone beyond the scope of the show cause notice, and therefore the order is invalid. My lords, at page number 258, para 2.1, at the bottom, just the last few lines, my lords. In view of this, we remit the entire issue to the file of the TPO to pass orders in conformity with the show cause notice issued by him after considering the reply of the SSE to the said show cause notice. At this stage, we refrain from going into any other grounds. My lord's, point of the matter is, pursuant to the tribunal's order dated 21st June 2023, the transfer pricing officer and the assessing officer had to pass an order giving effect. Now, my lords, the time limits are provided in section 153. Would my lords be kind enough to take section 153 subsection 5 at page 1.1048? One point 1048 minutes.
One point
1048. As my lords are aware, section 153 sets out the time limit to pass orders in various circumstances. I'm specifically taking my lords to subsection 5 at page 1.1048. At about the middle of the page, my lords.
Just 1 minute. Section
153. My lords, section 153 starts at page 1.1042.
one
153. Well, as this section reads, time limit for completion of assessment, reassessment, and recomputation.
Yes, subclause.
Subsection 5, my lords, at 1048.
Yes.
May I read the clause, my lords?
Yes.
Where effect to an order under section 250 or 254 or 260 or 262 or
This is an
263.
order under
254, my lords.
254.
Yes, my lords. Is to be given by the assessing officer or the transfer pricing officer, as the case may be, wholly or partly, otherwise than by making a fresh assessment or reassessment or fresh order.
3 months.
3 months, my lords. 3 months from the end of the month in which the order is received by the PCIT. Now, my lords, in my case, as my lords have
From
noticed,
July
23.
From 30th July, 3 months.
They have 3 months. Lords, the first proviso extends this time limit by another 6 months. The second proviso says if any submissions of the SSC are required to be verified, then the time limit is the time limit referred to in subsection 3. My lord, subsection 3 is just at the immediate previous page, 1047.
Now, when is the order giving effective passed?
My lord, the transfer pricing order is passed on 26th September 2025. That is at page 313.
26 September
2025.
25.
Yes, my lords.
Page
313. I'll take my lords to straight to the bone of contention. The contention is at page 314. The TPO's comment to my objection as to the proceedings being time barred are at page 314 towards the second half of the page.
Yes.
My lord, subsection 3, as my lord, as I was just referring to. May I just read subsection 3, my lords? Notwithstanding anything contained in subsections 1, 1A and 2, an order of fresh assessment or fresh order under 92 CA, as the case may be, in pursuance of an order under subsection 250 or 254 or 263, setting aside or cancelling an assessment or an order under 92 CA, as the case may be made at any time before the expiry of 9 months from the end of the financial year in which the order is received. My lords may just notice the first proviso, the last line of the first proviso, where this period of 9 months is extended to 12 months in cases where the order is received after 1st April 2019.
Yes.
Therefore, my lords, the effect of subsection 5, the second proviso to subsection 5 read with subsection 3 is that, my lords, the time limit to pass an order giving effect pursuant to the order of the tribunal ends on the last day of 12 months from the end of the financial year in which the order was received. Now, my lords, in my case, the order was received during the financial year 23-24. Therefore, 12 months expires on 31st March 2025. This is ignoring the first proviso to subsection.
No, let us see. Now you take, please, you want to examine.
May I just hand over one judgment, my lords? This issue came up for consideration before this honorable court in United Spirits. Identical issue, my lords. My lords, when I objected to the proceedings saying that proceedings are time barred, the assessing officer referred to subsection 4 of 153, which states that where there is a reference to the transfer pricing officer, the time limit gets extended by another 12 months. My lords, that is discussed in this very decision. May I point out the relevant portions, or my lords would like to?
Page?
My lords, the facts are at page 7 and 8.
No, the observation.
Observations, my lords, are at page number 41. Para number 9. The issue would be whether there has been a reference under 92 CA1 to the transfer pricing officer, or the matter being remitted to the transfer pricing officer by the tribunal to decide the issue under 92 CA3. There is a world of difference between the matter being remitted by the tribunal to the transfer pricing officer under section 92 CA and reference by the assessing officer to the transfer pricing officer under the said provisions of 92 CA. The subtle difference is considered by the division bench of the High Court of Delhi in the case of New Delhi Television versus Dispute Resolution Panel. My lords, I'll skip a couple of the paragraphs. My lords may kindly turn to page 45. Para 80 of the relied upon decision is extracted. May I just be permitted to read 80 and 81? It becomes pertinent to observe that section 92 CA reference rests solely upon the assessing officer being of the opinion that a reference is required to be made to the transfer pricing officer for computation of arm's length price. That power stands conferred upon the assessing officer and is available to be exercised in the course of assessment. However, as is plainly evident from section 153(3) of the Act, the statute does not deprive the Income Tax Appellate Tribunal of the authority and jurisdiction to require a fresh order under 92 CA being made. As we have observed herein, section 153(3) of the Act speaks of assessments as well as orders under 92 CA that may be required to be made pursuant to an order passed by the Income Tax Appellate Tribunal in exercise of its appellate jurisdiction comprised in section 254 of the Act. In our considered opinion, the reference which the assessing officer proceeded to frame on 27th December 2018 was thus clearly superfluous and in any case cannot be sustained on the basis of 153(4) of the Act. It is pertinent to note that subsection 4 of section 153 is concerned with a reference referable to section 92 CA1. That provision, as noticed here in above, is confined to a reference to the transfer pricing officer that may be made by the assessing officer. The limited application of section 153(4) is also evidenced from the provision using the expression made during the course of proceedings for the assessment or reassessment. Subsection 4 is thus clearly confined to a reference that the assessing officer may choose to make in the course of assessment. Subsection 3 of section 153 of the Act, on the other hand, deals specifically with assessments and orders under section 92 CA that the authority concerned may be liable to make in terms of the directions issued by the Income Tax Appellate Tribunal. Consequently, it would be the principle of generalia specialibus non derogate which would stand attracted and be determinative of the question that stands posited. My lords, the finding in this very decision comes at page number 73. The conclusions comes at page number 73. The third line from top, my lords. If the facts obtaining in the case at hand are considered qua the law as considered by the coordinate bench in Wipro and High Court of Delhi in New Delhi Television Supra, what would unmistakably emerge is that the limitation to pass an order after remand from the tribunal is 31st March 2024 and not 31st March 2025. The order is received from the tribunal by respondents 1, 2 or 3 as the case may be on 5/4/2022 and 22/11/2022 respectively. Therefore, if 12 months is computed from the end of the financial year of 22-23, which would be 12 months from 31st March 2023 and limitation would expire on 31st March 2024. There is no extension of 1 year as contended by the revenue merely because documents are sought for by the revenue or reply is filed by the petitioner to documents so sought. In that light of the petition,
We'll stay it, you take your stand.
Melas, just one additional fact. I filed this writ petition after the transfer pricing officer passed his order. Now, in the interim, Melas, the assessing officer also has passed a draft assessment order. I have filed an interim application for amendment to bring on record the consequential draft assessment order.
1 of 26 has been filed, seeking to amend the pleadings, including amendment of the prayer. Proceed. The order passed by the first respondent dated 23/2/2026. Petitioner submits that amendment is necessary in light of the subsequent events. Said application is allowed, amended petition to be filed. Petitioner has challenged the order giving effect to the order dated 21/6/2023 that Annex G has been by limitation in terms of section 153 of the Act. Submitted that the order ought to have been passed within an outer limit of 12 months from 24/7/2020, from 30/7/2023.
Outer limit of 12 months from the end of the financial year in which the order was.
12 months from 31/3/2024.
Yes.
As it is submitted that the order is passed on 26/9/2025 and reliance is placed on the order passed in WP 18439 of 2024. Matter requires consideration. In the interregnum, there would be stay of order at annexure G as well as the
Order at annexure Q.
Proceedings by virtue of order at annexure Q. Readings to be completed within 2 weeks. Relief accepts notice for the respondents. Yes.
Grateful.
I pay for the petitioner, please. This is a matter wherein I have challenged annexure A, which is cancellation of registration. This has been done on the reasoning that I have availed wrongful availment of input tax credit, please, my lords. Take my lords to the page number 26.
Yes.
Initially, my lords, a show cause notice cum cancellation of registration was issued by the respondent number 1, stating that you have availed a wrongful ITC and hence I am placing you under immediate suspension and calling you to show cause as to why cancellation of your GST registration should not take place. Subsequent to which, I reply at page 29, stating that I am present in the principal place of business. I have not undertaken any activity with an for having wrongfully utilized ITC, etc. I take up everything, please, my lords, and they call me for a personal hearing, which is at page 53, the record of it. The last para, please.
Why was it adjourned?
It was for the instructions.
To seek instructions. It is a case which could be remanded, my lords, for the reply of show cause notice. And in the meantime, since there is a cancellation of registration, it could be revoked.
The personal hearing, what happened?
In the personal hearing, the last para, please, my lords.
Yes.
The taxpayer has availed ITC from certain non-existent suppliers whose registration is cancelled retrospectively. Are you aware of the fact? Total ITC to the tune of so and so has been availed from such non-existent suppliers, and the same is eligible for so and so. To which the authorized representative sought the list of such suppliers and requested that necessary documents will be furnished. If they had given, this is the activity which has taken place, with this GSTN number or this entity, we would have come forth saying that I have done my activity in a right manner and availment of ITC is correct, which they did not give and cancelled my registrations, please.
The petitioner.
May make one submission, please. Even if it is remanded to the stage of show cause notice, the suspension will be there. That may be revoked, please, my lords.
By the virtue of cancellation of the, order, my lords, it will be revoked.
No. When they give me a show cause, the suspension will be there, please. But that should also be revoked.
Show cause is only to seek the reasoning, my lords. It
But
doesn't
show
speak
cause
anything
comes
about the
suspension.
suspension.
The petitioner is sought for setting aside of the order dated 30th January 2026 at Annexure A, which is an order of cancellation of registration. Next, peruse the order at Annexure A. The ground made out for cancellation of registration of GST is that is a wrongful availment of ITC in violation of provisions of section 16 of the Act. Next, counsel for the petitioner submits that the order of cancellation was preceded by a show cause notice for cancellation of registration. Further submitted that an opportunity of personal hearing was granted, and petitioner had also made his reply to the show cause notice. During the proceedings for personal hearing, as regards the allegation of wrongful availment of ITC, it is submitted that the authorities had quantified wrongful availment as 64 lakhs 5,566 as having been availed from non-existent suppliers, and that the said ITC was ineligible in terms of section 16 of the CGST/SGST Act 2017. Next, counsel for the petitioner submits that details of wrongful availment of ITC with reference to transactions and suppliers, if furnished to the petitioner would make out a written reply and place his case before the authorities. Submitted that in the absence of such material, petitioner is not able to take his stand regarding the serious allegation made by the revenue. Next. While noticing the assertion of the petitioner that details of wrongful availment of ITC have not been furnished, it would be appropriate to set aside the order at Annexure A and remit the matter for further inquiry to the stage of reply to show cause notice. The revenue to furnish details including transactions and that of suppliers and all other details relating to wrongful availment of ITC. Such information to be sought upon such information being furnished, petitioner is permitted to file an additional reply, and the authority may proceed further in accordance with procedure after following principles of natural justice. We'll stop next. However, the order of suspension of registration of ITC would stand set aside, and the show cause notice would be treated to be a show cause notice simpliciter. All other contentions are kept open. In light of the order setting aside annexure A, the appropriate steps to be taken for revival of petitioner's registration forthwith. Next, petitioner to appear before respondent number
One, please.
One man.
one without further notice on.
But date could.
All other contentions are kept. Accordingly, petition is disposed of.
Obliged, please.
My lords. This is a petition for 4 years. My lords, may I take my lords to page 34, my lords, annexure A. My lord, we are in challenge on a intimation under 143(1). On the right hand side, my lords, row 35, 4 digits from the bottom, my lords will see.
Page
34, 34.
Yes.
It says 000. This, the heading will see is as computed under 143(1). The adjacent column on the left is as provided by the taxpayer. Advance tax 2,25,000. 4 digits from the bottom, madam.
Yes.
Then below that, TDS 1,14,291. Then self-assessment tax 4,140. All these amounts are denied to me. My lords, may I take my lordships over the page, page 36. Reasons for mismatch on the right hand side, middle of the page. Page 36. The PAN number is stated and says has been reported for certain issues due to which credit cannot be given. Please refer note. That note, my lord, is over the page at page 37. Note 4. May I read 4, my lords?
Yes.
The TAN. First of all, it is a PAN. I don't know why they are saying TAN. They have quoted the PAN number. Has been reported for certain issues by AO. Accordingly, credit of TDS from the said TAN cannot be allowed till the issues are cleared by the said authority. You may contact the deductor in this regard for resolution and apply for rectification only after the resolution is completed. Now, we are in respect of TDS. This issue, what they are telling us that there is a dispute in my TAN. I have received TDS from 2 people, but my self-assessment tax and advance tax is also not been given credit of. If I may take my lords to page 11 of the petition, I made a table. Now, if there is a dispute insofar as TAN, the person who has deducted tax, that is one thing. If my lord see the table, advance tax, I have stated, TDS self-assessment tax. Advance tax and self-assessment tax is paid in cash by me. That is also not given credit of. And they are not telling on what is the problem with my deductor. Now I have made a list of my deductor at page 22.
Yes.
Your Lordship, this impugned orders are passed under section 143(1). Your Lordship, this is computer generated, my lord. This is also an order. Your Lordship, this is appealable before the first appellate authority under section 246A, my lord. Your Lordship, the impugned order is 143(1) is dated 12/1/2022. And after this, my lord, they filed the rectification application and it came to be rejected on 10/11/22. After this, they have not taken any steps, my lord. Your Lordship, let them file an appeal, my lord. Your Lordship can observe that till disposal of the appeal, no recovery. Let them file an appeal, my lord.
My lords.
Correct now. He's saying, admittedly, TDS and self-assessment tax paid. That you verify. If there is some issue, then we'll send it to the appellate authority.
Yes,
but he's saying, apart from the TDS,
yes, my lord,
that we'll see the remitter and etc. Yes. But his self-assessment and advance tax, he says is excluded.
My lord, I have filed an RTI and they have admitted
No,
I have credit.
Correct. But you verify it. Let us. Yes. When do you want?
2 weeks, my lord.
Relist. The same stage on.
I'll take notice for R1, my lord,
Third counsel,
CPC.
Arvind Chavan accepts notice for
R1.
R1.
My lord, I have made an interim prayer.
Sanmati accepts notice for respondent 2
and 3.
2 and 3, my lord.
Interim prayer is there, my lords. Because the taxes paid has not been credited, there is a demand. So my further refunds, or they may attach my account for making recovery also.
Your Lordship, 2022 intimation, they are challenging in 2026, they want stay, my lord. Let me get instructions, my lord.
My lordship should impose cost for not giving me credit. For the
Let us
time
see.
being, I'm only interested in,
No, let us see. On the next date, we'll see what we can do.
Please.
my lords, this month of March. So they may attach my accounts for recovery and they are for 4 years.
What is the amount?
My lords, page 11, my lords.
No,
My lords may see the page 11.
Lordship, can you have it next
Total
week?
is
My lord?
there.
I will just verify what has.
Each
the
year I
present
have,
position.
Just wait, just wait. Release the matter on Tuesday.
Please,
my lord, may, okay, 21, 22 and 26 are connected matters.
List along with 21, 22 and 26.
Please, my lords.
In all the matters,
R1, I'll take notice, my lord. R2 and 3, Sanmati.
Learned Counsel Arvind Chavan accepts notice for R1. Learned Counsel EI Sanmati accepts notice.
My
for
lords, if my
respondent.
lords grant stay, they can take a whole month and do it. I'm only worried about them attaching and recovering further amounts from my account. That's all in my prayer.
Your Lordship, I will just have a word with the assisting officer, my lord. Can you have it next week, my lord?
Let's see. On
I
Tuesday.
leave it to my lords.
Yes.
Please. Obliged.
Everybody is scared of March.
They have the money still, they want to recover from you.
Ides of March. Yes.
Please, my lords. My lords, I am seeking a declaration in this matter to the extent that corporate guarantees, my lords, provided by holding companies towards the bank for the subsidiaries or group
I'll
companies.
accept notice for respondents 3 to 5 months. Because this is against an order passed by the first appellate authority. Matter will have to be entertained here. For respondent 1 and 2, my lords, one of the central government standing councils can take notice.
My lords, in
First
fact,
title is at page
my lords,
14.
Page 14.
So you appear for
3 to 5 months.
then the G Kumar accepts notice for 3 to 5. G1 Niralgi accepts notice for respondent 1 and 2.
Lords, insofar as interim order is concerned, my lords, the order in original has been modified by the first appellate authority, my lords. And my lords have consistently said, my lords, because it's in the nature of a second appeal, 10% of additional tax to be
my lords,
deposited.
this matter is
As
already
it is to be
pending
done-
before your lordships, my lords. This, in fact, your lordships is already seized of this matter, my lords. The same issue, interim orders has been passed in the past. The issue is, my lords, I am challenging the constitutional validity of the notification number 52 of 2023.
What you could mention.
My lords may have the order dated 18/6/2024. 18/6/2024 on the previous page.
Sushal Tiwari.
Thereafter, my lords, in fact, this order was also further modified by Justice Krishna Kumar, my lords, dated 14/8/2024.
14th August.
14th August 2024.
So that we'll see.
My lords, in this case, I am impugning the same circular, my lords, the same notification, and challenging the levy of GST on corporate guarantee, my lords. It's a court jurisdictional issue, my lords.
What is that IA file? What was that IA in that? IA 1 of 2 of 24, 1 of 24. What were those IAs filed in that matter?
My lords, I am not appearing in this matter, so I will not be aware of it.
Yes. Yes.
That seems to be an, that seems to be an application seeking modification of the interim order granted earlier, my lord.
In fact, in that case, my lord, what I understand is that DRC 01A was issued, which was directed to be withdrawn.
We'll see.
Pursuant to an interim order granted by this honorable court, my lord, there seems to have been show cause notice issued. And paragraph number 3, my lord, will get it. The last 3 lines. I deem it just and appropriate to dispose IA2 of 2024 by clarifying that the interim order dated 18/6/2024 would include restraining respondents from issuing show cause notices and passing orders also.
So there was a complete stay, my lord, in this.
Each and every matter, my lords, involves interpretation of the agreements that they have been entered into, my lords.
Well, these are
I would
standard.
only try to impress upon this court, my lord, since it is in the nature of a second appeal. 10% of the additional tax as modified by the first appellate authority to be deposited, my lords.
You're correct, but now here it appears, now whether corporate guarantee is a shareholder activity and does not come, so some jurisdictional issues there.
This is court jurisdictional issue, my lord. It's not a issue because the
Light of
G-Stat.
Contention.
The copies we served.
Yes, yes.
And my lords, I direct them to produce legible copies of the agreements, my lords.
Yes.
Insofar as my petitions are concerned, I'm unable to go through the.
Yes.
Because the very.
Counsel for the petitioner.
You can send me a soft copy.
It's that identical legal issue raised in WP 12498 of 2024, and this court has granted an interim order. Reference is made to interim order passed on 18/6/2024, which reads as hereunder. Next. In light of the contention raised that in the present matter as well, an identical issue has arisen. Matter requires consideration. In the interregnum, there would be stay of.
My lords, annexure A, page 92.
Stay of annexure A. Copies to be served.
As well as, my lords, circular annexure D.
And pleadings to be completed within 2 weeks. A and
D, my lords, annexure D.
A and D. Stay again.
Page 116.
Yes.
The circular is not been stated.
Circular is stated. It has been stated in the earlier.
Annexure D.
D for Delhi, my lords.
No,
Page 116.
No, just a circular will leave it. Any annexure A will stay. Remaining will see.
All right.
Annexure A. No, annexure A anyhow we are staying. Annexure A ma. D better. Yes, sir.
That's 20.1, 20.2 connected matters.
20.1
and 20.2, same show cause notice, different orders. For the same show cause notice, different period.
Different assessment years.
Different years.
ಅದೇ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ in light of interim order granted in WP 6819 as extracted above, there would be stay of
same annexure A, my lords. In that also.
A.
A.
I mean next 20.2 in light of interim order passed in WP 6819 of 2026, there would be stay of annexure A.
Page 92.
ಅದರಲ್ಲೂ same. M. Kumar accepts notice for respondents. One now in the
respondents.
No, just
3, 4, and 5.
In 20.1, cost title 20.1. Cost title. In 20.1. 20.1, G1 accepts notice for 1 and 2. Him Kumar for 3 to 5. Same in 20.2.
Yes.
Yes.
Obliged.
May I please? Lord, the assessment year 24-25 intimation was passed in December 2024. There was a mistake, my lord, in taking the advance taxes and TDS credits that I had. Because on account of merger of 3 companies with this company, SC company, there was additional TDS credit that I was entitled for. So I made applications for rectification of that intimation. Ultimately, my lord, after multiple follow-ups, although the intimation was in December 2024, if my lords kindly come to Annexure J, the rectification order at page 500. Page 500 in volume 2.
Yes.
Annexure J. My lords have that? In the instant case, the following companies got merged with the SSE, white NCLT order bearing number so and so. Further, the SSE has filed its return of income for AY so and so on 2510, claiming consolidated TDS credit of 160 crores, as appearing in the respective form 26AS of all amalgamated entities. The return of income was processed under section 143(1) on 13/12/2024 by CPC. However, in intimation order under section so and so, CPC has allowed TDS credit only to the extent of 119 crores, as appearing in form 26AS of Quest. TDS credit of rupees 41 crores of all 3 companies pertaining to amalgamated company were not considered by CPC. On 13/8/2025, the SSE has submitted an application requesting for transfer of TDS credits. In fact, the application was submitted much earlier. As soon as the intimation was passed, we made an application for refund. This was a subsequent application by way of follow-up from old PAN to so-and-so pursuant to. On verification, the claim of the SSE is found to be correct. Subsequently, so-and-so did a refund of 42 crores has been determined. Now it's been corrected. This is in September 2025. Till date, we have not received the refund. All that we are requesting is that direction be given to refund this thing. Now the jurisdictional assessing officer says he has already intimated the CPC to process the refund, but CPC is not doing it. Therefore, my lord, a direction to respondents 3 and 4, which is CPC, to process the refund within a week or 2, my lord. Because end of year, we are also in need of funds, not just the government.
Take instructions. If the asking officer has already communicated by way of a OG that the amount can be released, then I'll seek instructions. My lordship may have it.
No, this matter was
Tuesday.
posted today at their request. If your lordships recall, on 2nd March, your lordships had directed notice and they said they'll take instructions.
I'll just take instructions.
Tuesday.
Very.
Matter. Same stage on Tuesday. See, such matters in Lok Adalat you have to do. No, what is there now? They've already issued instruction.
Unless there's a mandate, my lord, my learned friend is appearing, my lord, for jurisdictional assessing officer. I mean, they take instructions from the jurisdictional assessing officer, although they have no control over the CPC. Unless a mandate is given by this court, CPC is not going to do anything.
It was like this, my lord. After the rectification order, the jurisdiction officer has to issue a mandate or issue instructions to the CPC that yes, there is a rectification order, there is no other demand against this assessee, you can release it. Once we get that, my lord, we process it. Normally it takes around 2 months or something, we process it, my lord. Now it is September 2025 where the rectification order has been passed. I don't know when the jurisdiction officer has issued the intimation, so I'll just take instructions, my lord.
Tuesday in the same stage.
Great.
For the respondents.
Malos, this case is where the petitioner has applied renting of immovable property services and
has applied
renting of immovable property services without payment of tax in terms of section 16 of the IGST Act, which at the relevant point of time, that is 21-22, did not have the words for authorized operations. Now, in my case, I'm not seeking for refund. If my lords recollect, on the previous occasion, I had taken my lords to page number 57, which is the relevant part of the order. If my lords could just come to page number 57, It will all be clear because there's a chart there as to what the department seeks to demand in my case.
Yes.
Now, if my lord see the chart, the second last column there, it says pending. Now, this pending is a form called DSPF, DTA Service Procurement Form. Now, in terms of section 16, I am not required to submit anything. But nevertheless, I had submitted as far as I could. Now, so far as these pending forms are concerned, these are in respect of the tenants who have left and gone. And there is no way for me in 26 to obtain the DSPF forms and submit it to the department. Now, based on that, they say that I have to pay the tax. Now, my only submission is this. In 16, in 21-22, section 16 did not have any condition saying you have to submit these forms. So that is one. Secondly, my lords, on the last occasion, I had also handed over two interim orders of this honorable court because the audit conducting authority in my case is also the adjudicating authority. Now, based on that, my lords, in the previous occasions had already stayed the matters. So last occasion he had said
One of
that
the orders passed in WP number 961 of 2026. 2026. Copies should be available there.
I had handed over copies last time. Yes.
On that point.
Yes. In 961, my lords, there's a detailed order.
Here
That is the
also-
second order.
Now, in one of those matters, you complete your.
I'll do that.
Instruction.
I'll do that.
Counsel for the petitioner submits that where the auditing authority is also the adjudicating authority, proceedings are in violation of principles of natural justice, and such issue is in consideration in other petitions, including WP 961 of 2026, in which interim order has been passed. Accordingly, taking note of identical contention raised in the present matter also, there would be a stay of
Annexure A.
Annexure
A.
Pleadings to be completed by the respondents within 2 weeks. List along with, or we leave it separately?
It can be dealt separately. In one of the matters, I'll complete the pleading.
Leave it separate.
Grateful.
Serial number 25, Chetan.
Please unmute. You're not audible. Please unmute. You're not audible.
My lord, petitioner is a works contract, my lord. As a proper officer passed the order without giving abatements and then classification and then any exemption, just based on the income tax return data, he passed the order, my lord. So I am seeking a fresh assessment, and then my bank account was attached since 2.5 months. I'm unable to pay salaries, and then our business was paralyzed. We are severely impacted, my lord. You kindly grant the stay on the bank account attachment. And
He's not bothered of Chinmay anything. He's only bothered of attachment. Even if the writ petition is to be allowed, he doesn't mind. Say first attachment.
Yes, my lord. Because of bank attachment, we are severely impacted, my lord.
Yes, yes.
And willing to support and provide all documents, and then if they do fresh assessment, my lord.
On merits, you are saying
also taken arbitrarily 20% enhancement, my lord, for Jan 2017 to July 2017. That data he taken straight away 120% of the previous year without any having information by him.
No, on merits, it's exempt, negative list, barred by limitation. What is your ground?
My ground, these three, my lord, properly he didn't classify which is the taxable value of section 67 valuation. He didn't properly, just based on the gross receipts income tax return data available, he took that, and then he asked to us pay service tax on that, my lord. I am asking you just properly value and then properly give classification, give abatement because I am a works contract. I supply goods and labor as well as
Yes,
service.
yes.
Service only it should be
Petitioner.
chargeable, and then at the time of works contract abatement also is there, my lord. So he has to give me abatement. He has to properly classify, and then on taxable value of services we are willing to pay, my lord.
The petitioner has sought for setting aside of the order in original at annexure A. A perusal of the order at original at annexure A would
So my
indicate.
objection is, my lord, is ident
Just wait.
is
Yes,
respondent failed to write. Yes, my lord.
Just wait. Just wait.
Oh, okay.
Annexure A would indicate the proceedings are initiated under the provisions of the Finance Act.
73 of the Finance Act.
73 of
Yes,
the
ma'am. Finance Act
Finance
91.
Act on the basis of input received from the Central Board of Direct Taxes. And counsel for the petitioner submits that where proceedings are initiated under provisions of the Finance Act solely on the basis of declarations under the income tax returns or inputs from Central Board of Direct Taxes, this court has set aside the orders and remitted matter for fresh consideration, taking note of the observations made in WP 11154 of 2023. Next, on a perusal of the order, it is noticed from the observations made in para 2 that the proceedings are initiated solely on the basis of inputs received from the Central Board of Direct Taxes. Petitioner would submit that the procedure followed in quantifying the service tax demand is without affording sufficient opportunity of participation in the proceedings. Next, repeat para 9, para 10. Accordingly, the order at annexure A is set aside. Matters remitted to the stage of reply to show cause notice. Authorities to take note of the observations made in the order dated 3/7/2024, passed in WP 11154 of 2023 and connected petitions as extracted supra. In specific to the observation at para 10 of the order, as may be applicable. All contentions are kept open. Next. Needless to state, petitioner is at liberty to make out a reply to the show cause notice. Next. Petitioner to appear before the respondent number 1.
Assistant Commissioner Kesmal.
1.
Yes, my lord. Yes, my lord.
Without waiting for any further notice on
17th of April.
17th of April 2026. Next, accordingly, petition is disposed of. In light of setting aside of the order in original at annexure A, the respondent authorities are directed to rescind the intimation to the bankers for attachment of account forthwith. All other contentions are kept open. Notice is dispensed as regards respondent number 3. Yes.
26 urgent. 27 Deepak.
Much obliged, my lord. Thank you, my lord.
May I seek for a short pass over, my lords? Senior counsel engaged.
Pass over.
28.
Lords, I appear for the petitioner in this matter. Lords, I'm challenging this ex parte order of the year 2024 and a demand notice subsequently of the year 2026, my lords. My only submission that is it has been I have been placed ex parte. Therefore, the matter may be remanded, my lords.
It's an ex parte order, my lords. Can you look into Annexure B? There is no reply that was filed. Page 24, my lords. Page 24, para 9.
The petitioner has sought for setting aside of the order in original at annexure A. The perusal of the said order at annexure A would indicate that the department on verification of GSTR-9 returns for financial year 2018-19 had observed that the petitioner had availed excess ITC of rupees 3,29,163 and accordingly show cause notice came to be issued. As a petitioner has not made out reply to the show cause notice, the authority on the basis of material available has completed its adjudication. Next. The counsel for the petitioner submits that non-participation was due to bona fide reasons and the petitioner, if granted an opportunity, would demonstrate that the alleged discrepancy regarding availment of ITC would be demonstrated as to be an improper allegation made. Taking note of such contention and noticing that the authority did not have benefit of reply to the show cause notice, it would be appropriate to set aside the order at annexure E and remit the matter to the stage of reply to show cause notice. All contentions and merits are kept open. Petitioner to appear before respondent number.
Yes, my lords, it is before the superintendent has passed the order, my lords. However, superintendent has passed the order, but superintendent is not been made a party, my lords.
I'll make it, my lords. Within the course of the day,
Could be amended.
Amended.
No course of the day. Now itself you do.
Yes, my lords. Now itself.
Before the superintendent.
Superintendent of Central Tax, my lords.
Superintendent of Central Tax. Without further notice. On
17th of April.
17th of April.
I'll appear for respondent number 3.
Order sheet. AGA M. Kumar accepts notice for respondent.
3 months. 2, I don't know who the party is.
No, this is an appeal, is it?
There's no.
I don't know why Joint Commission has been made a party.
Don't know.
There is no
It's been
appeal.
made a party.
Strike out the second respondent.
Strike it out, my lords. This appeal. This is not an appeal.
Huh?
Strike it out, my lords. This is not an appeal. I'll strike it out.
So, AGA M. Kumar accepts notice for the first respondent. First is no.
First is,
first,
I am appearing for first respondent.
for the
Sir is
third-
for 2 and 3, my lords.
For the third respondent. For
Two is deleted.
For the Commissioner of Commercial Taxes.
When what?
Learned Counsel Akash Shetty appears for the first respondent.
And
Petitioner.
My lords, and also to the superintendent of Central Tax, my lords.
Petitioner makes a request for deletion of second respondent, Joint Commissioner of Commercial Taxes. And also makes a further request for including the Superintendent of Commercial Taxes.
Central Tax.
Central Tax, yes.
Superintendent of Central Tax.
My lords will get it at page 26, my lords.
Oral request is acceded to the Superintendent of Central Taxes is directed to be arrayed as an additional respondent. Necessary amendment to be carried out to the Cost title. Learned Counsel Akash Shetty accepts notice for the said respondent.
My lord, central.
Respondent.
My lords, and my lords, annexure A is the GST certificate, my lords. Annexure B is the order. B needs to be quashed, my lords. A and
A is the summary. Along
please,
with
please,
the
please,
summary
my
order.
lords, please, please, please.
Along with
Yes, yes.
Grateful.
29, Naveen GS.
Lords, it's the assessment order passed after the time limit, my lords. Your lordship may kindly see. Page number 36, my lords.
page
36. That is the show cause notice, my lords. For the year 2017 and 18, issued on 4/1/2024, wherein the time limit for the department was 30/9/2023. Further, my lords,
Why do you say what is the provision?
lords, there was a notification issued, my lords. Notification number 9 of 2023 at page number 76. Which had prescribed them, lords, the last date for under which they could have passed order and issued notices for the financial year 2017-18 for passing of order itself 31st of December 2023.
Which is the page number? Page number.
76. There was
So which year?
17-18, my lords.
So 31st December 23.
Yes, my lords. That is the date on which they should have passed order. They issued notice itself on 4/1/2024.
And order is passed on
21/3/2024. At page number 46, my lords. Page 46, my lords. 21/3/2024.
Yes. Yes.
I'll accept notice, Manoj. I'll verify, Manoj.
Learned Counsel
Because there is one more notification, I think, where the time has been subsequently extended.
That is for 18, 19 and 19, 20.
I'll just verify, Manoj.
56 of
J. Kumar accepts notice for respondents. Relist the matter in the same stage on question.
Next week.
25th.
My lords, on first May.
lords. Till such time, let them not precipitate the matter, my lords. Let them not issue any coercive steps. Attachment of bank guarantee.
The order is dated to 21/3/2024.
We had filed an appeal, my lords. That was also dismissed. That's why we are before.
And that is dismissed on the ground of delay.
As such, my lords, let
And
them
that
not.
order is also dated 28/1/2025. Nothing will happen in 2 weeks.
March.
I know. I would have taken it for next week itself, but since 4 days holidays, I'll not be able to get instruction. That is the reason.
Respondents not to take any steps for recovery in light of the contention that the order is passed beyond the time permissive, beyond the time extended by virtue of the notification at annexure
Annexure, my lords. G, my lords.
G.
Grateful, my lords.
30, Srihari.
For the petitioner in this matter. My lord, in this matter, the input tax credit of the petitioner was blocked. And the date of blocking was 21/11/2024. Even despite the expiry 21 November 2024. Despite the expiry of 1 year, it remains blocked. So I've submitted a judgment in the last date of hearing. The Lord has passed, it's an identical matter. Paragraph 4, the Lord has held 86A subclause 3 clearly states that the restriction shall cease to have effect after the expiry of a period of 1 year from the date of imposing such restriction.
Just look into it.
230.
Or Tuesday, my lord, I'll just. fine. I'll just look into it.
So that is 1 year.
1 year, my lord. I'll lordship have it on Tuesday, my lord. I'll.
Third counsel. Arvind Chavan accepts notice.
I already accept.
Relist the matter in the same stage on Tuesday.
Tuesday, my lord, please.
May make a submission. So in 60, covered matter.
We'll see. At 2:30 we'll see.
Great.
Sir. ಬೆಂಚ್ ಇಲ್ಲಲ್ಲ ಸರ್ ಇವತ್ತು ಮಧ್ಯಾಹ್ನ ಇಲ್ವಾ ಬೆಂಚ್ ಇಲ್ಲ ಇವ್ರು ಇದ್ದಾರೆ ಫುಲ್ ಬೆಂಚ್ ಇದೆ ನಿನ್ನೆ ಫುಲ್ ಬೆಂಚ್ ಇತ್ತು
ಸರ್ ಮಧ್ಯಾಹ್ನ ಇರ್ತೀರಾ ಸರ್
Yes. Submission, my lord. So it is in respect of sixth court, my lord. So we have filed a writ petition yesterday against the government as well as the Malur CMC. So earlier two directions has been issued by this honorable court. The latest direction has been issued last year, April 2025, directing to consider my form number 53, which is filed in year 1999. madam. And also some prohibitory order has been issued against the government as well as CMC not to dispose of it. Today morning, 12 o'clock, the CMC as well as Tahsildar of Malur, they went to the spot and they are forcing to evict the from the scheduled property of which is in question till date. That's why, my lord, I am moving for at the end of the list today, my lord. This is third petition we are filing. In two petitions already directed, undertaken by the authorities. Still, they are issued last week an intimation letter that my application has been in 2019 itself. But this honorable court prohibited them to not to act upon that endorsement.
You serve the government advocate. One extra copy, ask them to take instructions. I'll take it at the end.
So,
Serve an additional copy.
yes, I will, sir. I will, sir. So the office objection ಏನಿಲ್ಲ some okay ಇದೆ scrutiny branch.
Government advocate ಹೇಳಿ, let him find out by the time the matter is taken up.
Yes.
Let him telephonically call and find out what is the version of the state.
Yes, ma'am.
And you bring him and come, I'll take it at the end of the list after 4 o'clock.
Yes.
Samant Naika ಅಥವಾ ಆಶೀಶು ಅವ್ರಿಗೆ
Issue 2, fresh matter, serial number 1, Siddaramaiah VB.
Petition in this case, my lord. My lord, it's a purchase writ petition, my lord.
ಇದು ಯಾರು government advocate ಅವ್ರಿಗೆ ಬರ್ತಲ್ಲ? Let us see, let the government advocate of that court all come.
Please, ma'am.
I'll take it up. ಅವ್ರು ಖರ್ಚುಬಿಟ್ಟು ತಗೊಳ್ಳಿ.
Serial number 2,
Petitioner. To respond to this matter, my lords, yet to file my statement of objections. This case will pass over, my lord. The senior counsel address the argument.
No, what is the urgency now?
At urgency is, my lord, lord,
Where is the government advocate? Let the government advocate of that court all come first.
please do.
For Burley or pass. Unless there's emergency, I'm not taking the other court all matters. Yes.
Pass over matters, serial number 27, list 1, serial number 27, Deepak.
Lord, I appear for the petitioner's counsel, Lord. I'm sorry, I was not here in the morning when the matter was called. Lord, what is challenged before your lordships are, my lord, notices purportedly issued, my lord, under 143. But really what they seek to do is something more than that, is my respectful submission.
Just 1 minute.
Please.
Yes. Income tax. $27.
27. List 1, 27.
Please, I'll take notice.
You will take. Just 1 minute.
Please.
Let this come before some other bench. There's some disability.
Oh, I'm sorry, my lord. I did not realize that. I'm so sorry. I'm so sorry.
No, that's okay.
I did not realize. I'm sorry. Very good. Very great.
Relist before, not before me.
Please, so great. Publish.
I'm scared. Neighbors, something happens.
Oh.
If something good happens, okay. If something otherwise happens, then I'm in trouble.
No, 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 I perfectly understand. I'm so sorry. I did not even realize that. I'm sorry. Grateful.
Yes.
Issue to fresh matters. Serial number 1, Sidramaya VB.
Sorry, my lord.
My lord, it's a purchase writ petition, my lord. The first sale deed is, my lord, 23/10/1997, my lord.
Now, what is the urgency? First you tell me,
My lord,
then you go to the case.
they have
What is the urgency now?
They have issued a eviction notice, my lord.
Inaction?
Eviction, my lord.
Inaction?
Sure, my lord.
When is the first sale?
My lord, first sale is
26.
1997, my lord.
97. It's a single site.
Site sale.
Single site of 60/40.
60/40, my lord.
Out of 28 guntas of land, my lord, 60/40. Restoration is sought in, my lord, 2016.
Light of the.
Restoration in 2016, my lord.
Yes, in light of the contention. That the first sale. In 1997.
19 years.
On first sale was on 23/10/1997. The proceedings for restoration have been sought in the year 2016 after undue delay. Subject to further consideration, there would be stay of
Second will pass out.
So now you are seeking what?
My lord, earlier, my lord, we have filed on writ petition, my lord, seeking a direction against, my lord. Consider the application filed by the petitioner, my lord. That was allowed.
You filed an appeal, is it?
No, my lord.
Against the order of the AC?
My lord, we have filed a appeal, my lord, before the deputy commissioner, my lord. That application came to be rejected, my lord. Thereafter, my lord, the petitioner has filed a writ petition before this honorable court, my lord. This honorable court has given a direction, my lord, to consider that application, my lord. My lord, page number 78, my lord, kindly see the page number 78, my lord. Page number 81, my lord.
The proceedings are still pending before the DC.
Please, madam. Kindly see the page number 81 for a moment, my lord.
No, the final matter is disposed of, isn't it?
The appeal is disposed, my lord.
Disposed of the
Disposed
appeal.
of, my lord.
That you have challenged.
Please, my lord.
In light of the contention that the grantees have approached the authority of undue delay, matter requires consideration and there would be stay of the order at annexure
U,
my
P and
lord.
N.
U,
P and N.
annexure U,
P,
P and N.
N.
AG accepts notice respondents 1 to 4. Emergent notice to 5 and 6. Yes.
Not permit me to handle every minute.
Yes.
Sir. That will.
Serial number 3, Narendra Babu.
Please, madam, for the petitioner, the PTCL matter, petitioner of the purchasers, please, madam. Grant in the year 1939. First sale, there are two portions sold, please, madam. One first portion 1987 and another portion 1992, please, madam.
Proceedings are initiated.
Madam, 2012, please, madam. Madam, Assistant Commissioner passed the order on 24/10/2025, please, madam. Sorry, please, madam. 5/3/2026. I'm sorry, please, madam. Annexures D, page number 57, please, madam. Madam, immediately thereafter, mutation have been, revenue entries have been mutated in the name of respondents, please, madam. The original grantee. Annexure E and E1 and E2, please, madam.
When is the order of the AC?
AC, please,
AC
madam.
has passed the order, my lord. Deputy Commissioner is
3/3/2026.
now to consider the application for stay. That is not being considered, is what is prayer is, my lord. And annexure G1 and G2. Some direction be given, my lord, we'll consider the prayer.
E1 and E2 are the mutation. Immediately thereafter, my lord, despite of the direction, coordinate bench of this honorable court issued direction to Assistant Commissioner and Deputy Commissioner. My lord, kindly see page number 74, please, my lord. Through Principal Secretary, ಯಾವ್ದನ್ನು ನೀವು Assistant Commissioner ಆದ್ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದ ತಕ್ಷಣ ಮುಟೇಷನ್ ಚೇಂಜ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. 74, please, my lord. Despite of such, immediately after the order of Assistant Commissioner, they'll mutate the name of illegal heirs, please, my lord, original grantees.
My lord, this is automated. Brought it to the notice of the Principal Secretary, my lord. We'll trying to change this.
But this order was communicated on 23/1/2026. Now AC passed the order on 3/3/2026. Immediately changed the mutation on 4/3/2026, please, my lord. But now the respondents, lots of grantees, but from day to day in day out, they come to suit scheduled property. They'll try to dispose as, please, my lord. Hence, I before the Honorable Court.
Now your appeal is pending.
Please, my lord, appeal is pending. Not even considered. Appeal is in annexure G1 and G2, G3, please, my lord. I filed appeal through online e-filing, please, my
Page
lord.
64.
And your IA for
IA is in G3, please, my lord, page number 72. It is in pending, please, my lord, not considered by the Deputy Commissioner. Direction ಅವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಅವ್ರಿಗೂ ಕೇಸ್ ತಗೊಂಡು ಬೇಗ ಎಂಟ್ರಿ ಮಾಡ್ರನ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ ಅಂತ.
your case.
Please, in connected case, please, in other case by the Honorable Court.
Now what is the interim relief you want now?
Stay of order of Assistant Commissioner as well as mutation entries, please, my lord.
Will be granted for a period of 10 days, my lord, till the Deputy Commissioner decides on the application on merits.
We will dispose it of.
Please.
Please, my lord.
The petitioner has received the order of the Deputy Commissioner passed under section 5A of the PTCL Act and has also sought for consideration of interlocutory application for stay filed in the appeal proceedings. petitioner submits that you are the purchaser, is it?
I am the purchaser, please, my lord.
Petitioner submits that he is the purchaser of a land which is alleged to be granted land. It's further submitted that application seeking restoration of land sold in violation of the PTCL Act came to be filed in the year 2012, which was allowed by the Assistant Commissioner by order dated 3/3/2026. By virtue of the order of the Assistant Commissioner, there was a direction for resumption of land. Further submitted that immediately thereafter, revenue entries have been changed in the name of the grantees. Next, petitioner submits that an appeal has been preferred before the Deputy Commissioner. On which date this is?
My lord, on 5/3/2025, please, my lord.
On 5/3/2026.
Please, my lord, 26.
Within the period of limitation. Until date, the appeal has not been taken on,
Please,
has not been taken up for consideration.
no, please, my lord.
And the request of the petitioner for stay of the order of the AC has not been considered.
Please, my
Full stop. G3.
please, my lord.
The
G3,
petitioner
annexure
submits
G3.
that the appeal memo is at annexure G1 and the application for stay is at annexure G3. Next, submitted that in light of revenue entries already having been transferred in the name of the grantees, even while the appeal of the petitioner is pending consideration before the appellate authority, there is an apprehension of being dispossessed. Next. Taking note of the limited prayer being made, namely of consideration of application filed seeking stay of the order of AC in the pending appeal, comma, petition itself could be disposed of. Next. The Deputy Commissioner, respondent number 2, to take immediate steps to commence the proceedings in appeal filed before the Deputy Commissioner in terms of the memorandum of appeal at annexure G1. Next. Necessary orders to be passed on the interlocutory application filed seeking interim relief as is evidenced by the application at annexure G3. Next, till such request of the petitioner for interim relief is considered, there would be stay of the order of the Assistant Commissioner at annexure
D, please, my lord.
D, and proceedings pursuant thereto till the DC passes appropriate orders regarding the request of the petitioner for stay. Next. All contentions are kept open. Notice is waived to the private parties in light of the relief granted by the court is only transitionary till the Deputy Commissioner passes an order on the pending interlocutory application. All contentions are kept open.
Obliged.
He accepts notice for the respondent's number. 1, 2, 4.
4, Manjunath.
For the petitioner, madam. Petitioner is a owner in the agricultural land, madam. He is in possession and personally cultivating the survey number 1/1 and 159 of 3 bar of the Kablikate village, Kudligade Hobbli, Bhadrati Taluk, Milad. In the month of December, Milad, on the 18th, Milad, the 9th respondent, the Commissioner, Bhadrati Municipal Council, has, along with his subordinate, and with the JCB, Milad, he entered in the land of the petitioner and in order to construct some construction, Milad. And the act of the commission has been resisted. The next day also, Milad, has come with the JCB. Then having no alternative.
Local bodies dispute. Local bodies matter.
No, local bodies, Milad. On the basis of the annexure L,
Bhadravati Town Municipal Corporation, Lord, is saying that they're interfering.
On the basis of annexure
Respondent number 16. Local bodies issue.
Even after service of summons, Milad, the immediately without issuing a notice.
No, just one. Who has taken action?
Respondent 9, Milad.
Correct. Then
Yes.
how I can entertain the.
No, Milad, this is on the basis of the handing over the certificate, Milad, by the village accountant, that is the village administrative officer. Annexure L may kindly be seen, Milad. Annexure L, page number 56. ಹಸ್ತಾಂತರ ದೃಢೀಕರಣ ಪತ್ರ ಭದ್ರಾವತಿ ತಾಲೂಕು ಕೂಡ್ಲಿಗೆರೆ ಹೋಬಳಿ
ನಗರಸಭೆ
ಕಬ್ಲಿಕಟ್ಟೆ
ಭದ್ರಾವತಿ
ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ನಲ್ಲಿರುವ ಗ್ರಾಮಠಣ ಒತ್ತುವರಿ ತೆರವುಗೊಳಿಸಿ ನಗರಸಭೆ ಸುಪರ್ದಿಗೆ ಕುರಿತು ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ತಾಲೂಕು ಇವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಣಸೋ ಭದ್ರಾವತಿ ತಾಲೂಕು ಕಬ್ಲಿಕಟ್ಟೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ ಸೋಣಸೋ ಗ್ರಾಮ ಠಾಣ ವಿಸ್ತೀರ್ಣವು ಪಾಣಿಯಂತೆ 3 ಎಕರೆ 35 ಗುಂಟೆ ಇರುತ್ತದೆ. ಸರ್ವೇರ್ ಪ್ರಕಾರಂತೆ ಕ್ರಮವಾಗಿ ಸರ್ವೆ ನಂಬರ್ 1/1 ಹಿಡುವಳಿದಾರರು ವರದಿಗಾರರ ಮೋಜಣಿದಾರರ ವರದಿಯಂತೆ ಸೋಣಸ ಪ್ರದೇಶವನ್ನು ಒತ್ತುವರಿ ಮಾಡಿರುವುದು ತಿಳಿದು ಬಂದಿದ್ದು, ಈ ಸಂಬಂಧ ಉಲ್ಲೇಖಿತ ಆದೇಶದ ಮೇರೆಗೆ ದಿನಾಂಕ 2/1/26ರಂದು ಗ್ರಾಮ ಠಾಣಾ ಒತ್ತುವರಿಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಜೆಸಿಬಿ ಯಂತ್ರದಿಂದ ಟ್ರಂಚ್ ಹೊಡಿಸುವ ಮೂಲಕ ಗಡಿ ಗುರುತಿಸಿ ವಶಕ್ಕೆ ಪಡೆಯಲಾಗುತ್ತೆ ಹಾಗೂ ಪ್ರಸ್ತುತ ಗ್ರಾಮ ಠಾಣಾ ಒತ್ತುವರಿ ಮುಕ್ತವಾಗಿದ್ದು ರಕ್ಷಣೆ ಮತ್ತು ಅಭಿವೃದ್ಧಿ ದೃಷ್ಟಿಯಿಂದ ಸ್ಥಳೀಯ ನಗರ ಸಭೆಗೆ ಸುಪರ್ದಿಗೆ ವಹಿಸಲಾಗಿದೆ. This is handing over by the village administrative officer, Milad.
This is again by.
As per the direction of the Tahsildar.
No, the
Nagarasabhe Bhadravati.
action is by whom?
By the direction of the Tahsildar, the village administrative officer issued this handing over the certificate in favor of the 9th respondent. On the basis of this handing over the certificate, Milad, he has commenced the construction. I have filed the suit against him. There is a temporary injunction. In spite of temporary injunction, Milad.
We are only on the roster.
Yes.
How does it come before this roster?
No, this is the order passed by the revenue authorities, Milad.
No.
Yes, Milad.
Order passed by the Nagarasabhe.
No. Kindly say handing over certificate. That is ಅಂತರಗಂಗೆ ಮೂರನೇತ ಇದ್ರು ಗ್ರಾಮ ಆಡಳಿತ ಅಧಿಕಾರಿ ಅಂತರಗಂಗೆ ಮೂರನೇ ವೃತ್ತ ಭದ್ರಾವತಿ ತಾಲೂಕು. That is as per the orders of the Tahsildar, Milad. ವಿಷಯದ ಉಲ್ಲೇಖದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಮಾನ್ಯ ತಹಸೀಲ್ದಾರ್ ಭದ್ರಾವತಿ ತಾಲೂಕು ಇವರ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋಣಸೋ ದಿನಾಂಕ 30/12/2025. On the basis of this order, Milad, the handing over certificate is issued by the village accountant. These are the created documents, Milad. After filing the suit, after serving the summons and notice on the respondents, Milad.
What has happened in the suit?
Well, in the suit, Milad, there is injunction order granted in favor of me.
Injunction.
In spite of that, Milad, he has started construction. I have produced annexure G, S and S1, Milad.
Where is the injunction order?
Injunction order, Milad. Annexure R, Milad, page number 61. And the findings of the trial court, Milad, is page number 73, Milad. They have not produced any piece of paper, Milad, to showing that this is a grammatana. May I read, Milad? Page number 73.
The operative portion.
Operative portion, Milad. Page number 80, Milad. IA number 2, 5 with the plaintiff under the order so and so is allowed Consequently, the defendants, their when agents, servants, etc., are temporarily restrained from the interfering with the position of the plaintiff in the suit property, either by trespassing or by trying to make any kind of construction towards the northern side of the or in any other manner till pending disposal of the suit. Is also filed a IA tree number by the commission, my lord. Is IA is rejected. Dismissed. Is take construction, my lord, is on the basis of Unsecured. He has filed objection to my IS, my lord, stating that as per the direction of the Tahsildar, the surveyor has come to the place and he surveyed the animal. I also produced the report, my lord. Kindly see the report was also dated subsequently summoning the in the suit, my lord. There is no Gramatana land in available in survey number 101, my lord. Survey sketch within the taken place only 2-3 days, my lord, after serving the summons.
Let us see. The petitioner submits that suit for injunction was filed against the City Municipal Council Bhadravati and other private parties seeking for an order of suit for
a permanent injunction, my lord. I have also
for
produced the plaintiff and as well as IN.
order of permanent injunction against the defendants. Submitted that the application filed by the municipal authority came to be rejected, while application filed under order 39 rule 1 and 2 by the petitioners came to be allowed, restraining the defendants from trespassing or making any construction. It's further submitted that despite such order of injunction, the respondent
9
authorities pursuant to proceedings by the Tahsildar have attempted to dispossess the petition.
Disposal, take on some construction, my lord, as per annex yes and yes and my lord.
Have
They put up some construction.
started to interfere with possession by putting up construction, by trespassing into the property which is the subject matter of proceedings before the civil court.
On the basis only annex real, my lord, that is handing over certificate issued by the village accountant.
Same. The respondent number 9. Respondent number 9.
9, my lord.
Is restrained from continuing with construction till the next date. AG accepts notice for respondents 1 to 5.
1 to 8, my lord.
1 to
1 to 8.
1 to 8. Emergent notice to respondents 9 to 18. Petitioners at liberty to serve final counsel if any for respondent number 9. Interim order to be in operation till the next date. Relist the matter.
My lord, I'll have to take notice, my lord, for 10. Or these are private respondents. Sorry.
Private, notice has to go private listen.
Relist next week. Interim order will be in operation till the next day. Yes.
Serial number 5, Kiran B.
And before this court questioning the annexure J and L, my lord, L and J. The first sale is the year of 2000, my lord. After lapse of 24 years, he has filed the restoration application in the year 2024. That came to be disposed on 9/9/2025, my lord, at annexure J, my lord, page number 77. Immediately, my lord, on 23/9, 2025, I filed appeal before the Deputy Commissioner. Annexure K. So Annexure L, my lord, came to be passed on 16/2/2025, 26. During the pendency of appeal, my lord, kindly take page number 68, my lord. The revenue entries have been changed in the name of the original grantee, my lord. Pendency of appeal. And page number 88, my lord, at the bottom of the order, the respondent number 2 has stated that bottom of the order, madam, page number 88.
So that we'll consider. Now what you are seeking now, stay of the order that DC.
Yes, my lord.
J and K, my lord.
J and L.
J and K.
J and L.
Concurrent findings.
Concurrent findings.
The petitioner. Has received the order of the Assistant Commissioner and Deputy Commissioner. Dictating that proceedings for restoration have been initiated in the year 2024, whereas the first sale was
2000, my lord.
Whereas the first sale
26/2000.
was in the year was on 20th June 2000 after undue delay. It submitted that the exercise of power after an unreasonable period of time is impermissible. Light of the said contention raised, matter requires consideration in the interim. We stay of order as annexure J and L till the next date. Respondents are at liberty to seek for modification of the interim order upon appearance and filing pleadings. AGA accepts notice for respondents 1 to 4. Emergent notice to the 5th respondent.
6, Hyderabad.
Let this is PTCL matter. Petitioner or purchasers, please, Lord. First sale in the year 1991, please, Lord. They filed application for restoration on 2022 before Assistant Commissioner. Lord, order passed by the Assistant Commissioner on 24/10/2025, please, Lord. Lord, immediately on 3/12/2025, I filed appeal before Deputy Commissioner, please, Lord. Lord, as on this day, the same was now, it's been 3 months, please, my lord. Even not even numbered, please, my lord. ನಾನು ಅದ್ರ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ಎಷ್ಟು ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ. ಇಟ್ ಇಸ್ ಇನ್ annexure H, page number 54. There are about 150 matters are pending without even assigning number, please, my lord.
What are you
seeking to consider my application for stay, please, my lord, annexure E, the order of Assistant Commissioner, please, my lord. Seek.
The coordinate bench is disposing of in such matters or keeping it pending?
Circular issued by the principal secretary.
No, correct. I'm saying the coordinate bench
Is disposing of similarly.
disposing of.
Without direction,
Direction is given.
ಡೈರೆಕ್ಷನ್ ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಗೆ ಕೊಟ್ರೆ ಅಲ್ಲಿ 150 ಮ್ಯಾಟರ್ಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಮತ್ತೆ ಇಲ್ಲಿಗೆ ಬರೋದು ತಪ್ಪುತ್ತೆ. ಬರೀ ಎಂಟ್ರಿ ಮಾಡರ್ ಕನ್ಸಿಡರೇಷನ್ಗೆ ದೇ ಆರ್ ನಾಟ್ ಇವನ್ ಟೇಕಿಂಗ್ ದ ಮ್ಯಾಟರ್ಸ್. 150 ಮ್ಯಾಟರ್ಸ್ ಆರ್ ಪೆಂಡಿಂಗ್. ಡಿಸೆಂಬರ್ ಇಂದ ಇಲ್ಲಿವರೆಗೂ ನಂಬರೇ ಮಾಡಿಲ್ಲ ಕೇಸ್ಗಳದ್ದು.
ತುಮಕೂರು,
ಪ್ಲೀಸ್ ಮಲಟ್, ತುಮಕೂರು ಡೆಪ್ಟಿ ಕಮಿಷನರ್.
Directed to give a status report, my lord, next week.
We will keep it pending.
Fix a date.
Keep it pending.
Please.
The
Can be
petitioner
directed to serve a copy also.
AG is directed to accept notice for response 1 to 4. Emergent notice to the private respondent. The petitioner submits that the first sale was in the year 1991 and the grantees have sought for restoration with undue delay of about 31 years in the year 2022. However, it is submitted that the Assistant Commissioner has allowed the application seeking cancellation of the sale deed and restoration of grant, and the same has been grant. Full stop. It's further submitted that despite appeal filed on 3/12/2025 before the Deputy Commissioner, till date the appeal has not been taken up for consideration and no orders are passed on the application for stay. In light of the contentions raised, there will be the order of the Assistant Commissioner at Annexure
E, please.
at Annexure E would be stayed till the next date. While clarifying that such order would not come in the way of the Deputy Commissioner taking up the appeal and proceeding with consideration of interlocutory application. Learned counsel for the petitioner would submit that as on date
Annexure P.
in terms of Annexure H.
Please, Malad.
You?
Huh?
Please, Malad.
Annexure H.
ಹೌದು ಅಲ್ಲಿ awaiting ಅಂತ ಇದೆ, ಅಲ್ಲಿಂದ ಯಾವ್ದು ನಂಬರ್ ಮಾಡಿಲ್ಲ.
Concurrent.
77 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ.
Further submitted by learned counsel for the petitioner that there are more than 100 appeals pending before the Deputy Commissioner which have not been numbered and no dates are assigned. In light of such assertion, AGA to obtain necessary instructions and the Deputy Commissioner to furnish status report as to number of appeals filed and not numbered, comma, number of appeals in which interlocutory application filed and has not been considered, and the status report regarding matters filed over the past 3 months. Relist the matter on copy of the order to be communicated to the Deputy Commissioner.
26th. 26th.
6th of April.
Yes.
Hand delivery, please. Hand delivery. Macho please.
Petitioner ಬಗ್ಗೆ. Not the petitioner is mother's side. As first is land Malad and annexures A, the year 74-75.
What is the urgency now?
Urgent notice all rather sir. Urgency. I am not seeking any interim prayer.
This before regular bench.
ಅಲ್ಲಲ್ಲ ಏನಾಗಿದೆ?
You shouldn't move like this.
ಅಲ್ಲಲ್ಲ ಅಲ್ಲಿ ಮೂವ್ ಆಗಿತ್ತು because of the bench is not sitting.
No, you shouldn't move like that for 2:30.
No, it's not 2:30 matter. No, ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದು ಅಲ್ಲಿ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ
These matters you shouldn't move before the in charge bench, only emergency matters. Yes.
ನೆನ್ನೆ ಇಲ್ಲಿ ಮೂವ್ ಮಾಡಿದ್ರಂತೆ.
Only emergency matters.
ಅಲ್ಲಲ್ಲ ಡೇಟ್ ಹಾಕ್ಬಿಡಿ ಸ್ವಾಮಿ ಹೋಗಿ.
I am not going to give. There are 100 people who are waiting. I refuse to take any memo. Uniformity in my approach. Yes.
So they filed a petition seeking next list. Discuss two. The past one. Second matter.
Serial number 2.
Okay. That serial number 2 is passed.
Yes.
My lords, if I could make a mention. I could make a mention, my lords. The order and challenge, my lords, they have already preferred an appeal before the Assistant Commissioner, that is respond number 2, my lords. The matter is pending consideration before him. If you were to see, my lords, the timeline of filing, the appeal, my lords, was, the order, impugned order, my lords, was passed on 3/3/2026. Appeal came to be filed, my lords, on 9/3/2026.
The annexure A is the
impugned order, my lords.
by the special Tahsildar.
By the Tahsildar, my lords. R3, my lords.
Now this is for.
It is in respect of, my lords, RRT dispute, my lords.
Now this has been taken in appeal by.
by the petitioners here in my lords in RA 47 of 2026. Which appeal, my lords, was filed on 9/3/2026, my lords. 5/3, is it? 5/3/2026.
May I submit?
Yes, my lords, writ petition.
No, let me argue. You can reply. My lord, the property belonged to one
No,
Girish.
what is the urgency? What is the urgency?
No, urgency is, my lord, the RTC entries are changed on the basis of a will.
No, the reason I'm asking is any urgency, I'll take
No,
it.
urgency
Otherwise,
is there, my
regular
lord,
bench.
because once the name is entered, they will sell the property. Now, I have made an appeal before the Assistant Commissioner. Assistant Commissioner is not taking up the matter. From the past 15 days, we are trying to move. There is no sitting by the Assistant Commissioner. Now, matter is covered by a full bench judgment that on the basis of the will, no entry can be changed. But the Assistant Commissioner should at least consider. Otherwise, in the meanwhile, he is a person, my lord, he is not a family member. He claims to be only on the basis of the will.
Now you are the fourth respondent.
My lords, I am the fourth respondent, my lords. There is a will which is executed.
Okay, I'm not on merit, sir. Now what I'm saying is the appeal is filed before the Assistant Commissioner.
On 5th of March.
Now,
My lords, my humble submission, my lords, if I could
just 1 minute. What I'm suggesting, without entering into the contentions,
Yes,
appeal is filed before the Assistant Commissioner.
Yes,
Now till the Assistant Commissioner considers their application for stay,
Yes, my lords.
you don't create any third party rights.
My lords, the writ of mandamus, I have no objections at all, my lords. The relief sought for, my lords, is a writ of certiorari seeking reversal of the orders, my lords. A writ of mandamus can be given, my lords. Till then, I undertake not to alienate the property. I mean,
Lord,
status
here-
quo might be passed, my lords.
Lord, here, let the entry continue in the name of the deceased member.
No,
How,
that-
no,
my
one
lords,
second, 1 second. How, Lord, an entry can be changed on the basis of the will contrary to the full bench judgment of this honorable court?
Correct. Now that is a matter before. in
Correct,
appeal.
but what I would suggest is, Lord, entry is in the name of deceased Girish. Let it continue in his name, subject to what the Assistant Commissioner will decide.
No, let the Assistant Commissioner pass an order. Till then, I'll direct status quo as on date and not to create third party rights and dispose it off.
Much obliged.
The rest of it, you work it out in the appeal proceeding.
Much obliged.
ಅದಕ್ಕೆ ಅವ್ರು ಸೇಲ್ ಮಾಡ್ಬಿಡಿ ಅಂತ ಹೇಳ್ತಾರೆ. No, it appears, my lord, that he have already created third party rights on the basis of this. Unless he says that he has not created anything on the basis of this.
That's the very reason, my lords, we were to see.
Ah.
In fact, my lords, they have not included, my lords, the subsequent purchase.
Correct, he has already sold the property. Where is the question of
They
undertaking?
have objected, my lords. What they've made is they've made an
He is
entry
misleading
into
the
the
court.
RTC, my lords, with regard to the suit which is filed against a third party, so that the entry, my lords, the J slip has already been generated upon the basis of the alienation. Since the J slip, my lords, must not be enforced, they see to that, my lords, an entry is made as with regard to an OS proceedings pertaining to a third person, my lords.
He is an
But
undertaking.
let there be a status quo, my lords. I have no
Undertaking.
objections, my lords, with
He is
regard to the same.
undertaking
Let
before the court that he will not alienate after selling the property.
My
How
lords, they
can he
don't
make
even
that
make a party.
statement?
No, correct. Now, for the time being, what is the interim relief you want?
Lord, let this order, Lord, kindly see the order, my lord, for one moment.
No, correct. That the Assistant
Kindly
Commissioner.
see page 19.
No,
That
that-
order, my lord, this entry should be stayed till he decides the matter. Kindly see page 19. Last para. It starts from 18, page 19, last para. ಸದರಿ ನೋಂದಣಿ ಪತ್ರದ ಸಂಖ್ಯೆ ದಿನಾಂಕ 12/9/2002 ಪುಸ್ತಕದ ಮರಣ ಶಾಸನ ಪತ್ರವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಪ್ರಕರಣದ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳಿಬ್ಬರು ಹಾಲಿ ಖಾತೆದಾರರಾದ ಎಸ್.ಸಿ. ಗಿರೀಶ್ ರವರ ವಾರಸುದಾರರಾಗಿ ಕಂಡುಬರುತ್ತದೆ. ಆದರೆ ಸದರಿ ವಿಲ್ ಮರಣ ಶಾಸನ ಪತ್ರದಲ್ಲಿ ಸದರಿ ಸ್ವತ್ತು ಚಂದ್ರಶೇಖರ್ ಬಿಜಿ ಅವರಿಗೆ ವಿಲ್ ಪತ್ರವಾಗಿರುವುದು ಕಂಡುಬರುತ್ತದೆ. ಆದ್ದರಿಂದ ಪ್ರತಿವಾದಿಗಳು ತಮ್ಮ ಹಕ್ಕಿನ ಬಗ್ಗೆ ಸಕ್ರಮ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಪ್ರತಿಪಾದಿಸಬಹುದಾಗಿರುತ್ತೆ ಎಂಬುದು ಭಾವಿಸಿ ಸದರಿ ಜಮೀನಿನ ವಿಚಾರದ ಬಗ್ಗೆ ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಬಾಕಿ ಇರುವಂತಹ ಪ್ರಕರಣಗಳ ಅಂತಿಮ ಆದೇಶಕ್ಕೆ ಒಳಪಡಿಸಿ ಸದರಿ ಜಮೀನಲ್ಲಿ ಇತರಿಗೆ ಇರುವ ಹಕ್ಕನ್ನು ಕಾಯ್ದಿರಿಸಿ ಸದರಿ ಆದೇಶವನ್ನು ಸುಳ್ಳು ದಾಖಲೆಗಳು ಸಲ್ಲಿಸಿ ಪಡೆದಲ್ಲಿ ಆದೇಶವು ತಂತಾನುವೇ ರದ್ದಾಗುವಂತ ಷರತ್ತಿಗೆ ಒಳಪಟ್ಟು ಆದೇಶಿಸಿದೆ. ಮಂಗಳೂರು, ಬೆಂಗಳೂರು ಸೋನ್ಸೋ ವಾದಿಗಳಾದ ಚಂದ್ರಶೇಖರ್ ಅವರ ಹೆಸರಿಗೆ this is his name is entered on the basis of the will.
It has been sold to.
Kindly see
My
page
lords, it's been sold to Prashant, my lords.
page 20, my lord.
It's been sold
Just
to
1 minute. Just it has been sold to.
one Mr. Prashant, my lords.
When was that?
My lords, on 5-3, my lords.
On?
ಎರಡು ದಿನ
5-3.
ಆಗಿಲ್ಲ. ಥರ್ಡ್ ಆರ್ಡರ್ ಆಗಿದೆ. ಫಿಫ್ತ್ they go and sell the property.
My lords, if you were to see, my lords, on the 9th, there is an entry, my lords, in the RTC, which, my lords, the petitioners have made upon the basis of an OS, my lords, which is pending. So that, my lords, the J slip generated automatically shall not be enforced. So it is not the case, my lords, the petitioners are not aware of the alienation. They are very much aware of the alienation.
aware.
In spite of that, my lords, they don't array the purchaser as party to the proceedings. The
Kindly
conduct
see-
might be also looked into from that
Full
aspect. my
bench
lords.
judgment, my lord, the issue is covered. On the basis of the will, no entry can be made, my
humble
lord.
submission.
Kindly see the judgment which I have just now produced.
Oh, just 1 minute. Now, has revenue entry been transferred in the?
My lords, it is transferred into my name, my lords. I have sold the property. J slip has been generated, my lords, because of the entry of an OS pertaining to a third person, my lords. The J slip is not been enforced. If not, my lords, automatically, my lords, the J slip, the transfer takes place within 45 days. My humble submission before this honorable court was, my lords. Now, my lords, proceedings is pending before the AC. Let him consider, my lords, and
No,
let
no,
him
the
pass an order
question
to that
is,
effect. Till then, my lords,
The
let
way
the-
in which, my lord, cases have gone, what is my
Even in
remedy,
the
my
impugned
lord?
order, my lords, for that
Order is
matter-
passed on third, and he goes and sells the property on fifth itself. On the basis of the will, it is done, which is directly contrary to the full bench judgment of this honorable.
Correct. Now we'll say status quo regarding revenue entries. No further third party rights to be created.
ಇವ್ರು ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಬಿಟ್ಟು ಈಗ ಮತ್ ಫರ್ದರ್ ಸೇಲ್ ಮಾಡೋದಿಲ್ಲ ಅಂದ್ರೆ ಲೆಟ್ ದಿಸ್ ಎಂಟ್ರಿ ಬಿ ಸ್ಟೇಟ್ ಬಲಾಟ್ ಮ್ಯಾಟರ್ ಇಸ್ ಗಿರೀಶ್ ಲೆಟ್ ದಿ ಎಂಟ್ರಿ ಕಂಟಿನ್ಯೂ ಇನ್ ದ ನೇಮ್ ಆಫ್ ದಿ ಡಿಸೀಸ್ ಪರ್ಸನ್.
No, let it be heard before the regular bench. I'll have it on.
But
Monday.
what should happen to a person, my lord, who is affected? Now, he passes an order on third. Fifth, they go and transfer. On the immediately I file an appeal. There is no person who will take up our matter. And they take advantage and they sell the property. And they are making a statement before this court that they will not sell it. He has already sold it. He does not disclose until we bring it to the notice of the court. It's a clear case, my lord, that he does not even, how did he undertake, my lord, that he will not sell the property after selling it? Now, that party, my lord, is not before the court, he will further sell the property. That is why, my lord, this entry should be stayed. Let the assistant commissioner decide the matter. Let the assistant commissioner decide the matter. Matter is not as if, my lord, there is no question of dispute on any issue.
My lords, stay in respect of
Kindly
the order
see-
itself to that extent. Till when the matter is decided by the assistant commissioner.
Petitioner has challenged the order of this Tahsildar at Annexure A by way of appeal before the assistant commissioner. It is submitted that though the appeal before the assistant commissioner was filed on
Filed on 5/3, 5th of March.
5th of March.
Questioning the order dated 3rd of March.
Till date, the said appeal has not been taken up for consideration, nor the request for interim prayer, nor any orders passed on the interim prayer sought for in the appeal. Full stop. In the interregnum, it is made out from the submission of counsel for the respondent that the private respondent in whose favor entries were effected subsequent to the order of the special Tahsildar has sold the property to another private party. Full stop. In light of the submission that the assistant commissioner has failed to take on record the appeal and consider request for interim prayer, there would be stay of the order at Annexure
Annexure A.
A and the revenue entry effected pursuant to the order at Annexure A. The purchaser from the fourth respondent, details of whom is furnished by way of a memo to be impleaded as an additional respondent. Necessary amendment to be carried out to such necessary amendment to be carried out. Emergent notice to the newly added respondent. AGA accepts notice for response 1 to 3. So and so appears on caveat for the fourth respondent.
My lords, humble submission, my lords. In fact, my lords, the matter can be disposed of, my lords, granting liberty, my lords, for the parties to.
Let us see, let the other person
Writ of
come.
mandamus.
No, let the other person come. We have passed some adverse order. Now you say he has sold.
No, my lords, my humble submission is, my lords, what has been sought as writ of certiorari without, my lord, surpassing the appellate provisions.
So that cannot be done.
That cannot be done, my lord.
No,
So
we-
let there be a writ of mandamus, my lord, directing the AC to dispose of the case itself.
I can't, without hearing the other side, no such order can be passed.
Lord,
We'll list the
impleading
matter.
applicant shall not further sell, my lord. That impleading
We have
will.
state, no, we have stated. We have stated that order, the revenue entries.
It states.
If we give
This the matter
details of the.
next week. You give the details in the memo.
I will.
Next.
Stay agta, ಅವ್ರ ಹೆಸರಿಗೆ ಹಾಕಿ.
Court matter,
We'll upload it.
court matter, Sachin PS. Sachin PS.
Agency's eviction through police protection passed by the Tahsildar. Notes, violation of principles of natural justice. Implement order indicates that he has issued show cause notice and had not given a reply, which is factually incorrect, my lords. For show cause notice, reply is submitted. But show cause notice, my lords, who find it at annexure D, page 26, and reply is submitted to page number 28. And what the allegation is, a Karab land. Notes, it's a cultivable land, my lords. Enquiry has to be done. It says that, my lords, there is an inquiry report which copy is not furnished to me.
No. What is the notice?
My lords, notice says that, my lords, I encroach the Karab land, B Karab land.
Notice is dated when?
My lords, it is
Yes,
on
sir.
17/2/2026.
What is annexure D?
My lords, annexure D,
You give a copy to the government advocate.
material. I'll furnish one more copy. ಮುಂಚೆ ನೋಟಿಸ್ ಕೊಟ್ರು annexure D ಪ್ರಕಾರ.
Now what happened after that?
annexure E ಪ್ರಕಾರ ಆ ನೋಟಿಸ್ ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀನಿ. annexure A ಪ್ರಕಾರ ಈಗ ನೋಟಿಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ರಿಪ್ಲೈ ನೀವು ನೋಟಿಸ್ ಕೊಟ್ಟರು ಕೂಡ ರಿಪ್ಲೈ ಕೊಡ್ಲಿಲ್ಲ. ಆದ ಕಾರಣ ಆರ್ಡರ್ ಬರೀತಾ ಇದ್ದೇನೆ ಅಂತ ಬರೆದಿದ್ದಾರೆ. annexure A page 18 second paragraph. ಸಮಜಾಯಿಷಿಯು ಸಹ ನೀಡಿರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಮಾಪಕರು ನೀಡಿರುವ ಒತ್ತುವರಿ ನಕ್ಷೆಯಂತೆ ಒತ್ತುವರಿಯನ್ನು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ.
I'll pass over, you just find out.
Yes.
There's some lake there. See. Pass over.
Great, perfect. ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಟ್ಟು. ಇನ್ನೊಂದು ಕಾಪಿ.
Serial number 2, Karumbai TA.
Well, annexure H at page number 62 is the eviction notice. The Lordship directed me to take out notice to Mr. Krishna. He has not come to the court and Arudan Meister, Girish.
I want to take instructions.
But at annexure H is the eviction notice, my lord. At page number 62. But page number 62, my lord. It is a general notice, my lord. It is not individual notice. And thereby the fourth respondent has directed the unauthorized occupants to vacate from the encroachment, and to failing which within 7 days from the date of the receipt of the notice, it was not served on my lord, and it was affixed in the building. So from the date of 7 days, my your lordship may kindly see, my lord, the predecessor of these petitioners.
No, we'll have it tomorrow, you find out. Tomorrow morning I'll have it. By then you find out what is this. You get your preliminary instruction, so far as the interim relief.
They have the houses, my lord.
Huh?
They have the houses residing in the land, my lord. I have produced the photographs. And also in the neighboring land, there was a demolition also, annexure J1 and J2, page number 63, my lord.
No, but what is this now? BDA land?
BDA, no, it was proposed for acquisition, my lord. The predecessor of these petitioners have filed a writ petition. Your lordship may kindly see annexure A and page number 21, my lord.
No, but let him find out. We'll have it tomorrow.
Please.
Land council. See, Girish.
NR Girish.
NR Girish.
NR Girish. Accepts notice for the respondents. 2 to 4. AG accepts notice for the first respondent. Relist the matter in the fresh matters list tomorrow.
There are 4 similar matters, my lord.
Same order in 4, 5 and 6. You must find out.
Yes.
What is this? No, but is it acquired land?
No, it was acquired, but it was a built-up area, my lord, and this honorable court has given observation in the proceedings, my lord. The built-up area should not be acquired, And we have the building at the, before the acquisition proceedings was initiated. Our land was acquired and in which our houses were situated, my lord. And this honorable court has also given liberty to the petitioners and also directed the BDA not to acquire the land where it is fully developed. My lord.
No, correct. Which year this notification?
Notification 2003. We have filed the writ petition, my lord, in the year 2004. It was disposed on 17 to 2006, wherein this honorable court has observed. And our challenge was also that, my lord, 20 gunta, only we are challenging about the 20 guntas.
Let's see, tomorrow.
Tomorrow.
You find out.
Please.
Yes, next.
Serial number 3, Vasudevan, action.
Petitioners, my lord. Challenge annexure A at page 25, which is a notice issued on this, meaning it was pasted on the outer premises of one of the houses, asking him to vacate the premises within 7 days. That was given on 13th. Even the notice also, my lord, at page 25 can be seen that there is no name mentioned. It's only the survey number that has been mentioned. But previously, my lord, these particular notifications were challenged. That was set aside. And thereafter, in the writ appeal, my lord, the notification of upheld. However, in the writ appeal, my lord, may I pass on the judgment of the writ appeal? There was a specific protection that has been granted. Last page may kindly be taken up, my lord.
They are the revenue site holders.
They are the revenue site holders. It has been specifically said, if my lords may come at para 69 order, so then at A, 3A, with regard to the landowners excluding.
Your subsequent purchases or
no, my lord.
Some
of them are subsequent purchases. Some of them are already approached this honorable court in the year 2011. They were directed to file their sale deeds along with the other documents before the BDA. And after this particular order in the writ appeal, my lord, certain notices were issued. My lords will find a notice at annexure G.
No, now.
Please, my lord.
You take a call. Now, either they are eligible in terms of the rules. Till then you make a list of how many people are there and you pass orders individually.
My lord, that particular direction was given in the writ appeal and everyone have filed their applications with the BDA with the nominal fee. That was taken in the year 2024. And thereafter, there was a notice also issued stating that all these applications have been received. That is also produced, my lord, at page number 485. They said that this has been placed before just Bopaya committee for consideration. That was on 2011-2025. All of a sudden, my lord, now this particular notice has been pasted and they are patrolling since yesterday.
Now that's pending before the committee.
That is a communication that has been sent. It is at page 485. May kindly be seen, my lord.
Annexure H series, my lord. They filed the application.
There is a series of applications that has been filed pursuant to the order of the writ appeal.
It's under process.
Second para, it clearly says. ಕ್ರಮ ಕೈಗೊಳ್ಳುವುದು ಎಂದು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿದೆ.
Now, no decision is yet taken.
Not.
And my lord, if I may draw my lord's attention.
Let us see. Then you hold your hands. That's all. Will you see?
And even my lord, just
so, but how do you issue notice now? When you yourself know it's pending before the committee, why all this exercise?
And writ appeal, my lord, court clearly said that till the aforesaid exercise undertaken by the BDA and applications filed by writ petitioners for allotment of states or for dropping of the lands from acquisition are considered, their possession shall not be disturbed and the existing construction shall not be demolished.
Now this annexure G.
Please, my lord.
You're saying similar to all.
Some of them have received, some of them have not received so far.
All of them have filed.
Out of there are 60 sites in this particular layout. 60 people have filed. 32 are before this court now.
The petitioners submit that pursuant to the observations made by the division bench in WA 1795 of 2014 and connected matters, the petitioners have sought for consideration of request for alternative sites.
Alternative sites, some of them sought to resume the same land.
Alternative
they have
sites,
given both the declarations.
Alternative sites and for retention of land by regularizing their occupation. It is submitted that the Bangalore Development Authority has referred all such applications to the Bopaya Committee for consideration. And despite no decision having been taken by the said committee, the notice at annexure A
Dated 13/2/2026.
has been issued.
Been pasted, my lord, actually on the
First
outer wall.
annexure, we peruse the notice at annexure J. In light of committee having been constituted, committee is to take a decision and orders communicated to the affected parties. Till such time, question of treating such persons as encroachers does not arise. Full stop. Such would be the position on noticing the observations made at paragraph at the operative portion in the writ appeal at para Roman 4. Roman 4. In light of the same, the respondent BDA abstained from taking any action pursuant to annexure A insofar as the petitioners are concerned till the next date. Grant Council Vasanta accepts notice for the respondents 2 to 4. AG accepts notice for the first respondent.
Lochana, serial number 31. Lochana S. Babu.
Because this is a GST matter, my lords, pertaining to financial year 18-19. The respondent has passed the impugned order disallowing my ITC, my lords, solely on the basis of difference between GSTR 2A and GSTR 3B, my lords. During the relevant financial year, there was no provision under section 16, which talks about eligibility of claiming ITC to reconcile with the GSTR 2A, my lords. If I may just have my lord's attention at section 16, my lords. Milords, section 16, subsection 2, subclause AA, Milords. It provides that the details of the invoice or debit note referred to in clause A has been furnished by the supplier in the statement of outward supplies, that is the supplier's GSTR1, and such details have been communicated to the recipient of such invoice or debit note in the manner specified under section 37. So they are reflected in my GSTR 2A, Milords. Milords, if you may just see the section 16, subsection 2, subclause AA has been inserted only with effect from 1st January 2022, Milords. The relevant period, financial year in my case, pertains to 2018-19, Milords.
Yes.
Further, Milords, the respondent has issued ASMT 10 and DRC 01A, where the amount that has been showed in my portal has been reproduced. But in the show cause notice, the amount is significantly reduced and does not match the amount which is showing on my portal, which was intimated by me through the reply to the show cause notice in my form GST DRC 06, Milords.
No, now the adjudication is still pending or?
Order is passed, Milords. They have disallowed my ITC, Milords, only on the basis of GSTR 2A 3B difference. Annexure A, page number 42, Milords, is the impugned order.
Did you participate in the proceeding?
Yes, Milords. I have participated. I have provided replies. I have provided reply to the show cause notice, telling them that the amount has been that the amount produced in the DRC 01A and the ASMT 10 is different from the impugned show cause notice, but they have ignored that submission and have proceeded to pass the impugned order, Milords.
Participated, their CA has appeared. They participated, they have filed the reply. There is appeal mechanism.
No, but then you may have to file an appeal now. If there's an error on
Section
merits.
107, they have to file appeal.
Milords, appeal is not effective in this case, Milords, because We have also intimated the respondent about a circular, my lords. It's produced at.
No, correct. All that he will direct him to take note of that circular and reconciliation and dispose it in accordance with law. Now you can't come rushing to the High Court.
My lords, the appellate authority does not have power to remand, my lords. That is why I'm in front of you, my lords.
Does not have power to
remand the matter back to the respondent, my lords.
Why not?
Section 107, subsection 11, my lords. If I may just read, my lords.
No, correct. But then the appellate authority has all the power as is available to the original authority. So let us see. You go there. Let us see. You work it out. If nothing happens, you can come here always.
No, my lords, he could not have invoked the proceedings wholly on the basis of GSTR 2A and 3B, my lords. That is the jurisdictional defect that he has caused.
What is the jurisdictional defect now? No, we can't say, entertain all writ petitions directly. The High Court will collapse. I'm not saying that you may not have a case. I'm not saying that. But I'm saying that you go there and then you come back. Jurisdictional issue is a different matter. But every matter we can't convert it into a and permit a writ to be filed. You go there, you work out your remedy, and then you come back. All contention will be kept open. It's a practical difficulty. It's not that we don't want to entertain it. It's a practical difficulty. We can't entertain every matter here by way of a writ.
My lord, if I may make one submission, my lord. The authority could not have issued the notice invoking section 16(2)AA when that section provision of law did not even exist in the disputed tax period. That is one, my lord. Section 107 subsection 11 says 16(2)AA. It is under this provision that matching of 2A 3B is sought for. The only basis on which the impugned order is passed in my case. He could not have issued notice basis this order when the provision itself did not exist in the disputed tax period. That is first, my lord. Secondly, my lord, to file appeal, my difficulty is 107 subsection 11. It says he cannot remand the matter. However, he can decide the matter. But my difficulty, my lord, I'll be put into financial trouble because to get this when he had no authority to issue a notice or pass the impugned order, basis this provision which did not exist, I have to go through 10% of financial loss. I have to pay that and then come back here.
That is not a ground. Everybody will come.
No, my lord, he had no authority to pass. It's on jurisdiction, my lord. When he had no authority to pass,
correct,
me going to appellate authority, going to 10%.
Let's decide on the jurisdictional.
Yes, yes, my lord.
Let them take instruction.
Yes, my lord. Jurisdictional issue, my lord. Yes.
Then counsel Ben Chavan accepts. Respondent. Relist the matter.
April.
Next week or week of second.
Second of April.
2nd of April.
32, Pranation.
Was appearing for the petitioner in this case, my lords. This is a writ challenging the orders passed for financial year 17-18, 18-19 and 19-20, my lords, where the respondents have invoked the extended period of limitation. That is notification number 9 and 56.
Who appears?
State, my lord. State.
Who
Hem
appears?
Kumar, sir. Hem Kumar, sir. State. State, my lord.
And password, let us see.
Please, my lord.
Password.
Lords, I'm appearing on behalf of the petitioner here, Your Lordships. Lordship, we are challenging the order and original passed by the Commissioner of Customs on the basis of several procedural infirmities and also suppression of a material test report which is relevant for the classification of the subject goods. Your Lordship, Your Lordship, the subject goods in the present matter are fiber optic splitters or PLC splitters, which are planar light wave circuit splitters. Your Lordship, we had classified the present goods under CTH 8517-7990 as parts of equipment used for transmission of voice and other data. Your Lordship, it's the
page
Your Lordship, page number 144. 144, the table has been reproduced, Your Lordship.
The
85.
first time. it's coming.
Yes.
If you serve copy, we'll have it on Tuesday and we'll consider.
Obligation.
Then also G1 accepts
Lordship.
notice for the respondent.
Now, number now.
Release the matter in the same stage on
Next, Malon, Wednesday,
Wednesday.
25.
Now, what is your point so that he can get?
Your Lordship, actually, there were two test reports, Your Lordships. At one instance, one test report was to clarify whether the CTH, which is said by the department, there are some exceptions given under that, Your Lordship. The second test report actually asked a question whether the subject goods is a part of a sub-assembly or not. If that question was answered in the positive, this test report has been suppressed both in the show cause notice.
Where is the reference to that?
Your Lordship, this may be seen at page number 77, Your Lordships. 77, Your Lordships. May be seen that this, during investigation, this was a photo which is taken by the petitioner, Your Lordships. This has not been provided to us officially.
77.
77. Lordship may see serial number A, whether these items are an element of a sub-assembly or assembly. It has been answered as yes. This singular point itself puts the classification in our favor, Your Lordships. Moreover, also referring to the advanced ruling authority, even though it is not binding in nature, it's persuasive value, Your Lordship. It makes reference to 3 Sistat judgments on specific point of PLC, and it says that the classification has to be 8517 7990, Your Lordship. This also stands against the revenue. Lordship, para number 6.
All on classification and merits, my lord.
Are you
Prima facie, my lord, an appealable order. Not a lack of jurisdiction or
Lordship, the test report was suppressed in passing this order, Lordships. It does not nowhere. If I may kindly direct to Lordship attention to the order in original.
You're correct, but why are you coming directly by way of a writ?
Your Lordship, because there has been procedurally, it has been suppressed. This test report, Your Lordship, the second test report was asked, and the second test report finds no mention in the order in original or the show cause notice, Your Lordship. And the test report was asked by the department itself to the TEC. It was not something which the petitioners asked for.
Let us, the department.
Yes, Your Lordship. The department themselves sent it for the test report, and the first test report which came in, they have mentioned that test report. Whereas the subsequent test report finds no mention anywhere in the order in original nor in the show cause notice itself.
Let us release the matter. G1 accepts notice.
25th.
Respondent release the matter in the same stage on Wednesday.
25.
Yes.
34. Serial number 34.
Yes.
I'm the fourth respondent.
Appear for the petitioner, my lords. My lord, this is wherein I'm challenging the order and annexure A, my lords. The order was passed on section 74, my lords. If your lordships can kindly just see page 22, my lords. My lords, this is an ex parte order, my lords, and also the order is based upon the grounds of that my supplier, my lords, was not found at the location at which he was supposed to be at, my lords. Subsequently, what they say is, it is observed that the registered person so-and-so belonging to so-and-so has availed input tax credit from the registered person who has been found to be non-existent or non-conducting any business from the place for which registration has been obtained, my lords. My lords, and with respect to this, my lords, there's nothing to establish that there's fraud or anything. I was not given a chance to even come before the authority to have it, to give my documents on a record or even my bank account statements, my lords. As well, the form DRC 01, my lords, which was sent to me with respect to this, it's at annexure G, my lords. My lords, if your lordships can see annexure G, page 47, my lords. My lords, the address what has been mentioned is not my address, my lords. It's not my registered address. This refers to an address at Magadi Main Road, Kadapagare Cross, Bangalore Urban, Karnataka. Whereas your lordship will file my GST address at Annexure D, my lords. My GST registration is mentioned, wherein it's my address of principal place of business is 164 Chokasandra Main Road, Pina, Bengaluru, Urban, Karnataka. So all my notices were served upon another address which does not belong to me, my lords. My lords, subsequently what has transpired is, my lords, after such an order is passed, after 2 years, my lords, at Annexure B, your lordship will find my notice where I've received the same notice, my lords, for the same tax period at page 26, my lords.
Yes, seems.
Please, my lords. This is an order passed in the year 2024, June 2024, my lords. Annexure A, 29/6/2024. And probably, my lords, that would be the address that would have been given at the time of registration.
My lords.
So, my lords, notice is said to have been served by way of RPAD, which is said to have been returned with a shara that the addressee has left. My lords will get it at page 23, my lords.
Yes.
And it is also at page 20, my lords will get it that the show cause notice dated 20/11/23 was also served through registered email ID. And a copy is also sent through registered post on 21/11/23. The registered post returned back with the remarks addressee left.
They're seeking for.
So whether at all the change of address, my lords, has been updated to the.
My lords, if I can take your lordship to Annexure J, my lords, page 138. My lords, this is the recent OD which I have availed from the bank, my lords, with respect to the address to show that I have been residing at the same address, and as well as my GST registration certificate. My lords, it shows the correct address. My lords, the
What is the
irony.
address in your certificate?
My lords, my GST certificate is Annexure D, my lords. Page 38. My lords, and the date of issuance of certificate is also there, my lords, 8/7/2018.
So then which
So
is
I have been residing
is
at,
this address?
my lords, this address does not belong to me. I have no idea as to which address is this or whose address is this notice being sent to. Annexure G, my lords, that's the DRC is being sent to another address which does not belong to me at all.
Lords, I'll accept notice, my lords. I'll verify the records and then get back.
My lords, if at all, my lords, if I can place on memo, my lords, what has transpired is, my lords, subsequently now, they have initiated another notice has been sent to me with respect to the same tax credit, my lords. For the same period, if it's, I've produced that also, my lords, at Annexure B. It's at Annexure B, my lords. If your lordships can see page 26. My lords, the tax period is shown as April 2023 to March 2024. And my lords, for that, I've been held under difference between GSTR 3B versus GSTR 2A. Whereas, my lords, the orders which is passed, it's at page 25, my lords. Tax period is the same tax period, my lords, April 2023 to March 2024. So, my lords, for the same tax period, first they hold me accountable under section 74. My lords, I have not been served notice. The copy of the order is not served upon me. Subsequently, in 2026, another notice has been served upon me, my lords, but it's under section 73 this time. And for the same amount, my lords, amount is also the same, similar, my lords. If your lordship will find the amount also at page 22, my lords. 38,39,795, my lord. And my lords, the recent notice at page
No, you'll have
26.
to find out.
I'll verify from the
My
records and
lords,
then
in
get.
the meantime, my lords, I'm producing another memo on record, my lords. What is transpired is my subsequent persons, my lords, who I'm doing business with have been receiving notice, my lords. My lords, my lords, in the first page memo, my lords, I've showed a copy wherein they have already deducted a certain amount with respect to this tax, my lords. Around 11 odd lakhs has already been deducted from my credit tax ledger. And my lords, on 12/3/2026, my other clients have been receiving notice, my lords, under section 79 clause 1 clause C, my lords, stating that I'm due such and such amount, 44,21,481. Your lordship will find it at page 3 of my memo.
Towards demand, they debit the ledger. Is it?
I'll have to get instructions.
No, I'm saying in case there's the positive balance of the ledger, they debit.
Yes, my lords,
Yes,
under, if I may, my lords, under section 49(4), even credits to my electronic ledger, they can debit, my lords. Even this honorable court has held, my lords, that if I were to go on appeal.
So how much amount now any balance has been debited?
My lords, around 11,45,000 is the sum that is debited to my lords.
7,45,000.
It amounts to around 20% of the demand that is raised, my lords.
No, but then you find out what is this overlap?
I'll do it.
My lords, in the meanwhile,
Coming up for the first time, my lords, let me take notice and then.
my lords, it's coming up for the second
Last
time, my
I
lords.
think
Notice was not
it come up last time, but I don't know if you were there or not.
My lords, in the meanwhile, if there can be a stay, my lords.
Now, where is this deduction of 11 lakhs?
My lords, I've produced my ledger, my lords.
Where page?
My lords, in my memo, I have given it today through a memo, my lords. If your lordship can find at serial number 6, 11 and 12, my lords. Serial number 6, my lords, it says a tax period of any, March 24. Description, my lords, outstanding demand.
When I have it tomorrow, my lords, in the same stage, I'll get that.
Relist the matter
My
tomorrow.
lords, in the meanwhile,
Tomorrow.
no, not to precipitate, my lords, because a lot of notices are going. My standing.
Tomorrow will relist the matter in the same stage tomorrow.
Certified, Pranay Sharma.
Now, in case they've debited, then you can hold. Let us see. Yes.
Certified.
That's for the petitioner, my lords. This is a writ challenging the order passed under section 79 and 107, my lords, wherein they are challenging on the ground that the respondents have relied on notification number 9, my lords. One of the issues that, if I may request my lords' attention to page number 55, my lords. This is with respect to the appellate authority order, my lords, at annexure A1. 55, my lords. The endorsement given is issued by one Assistant Commissioner Audit, Sudhir Biradar, my lords. Next page, my lords. The audit report at 56 is also signed by the same person, my lords. Further, my lords, page number 59, my lords. If I may read at 58, page number 8, ink page. Show cause notice also issued by same person. Order of adjudication also passed by the same person. That is the other ground, my lords. Order of adjudication is at, my lords, page number 64, my lords. In 63, the end, my lords, the adjudicating or the adjudication order in form GSTR 07 was uploaded, undersigned, same person, Sudhir Biradar. Same person conducts my audit, issues show cause notice, passes order of adjudication. That is the other ground, my lords, apart from the other grounds which I've raised. The whole issue, my lords, is with respect to me claiming ITC in respect of IGST, wherein I've set it off against CGST and SGST. It's a revenue neutral transaction. I have filed my revised returns also. But manually, they're saying that there is no provision under GST where manual returns can be considered. And they have demanded the amounts, my lords.
Insofar as the challenge to the notifications extending the period of limitations matters are pending, my lords. And insofar as that second issue with regard to the audit authority and the adjudicating authority being one of the similar matters have been stated.
Right of the contention that the auditing authority is also the adjudicatory authority who has passed the order in original. Matter requires consideration. In the interregnum, there will be stay of
No, it's annexure A1, A2 and A3, my lords. Annexure A1 and A2 is enough.
A1 and A2.
Yes, my lords.
AG accepts notice for the respondents 1, 2, 3 and 5.
Yes, my lords, 1, 2, 3 and 5 and center, because notification is challenged, the respondent number 4, my lords, CBT.
Or G1 will accept.
CBT.
Please. Present counsel G1 accepts notice for the fourth respondent.
Let's make a request, my lords. My lords had passed over one matter because my learned counsel wasn't there. Can I request it to be taken up, my lords? That is also 32, my lords.
32. 32.
These are ex parte orders passed for the financial year 17-18, 18-19 and 19-20, my lords. I was not effectively put to notice, and I was put to notice only when my bank attachment was done, which is at annexure G, my lords, page number 108, my lords. On 12/1/2026, my bank attachments took place, my lords. That was effectively when I was put to notice and immediately approaching this Honorable High Court. I am unable to prefer an appeal because the orders are of the year 2024, my lords. 23-24.
You did not receive notice or what?
My lords, I haven't received notice. For one of the period I received, I sought time, my lords. After that, I haven't received notices. These are all orders passed wherein they have relied on the notification which extended the timelines, my lords. If my lords are maybe sent back, I'll be obliged, my lords.
10% of the tax amount.
That's a small time. I agree with respect to 1 year, I have a huge demand of around 30 to 40. That is including the interest and penalty. Other than that, I have only 5 lakhs, 2 lakhs, 3 lakhs. I leave it to my lords.
Small matter, 2017-18, my lords, the tax itself was 20 lakhs.
My lords, 2 orders have been passed, my lords, for the same period. If my lords may kindly see 57.
If they appear and tell my lords, the second authority would have, because it will not know it on the portal, my lords, that an earlier officer or some other officer has passed an order. Once a show cause notice is issued, if they come and say that we have already suffered an order, we'll drop the proceedings. We have done it, my lords. Even when they come up before this Honorable Court, if I'm given a week's time, I'll see to that these orders are withdrawn and the petition becomes infructuous. They don't appear before the officer to any number of notices that is issued. And put a blame on the officer before this Honorable Court saying that we have passed an Exparte order.
Recently, courts have held if the assessee is unresponsive on portal, try to initiate other respective with respect to serving an RPAD.
I'll not press upon 18-19, my lords, though the order is dated 16/4/2024. The tax amount is only 2,27,000. Whereas, my lords, for the assessment year 17-18, the order is dated 16/12/2023, my lords. And the tax amount, my lords, is 10,92,569. I should in fact be insisting on more. I should say every year of delay, I should increase it by 10%, my lords.
17-18, then?
17-18,
18-19 and 18-19.
And 19-20. 3 years, my lords.
18-20 and 17-18, he has to pay.
Where is 19-20 order?
Annexure C, Annexure C1, 83 to 86.
Annexure?
C1 in this one. Lords, page number 85, my lords, the amounts around 13 lakhs, my lords, including the interest and penalty. Only tax amounts around 7 lakhs, my lords. This is something that I have to substantiate. I have all documents. I have discharged all the liability, my lords. Only part was I wouldn't say I hadn't received notice. I was not effectively put to notice, my lords. Only upon my bank attachment, I realized, my lords.
I really fail to understand, my lords. Effectively put to notice andre nav ಏನು ಮಾಡಬೇಕು. 169 ನಲ್ಲಿ there is a procedure that is prescribed that how we have to serve notice. It is enough if we put it on the portal. That is what the Madras High Court says.
And as
We have
recently,
served it by the email, on the registered email provided by them. And a plea is taken that the email of the auditor will be given, so they will not respond back to us. Or the ultimately after 1 year, the blame is put on the auditor. Or they'll say the notice was gone onto the column belonging to additional notices.
now they've
and
replaced
documents.
that also,
So
my
it
lords.
was not,
Everything is
it was
merged
not
now.
there. Any number of excuses, my lords. I'm
They're covering up all
started
the
learning how
whatever
to give
legal grounds we are
excuses now.
taking. It's all being covered up, my lords.
The last one is spam.
Yes.
Spam. am I-
Spam.
Let's let them implement a system where the moment like WhatsApp, when we open blue text come,
You can come and
let
assist us.
them implement a system. One of the
we'll-
coordinate benches actually made a observation like that, my lords.
Yeah, we don't want to get, then they'll start blaming. No,
You
Hemkumar.
use your AI and give it to us.
Hemkumar, they'll start blaming us before the appeal. Single judge said, blue tick one.
No, my lords, I'm just saying such an observation was made telling to implement
Let us see.
in the interest of justice.
For 2 years, my lords, 10%, my lords. 1 year it can be better.
The petitioner.
Lords, if I may request for a cost, I'll be obliged, my lords.
Hey, you can't choose.
I'm requesting.
Petitioner. Yes. Short form. Setting aside of. Hemkumar's cost colleague has not come back.
She'll be back probably next week, my lords.
Petitioner has sought for setting aside. His colleague will insist on deposit and cost. Your
Please,
colleague
my
will
lords.
insist on deposit plus cost. Petitioner sought for setting aside of order in original at annexure A1,
A1, B1, C1, my lords.
A2,
A1, A2, B1, B2, C1, C2, my lords.
A3, A4, B1, B2. Full stop. Petitioner also sought for setting aside of the show cause notice at annexure B3, B4, intimation at B5,
My lords.
intimation summary at B6, order in original at C1, summary of the order at C2, show cause notice at C3, summary of show cause notice at C4, intimation at C5, comma, intimation summary C6. The counsel for the petitioner submits that in the impugned orders of adjudication, the authority has proceeded to pass orders of adjudication without benefit of any reply,
Yes,
as the
madam.
petitioner failed to participate in the proceedings, though due to bona fide cause.
That's, in the first year, my lords, that is 1718, they file a reply to the notice and seeking for a month's time, and they don't respond back. My lords will get it at page 62 of the petition.
62, my lords.
Now, in which all you are ex parte, in which all you participated?
My lords,
All three are
ex
ex
parte,
parte. All
my
three are
lords.
ex parte, but insofar as 1718 is concerned, in response to a show cause notice, they file a letter seeking for 1 month's time. That is granted, then they don't get back.
It's submitted.
So it has resulted in an ex parte order.
That as regards the tax period of 1718, though initially the petitioners participated in the proceedings, however, no stand on merits by way of reply to the show cause notice has been taken.
Yes.
Next. It is submitted that the orders of adjudication.
Let's see, an annexure A1 has to be set aside.
The orders of adjudication have been passed. Any discrepancy between?
3B, 2A is one of the issue. The other one is they're saying I have undertaken work with respect to Manrega and the turnover is not declared. As a matter of fact, I have provided they have discharged all taxes, my lords. If my lords may kindly remind me back, I'll produce all the documents.
It is submitted that we must say one writ, single writ, we have to say single writ only 1 year, one adjudication order. The petitioner submits that if an opportunity is granted, they would demonstrate that the discrepancy as made out in the show cause notice does not exist. In light of the admitted position that the orders of adjudication are passed without benefit of any reply to the show cause notice on merits, it would be appropriate if matters are remitted to the stage of reply to show cause notice by setting aside orders of adjudication so as to enable the petitioner to take their stand. Accordingly, without entering into the merits, taking note that the orders of adjudication are ex parte orders. The following order. Orders of adjudication at annexure
A1, A2, A3, A4, B1, B2, C1, C2.
A1, A2,
A1 to A4 with respect to 1718, my lords.
A1 to
A4.
A4 as regards the
For
year
17-18,
2017-18.
my lords. B1 and B2 is for the tax period 1819, my lords.
B1 and B2 as regards the year 1819.
C1 and C2 is for the tax period 1920, my lords.
C1 and C2 for the tax period of 2019-20 are set aside. Matters remitted to the stage of reply to show cause notice as regards the respective years referred to above. All contentions are kept open. Petitioner to appear before respondents number
2, my lords.
2. Respondent number 2 on without further notice in that regard. Petitioners put on terms and directed to pay 10% of the tax demand for the year 1718 and 1920. 1718 and 1920.
10% of tax amount, my lords.
10% of
tax amount.
Tax amount.
Deeply obliged, my lords.
Petition is disposed of.
Grateful, my lords.
57, 37, Sri Rama.
For the petitioner, my lord, I may be permitted to appear through online, my lord.
Yes.
My lord, the challenging annexure challenged annexure in annexure B, my lord, the adjudication order passed by the respondent. It's a ex parte order, my lord, the page number 21 onwards, my lord. Only reason is, my lord, I have not paid the outward taxable supplies, my lord, for the period of 2019-20. The payable amount is, my lord, total 2,33,499, my lord. A prior opportunity may be given, my lord, I will deposit, my lord. Because of my previous auditor, my lord, the petitioner is unable to file the same. And now, my lord, they have issued the notice to my bank, my lord. The bank is, all my amount is holded by the authorities. Because of the notice, wide annexure C, my lord. Annexure C is the notice, my lord. Dated 21/1/2026. Page number 24.
Yes.
Yes,
As I
my lord.
mentioned, one of the reasons, auditor mistake. That's page 22, my lords. Paragraph 8. Show cause notice so and so dated 24/2020 was issued and served on the RTP through taxpayer login. Next paragraph, my lords, further an opportunity for personal hearing was also given to the taxpayer on 9/5/24. The taxpayer has not appeared for personal hearing. No reply, no personal appearance.
The petitioner At least,
And the order is of 2024, my lord.
the petitioner. Has sought for setting aside of the order of adjudication under
I
section
will,
73.
I will,
We'll send it back. Order of adjudication under section 73(9) at annexure B. As also notice to third person under section 79 1C. In case of the petitioner that the order at annexure B, which is the order of adjudication, ex parte order,
yes, ma'am.
without benefit of passed without benefit of any reply to the show cause notice by the petitioner.
That's a respondent, my lords, is not the correct respondent, my lords. The respondent should have been Commercial Tax Officer LGSTO 26, page 23, my lords will get it, my lords. He is the person who's passed the order.
We'll permit him to amend.
Please.
I may be permitted to amend. Sorry.
Benefit of any reply to the show cause notice on its merits. Good stuff. Submitted that the authority has proceeded to adjudicate the matter on material available, which has resulted in the ex parte order being passed. Next. Further submitted that if petitioner is granted an opportunity, the alleged discrepancy noticed by the authority between GSTR 3B and GSTR 1 would be substantiated. Peruse the order at annexure B. The order is an ex parte order, as the petitioner has neither replied to the show cause notice nor participated in the proceedings. The authority has adjudicated the matter after noticing that there was a discrepancy on comparison of outward taxable supplies other than within bracket other than 0 rated, comma, nil rated and exempted, close bracket, on one hand, and within inverted comma outward taxable supplies within bracket 0 rated on the other, as per GSTR 3B and GSTR 1. Taking note of the assertion of the petitioner that they would demonstrate that the alleged discrepancy does not exist, it would be appropriate to grant an opportunity to the petitioner to participate in the proceedings. Accordingly, the order at annexure B, which is the order of adjudication, is set aside, matter remitted for consideration at the stage of reply to show cause notice before
the commercial tax officer.
Before the commercial tax officer.
LGSTO 26.
LGSTO
26, comma, capital DGSTO 4.
DGSTO 4. Full stop. Petitioner to appear before the said authority without further notice. Full stop. Petitioner is at liberty to take out to file reply to the show cause notice.
My lord, one more submission, my lord.
Just one.
Yes.
Just one. Accordingly, petition is disposed of. Consequent to the setting aside of the order of adjudication, the authorities, the respondent authorities are directed to rescind notice issued to third parties insofar as recovery pursuant to the demand arising out of the impugned order, which now has been set aside. Order sheet AGA M. Kumar accepts notice for the first respondent. Petitioner makes a oral request to array CTO, LGSTO 26, DGSTO 4 as an additional respondent. Necessary amendment, such oral request is acceded to. Necessary amendment to be carried out. Accordingly, carried out. Full stop.
I may be permitted to carry out, my lord.
Yes, yes.
Grateful.
38, Vishwanatha.
Petitioner is the owner of the property bearing number 224, my lord, situated at 10th Main, 10th Cross, Chandranagara, Kumarswamy Layout, Elchenahalli. He has put up the constructions, site measuring a 20 by 25, my lord. Now the BDA has issued a notice, annexure A, my lord. I have produced all the document to show that I am in possession and enjoyment of the property. ಈಗ BDA ಅವರು ನೋಟಿಸ್ ಕೊಟ್ಟಿರೋ ಉದ್ದೇಶ ನಿಮ್ಮ ಹತ್ರ ಏನಾದ್ರು ದಾಖಲಾತಿಗಳಿದ್ರೆ ತಗೊಂಡು ಬಂದು ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. Since from 24 years, the plaintiff has in position in the put of the construction. Annexure A, my lord. Annexure A.
Correct. They are saying it's BDA property.
No, my lord, it is slum area, my lord. We have put up the construction. So there is some dispute between the slum, that area. They have instigated the BDA to issue notice.
Any BDA council? Land Council. Sachin BS is directed to accept notice for the respondent 2 and 3. AGA for first respondent. I'll have it on Monday, just find out.
Yes, let them serve, my lord.
Serve copy.
I will.
Relist the matter. Same stage on Monday.
39, Ravi Kumar CH.
The petition is challenging the notice issued by the respondent number 3 and 4 to remove the unauthorized construction in made in survey number 5/3, wide annexure Cayman, page number 54. Petitioner family is the owner of the land measuring 34 guntas in survey number 5/2, my lord. So out of that, my 34 guntas, my lord, BD has acquired for 14 guntas. So in balance 20 guntas, my lord, in my portion, my lord, I have made the construction, my lord. Now, my lord, BD has officials have issued the notice to remove the unauthorized construction. In fact, I have not made the construction in the acquired portion. In this regard, my lord, I have produced the sketch drawn by the.
Serve copy. We'll have it on Monday and we'll dispose it of. Let them do a survey and demarcate.
In this, yes, ma'am. In this regard, ma'am, for the
serve copy.
Yes, ma'am. For adjacent land, my lord, your lordship has directed to conduct a survey and submit the report, my lord. Same adjacent land.
Date is fixed, is it?
Yes, my lord.
Good.
Yesterday. In survey number 5/3, survey number 5/2, my lord. In fact, I have made the representation to the. I have no objection to acquire my land and seeking for compensation to the acquired portion.
What is the date fixed?
In fact, for 16 to submit the report. In my land, I have no objection for acquired land. So it is.
Land Council, Shri Ajay Kumar is directed to accept notice for respondents 1 to 4. List the matter in the same stage on This is the matter. This same stage along with WP 6749 of 2026 on. ಅದು ಮೊನ್ನೆ ಬಂದು ಡೇಟ್ ಹೋಗಿರ್ಬೇಕು.
Stay of the notice, my lord.
No, let us see now. We'll see.
Because my lord, there is a threat of demolition because I have constructed in the unacquired portion. I have not constructed in the acquired portion, my lord.
No, we'll have it on Monday. We'll see. We can dispose it of.
40, Venkatji.
GST matter, where the state is the party, my lord. It's an ex parte order, my lord. Annexure A1 at page 30. At page 32, my
You
lord.
can actually have one Lokadala.
For ex parte orders.
No, for expert. You can get at your highest level.
To that extent, my lords,
You can make one.
To that extent, my lords, from my side, I can give the
You can
cooperation.
propose to your commissioner, whoever the decision-making authority, that let them pay 10% of the.
Lords, to that extent, my lords, I can talk to the commissioner and inform him as to what is there in the mind of the court, my lords. But other officers, my lords, are not practically, my lords, any officer who passed the order, he'll not have any power to come and concede before this court or.
Yes.
My lord, in this case, at page 32, my lord, the references may be looked into.
Yes.
In response to serial number 3, which is the show cause notice dated 4/7/2025, I've made a reply, which is at serial number 4, 16/8/2025. Then for nearly 3 months, I did not hear. And then there appears to be an endorsement which is issued on 11/11/2025. On that, my lord, at page 38, it says in the second para, my lord, bigger font, in that second line, an endorsement for personal hearing was issued on 11/11/2025 to provide an opportunity of natural justice. Our taxpayer did not appear for the scheduled personal hearing. Now, my lord, on that date, one thing is they do not say as to how it was served and whether it was served at all. Anyways, at page 75, my lord, there was a time when my managing partner was on travel. He was on international travel. The air tickets I have placed on record, my lord, page 75. The dates may kindly be noticed, my lord. In the portion of your travel information, after that, flight EK 567, they check in at 4th November 2025. And over the page, my lord, when he returned, that is at again EK 564, 18th November 2025. And this endorsement appears to be issued on 11/11/2025. So even if the SMS alert would have come, he was on international travel. It is doubtful whether he received it. And on the portal, there is no such endorsement, my lord. That's a fact. That can also be verified by my learned friend. And insofar as the merits are concerned, my lord, I have made a reply. But all that the adjudicating officer says is that in support of that, the documents have not been produced. Majorly, the receipts in bank statement, everything has been added as turnover, my lord. They all consist of loans and various other receipts which are not in the nature of taxable supply, not consideration for taxable supply. All that I am seeking, my lord, is that if it is remanded back, I will produce all the necessary documents and make out a case. And this order is very recent one, my lord. It is of 3rd December 2025.
Yes.
Lords, it's an appealable order, my lords. They have filed a reply. The reply has been considered. It is only that they have not appeared for personal hearing. Just because they are on a pleasure trip, my lords, to Paris, that doesn't mean that I have to wait for them to pass an order. There are a lot of limitations, my lords. For example, we'll be rushing against the limitation to conclude the assessment within a particular time frame. It's an appealable order, my lords, let them file an appeal. Now that we have already issued a bank attachment, I don't know whether any amounts have been recovered. Let them deposit 10% of the amount, my lords, and then file an appeal. My lords may permit them to file an appeal. Because they have approached this court, my lords, within the time limit provided to file an appeal under section 107. There is no other question with regard to jurisdiction, except saying that only they could not appear for personal hearing because they had, this person was on a tour. That cannot be a valid ground, my lords.
You can file an appeal itself.
No, my lord. If that is the case, my lord, let them produce as to how they have issued that 11/11/2025 endorsement, how it has been issued and served on me, that they can show, my lord. And the bank attachments have been now made on a different entity. My lords may look at page 80.
Page
80. The petitioner is Dhriti Construction, whereas bank account of Skandavani Shelters Private Limited is attached.
Is this a group company?
Even then it is a separate legal entity, my lord. It's a private limited company.
Correct. I'm just asking, is it related or unrelated entity?
Yes, it is a company where my partner is a director, but that does not permit them to attach that bank account, my lord. There is no legal basis to do so. All that I'm asking, my lord, is that if they wanted to give me an opportunity of personal hearing, section 75 also says that 3 opportunities should be given, my lord.
Okay, find out. First
Please.
time it's Council M. Kumar accepts notice for the respondent. List the matter in the same stage on
Tuesday, my lords.
Tuesday. Yes.
41.
Grateful.
Madhusudan.
It's Exparte assessment order for the assessment year 2021, my lord. For the immediately preceding 2 assessment year, your lordships had remanded back, saying that the notices were issued on a mail ID of an ex-employee, my lord. Hence, therefore, I was prevented from sufficient cause for furnishing any replies. May pass on that order, my lord.
Lordships have, lords, on 4th February, lordships.
Tax, GST, income tax, all expert.
Lords, they have not
Please
filed
sit, please
replies.
sit and do this. No other adjudication on some point.
The order which I passed on is for assessment year 1819 and 1920, my lords. The petition is today's
It's like doing some MVC case.
Lordships should impose cost, my lords, so that they'll stop filing.
It's like doing MVC case. The same reason, is it?
Same reason, my lords. Same assessee also.
The petitioner. Yes, sir. The sealed. The assessment order at annexure A1, computation sheet at A2. The notice of demand at A3. Penalty order at A4. Computation sheet pertaining to penalty at A5. Demand notice at A6. Penalty order at A7. Computation sheet at A8. Demand notice at A9. Penalty order at A10. Computation sheet at A11. Demand notice at A12. This under 148 cap A small b at B1
and B2.
2 notices were issued.
and similar notices at B2 and order under 148 A small d at B3 a notice under 148 at B4. Petitioner submits that the order passed, assessment order passed. You have participated initially.
My lords,
You have participated initially.
one adjournment request I have
One
filed, my
letter
lord.
they filed.
One adjournment request. None of the replies were filed to any of the notices, my lords.
So it's submitted that though the petitioner had initially participated in the proceedings. No, but once you have participated, then
No, it's one of the request, one request has been sent, my lords, for adjournment request because one of the email, one notices, they were logged into the portal and they'd seen in the testing, my lords, but none of the notices were received to the email ID which was accessible.
in Brazil. And it sought for adjournment. However, subsequently was unable to participate, and the notices seem to have been sent to the email ID of the employee who has left the services of the company. Accordingly, it is submitted that the petitioner, not having been informed of the subsequent dates, could not participate and put forth their case before the authority. Next, it is submitted that if the petitioner is granted an opportunity to participate in the proceedings, petitioner would be saved from undue hardship. Peruse the assessment order it would indicate that the authority has proceeded to adjudicate on the basis of material available as the petitioner has not responded to the notice. Taking note of the consequences that would visit the petitioner if the order is allowed to stand, the impugned order of adjudication requires to be set aside and matter remitted.
The stage of B1, B2, my lords, 148 AB, my lords.
They have not filed reply to AB also. Leave it to your lordships. Leave it to your lordships. You can go back to 148 AB, my lords, because they have not filed reply.
In particular, to the stage of 148 capital A small b,
Annexure
the stage of reply to notice under 148 capital A small b. It is required to be remitted to such stage as it is noticed that even when the order at 148 capital A small d was passed, it was preceded by a notice under 148 capital A small b, but petitioner had not made out any reply to such notice. Accordingly, the order at annexure B3, B3,
B3, A1 to
aside.
A1 to A12, B3 and B4 required to be set aside.
Accordingly, the orders at annexure
A1 to A12
A1 to A12
and B3 and B4, my lords.
B3 and B4 are set aside and matters remitted to the stage of reply
B1
to the 148A small b. All quotations are kept to open. Council Dilip accepts notice for the respondents.
42.
Lords, challenging the order passed by the state, my lords, wherein I may request my lords' attention to annexure A4, my lords, at page number, page number 113, my lords. One of the issues is consolidated show cause notice, my lords. And my lords are there in page number 113, my lords.
Yes.
Well, it's in that annexure brief facts in the show cause notice for the periods 2017 to 2019-20, Malats.
1718 to 22-23.
Page.
23.
ಬರ್ತಿದ್ಯಲ್ಲ?
Malats 1718 to 1920, Malats 113, Malats.
ತಪ್ಪರ್ದವ್ನು.
Yes.
One of the issues that, Malats. The other issue is with respect to the Chandrasekharaya issue, Malats, wherein I'm supposed to receive money from the government department in order to discharge to the department with respect to the change of tax rate. I've made the PWD electrical division as a party, respondent number 4. Malats may direct the state to accept notice or as my lords deal with.
So we'll state on that show cause notice.
My lord, this is on that ground, my lord, consolidated show cause notice, my lord can consider it. As far as other parties are concerned, my lord, notice.
Only state one party is there, my lords, that's all.
That is also, my lord, posted for hearing in
That
Chandrasekhar.
show cause notice has been issued as regards multiple tax periods.
For respondent form, its copies to be served.
Spanning
I
between
will serve, my lords.
2017, 18,
1, 2, 3 are ಮಾಡಿದ್ದಾರೆ.
20.
Lord, I take notice for
placed
1, 2,
on
3.
Ramur Homes and Shelters also so and so. There will be stay of
A1 and A2, my lords.
A1 and A2. Grand Council G1 accepts notice for respondents.
Respondents 1, 2, 3 and 5, my lords.
1, 2, 3 and 5.
That is central. And respondent number 4 is the state PWD electrical division, page number 9.
Yes, Hem Kumar.
He will take for 4.
4 I'll take notice. Copies to be served.
Copy will serve, my lords.
Accepts notice for the fourth respondent.
Oblige, my lords, great.
43. Meet.
Lord, the matter arising out of form number 26 years, my lord, where solely on the returns of income tax returns under 26 years. And also the other ground is that, my lord, the consolidated show cause notice.
Yes.
So I have it next week, my lord. I'll just
Council
received the
Chavan
copy.
accepts notice for the respondents. Is the matter in the same stage on
Next week. 24th or 25th, my lord.
25th.
Rated in the orders list, my lord.
Same stage.
The preliminary hearing, my lord, orders one.
No, same stage. This is the best stage. Yes.
Let them not proceed.
We'll dispose it on the next.
Goods are, well, goods are in transit, detention address passed, my lord. Section 129 and 130, my lord. Without completing the procedure under section 129, they have initiated 130 proceedings, my lord.
Center or state?
My lord,
I'll appear.
my lord, my lord, identical letter.
For the respondent. Huh?
My lord, without completing the proceedings under section 129, 130 was issued, my lord. Ready to pay the 25%.
No, let Hem Kumar have a look at
This is a case, my lords, where we have not even initiated proceedings under 129.
My lord,
We have straight away gone to 130. We have issued a notice, my lords. The communication for detention, my lords, will get it at annexure A, page 26. We have communicated a detention, my lords, exercising the powers conferred under section 68. And my lords directly issued a notice for confiscation at annexure B, page 29. They have to participate in the proceedings, my lords.
my lord, 129, detentions comes under 129, my lord.
Because, my lords, this honorable court has been interfering, saying that once I pass an order of detention under 129 and then issue a notice thereon, I can't subsequently, it's not that I can't, jumping into 130 and trying to confiscate the goods. This court, my lords, expressed some opinion that the matter has to be considered. Now, my lords, going by the Gujarat High Court judgment, where, my lords, the Gujarat division bench of the Gujarat High Court has said there is no necessity to go into 129, 130 can be invoked directly. We have invoked 130, my lords. This is just a notice, my lord. Let them go file the reply.
My lord, communication of
Annexure
detention
B is
comes-
a notice.
My lord, communication of detention comes under 129, my lord.
They cannot decide, my lords, whether they want 129 or 122 or 130. Or they can choose. They can commit an offense and choose which provision they want.
My lord, in this case,
Anyhow, you'll have it on Tuesday. You see.
Yes, my lords, all that I'm saying is, my lords, this notice is dated 5/3/2026. Let them go file a reply to this. Let it get culminated into an order. They are only wasting time, my lords, and they say it is Arcanet.
my lord, issuance of Annexure A itself is a 129%, my lord. Issuance of Annexure A itself is a 129%, my lord. Communication of
I don't
detention,
understand,
my
my lords, why they are not permitting us to pass orders under 130.
lord. We do agree with the proceedings under 130, my lord. We board on it. Until then, interim relief should be granted, my lord. We participate in the 130 proceedings, my lord.
My lords may kindly see
As
the
per-
interim order that is passed in the earlier matters also, my lords. That was a case, my lords, where we had initiated proceedings under 129. And that was the reason, my lords have mentioned that in the order. Could he? Could he? Copy iದ್ರೆ ನನ್ಗೊಂದು ಕೊಡಿ. Probably it is not mentioned here, my lords, but the facts of the case therein, my lords, was that it was an order of detention passed under 129. Then we went on the proceedings till 129(6). Then we shifted to 130 and issued a notice for confiscation because there was a delay in conducting an inquiry.
No, what is it you want now?
Not we're ready to pay the 25% of the amount, my lord.
No, it's not yet quantified now.
Yes.
That'll,
Notice was
It's
issued-
only still
notice-
at the stage of issue notice.
Notice was issued, my lord. Annexure B. The completion was made at page number 39, my lord.
Page?
39. Calculation was made, my lord.
Waiting takes ₹1 ಕೊಟ್ಟಿಲ್ಲ 7 months into.
This case, I am having the e-way bill and invoice also, my lord.
Anyhow, you want to look at it in detail, we'll have it on Tuesday or week.
Please, my lords, I'll.
Until then, do not precipitate, my lord.
No, let us see now.
Lord, 130, notice at page number 40, my lord, the date was for 11/3, my lord. Not to precipitate further, my lord.
No,
Not to
correct.
precipitate.
Only to demonstrate, my lords may kindly turn to page 30, my lords. 31, sorry. Kindly see, my lords, the turnover.
It was declared, my lord.
We'll have it
For the
on-
past 6 months.
Huh?
After 6 months, they'll not be available.
We are due to file after it, my lord.
Correspond 1 and 2. What affidavit?
Please, my lords.
He wants to file affidavit.
It's not-
No, I'm just saying.
I think, my lords, I have also been
Land Council.
extra reasonable in.
Union of India.
For R3.
So accepts notice of third response. List the matter. Relist the matter
My
on.
lord, till then, do not precipitate, my lord, in pursuant to Annexure B, my lord.
No, let us see. Let us see.
Lords, in the meanwhile, let them go file a reply, my lords.
No precipitate.
Why they
order,
want
my
to
lord,
delay
should
the
be
procedures?
You
Till
file
then,
the
no
reply,
precipitate
we'll
order, my lord.
see. On what ground now you have come to this court?
My lord, there are two grounds, my lord. They are saying that the goods are loaded from some other place, my lord. Their first contention, as
Those
per
all
a
are-
statement of the driver, my lord.
Those all
But
are
as per,
recent-
but
those
as
all
per
are-
I move on, my lord, there is no statement was recorded
All
by
fact-
saying that the,
Factual findings, how we can interfere in it.
my lord, kindly see the page
Let
number
us see on
48.
the next date we'll see. Yes.
Let the court also have the benefit of an order, my lords. Once they file their reply, a fact authority will write everything in his order. So I'll be at an advantageous position to defend my case, my lord.
When the
Otherwise, on a notice, it will be difficult.
My lord, when the order itself is under section 129 and without completing the proceedings under 129, the issuance of 130 cannot be done, my lord.
That's why they say that they've gone under 130 directly.
My lord, kindly, please to read section 129, my lord.
Let us see. On Tuesday, we'll see.
Till then, do not precipitate, my lord. Not to pass any precipitate order, my lord.
Nothing will happen next
My lord,
3-4 days holidays.
They will pass 130 order, my lord.
That we'll see what ground, in that we'll see what is to be done.
That is the reason, my lords, I'm saying let them go file a reply on Friday.
Against 130 orders, we are not interfering. We're only at the most ordering for release and directing you to go to before the appellate authority.
I do agree, my lord. I do agree, my lord. We are ready to pay the amount, my lord.
That let us see.
25% of the amount.
Let us see on next year.
My lords, I'm sorry, my lords. In the earlier matter, they were directed to appear on 11/3/2026, my lord.
So that I am seeking the.
They have not appeared, my lords. So let them go file a reply, my lords. Let them participate in the proceedings.
We file a reply without prejudice to the.
Whatever,
contentions raised
let them,
and then
if they
come
suffer
back.
an order, let them bring that order before this honorable court, my lords.
Then we'll see.
Till then, no precipitate order, my lord, because the date was already been passed, my lord, 11/3.
They may have passed an order.
It should have been, I don't know if it is already passed also.
Till this date, we are not disputed, my lord, so that.
You should have participated there, suffered an order, and then sought for your, unless you have a jurisdiction point. That we'll see. We'll see on Tuesday.
This case, Miller. So may kindly peruse the orders dated passed by this honorable.
Who appears?
I appear.
So page number 103 of 103 and 104 of direction issued in Rectification 21,092 of 2019 dated 28th April 2025. Para number 5, page number 104. Learned AGA on instructions submitted that as a matter of fact, 2 grants were made after the land came within the purview of 5 kilometer radius, namely Sinapa and to 1 Appayachari, to an extent of 30 guntas and 2 acre 20 guntas. And both these grants were made on 24/7/1998. This particular fact by itself indicates that the revenue authorities are selective in either considering or rejecting the applications filed for regularization. If the revenue authorities have ignored the 5 kilometer radius in respect of Sinapa and Appayachari, the application of the said rule for considering the petitioner application would be arbitrary and discriminatory. It is also pointed out by the learned counsel for the state that after the reservation of 5 acre 20 guntas in survey number 49, there still remains an extent of 2 acres 29 guntas. In the light of this statement of the learned AGA, in my view, it would be appropriate to consider the application of the petitioner for regularization in respect of this extent of 2 acre 29 guntas, and the authorities are also directed to take into consideration the fact that the revenue sketch was prepared as per Annexure H, indicating that the petitioner was in possession of 1 acre 25 guntas. The authority shall also take into consideration the measure that has been drawn up, a copy of which is produced at Annexure J, which also indicate that the petitioner was in possession of 1 acre 25 guntas in survey 49. In the light of the same, the authority shall not take into consideration an endorsement dated 14/8/2019. It will be considered the case of the petitioner on the same lines as has been considered in case of Sinapa and Appayachari, who had been granted land in survey number 49. This is the findings given by this honorable court, my lord. So in the last week, my lord, I received the intimation, Annexure Z, page number 107. My lord. Again, they're relying upon the very same endorsement. That's why I am filed this petition challenging that endorsement once again. And today afternoon, 12 o'clock, the respondent number 3, Tahsildar, and as well as the CMC commissioner of Malur went to the spot, and they are instructing to vacate the scheduled property. And also whatever that endorsement issued by the Tahsildar, my lord, it is antedated, my lord.
Could your lordships have this tomorrow, my lord?
list. AG accepts notice for the.
Learned friend be directed to serve a copy as well.
1 to 4. Emergent notice to 5th respondent. Relist the matter tomorrow.
Great.
Copy has been served to them. So meanwhile, may I kindly protect my position.
Tomorrow.
Who matter? Sachin PS.
But the update for the petitioner. But the Tahsildar my lords has passed this order, my lords. That's at annexure A, my lords, page 18, which my lords records that my lords have not given any reply, my lords, to his notice. And an order, my lords, of notice for eviction is been made, my lords, by the Tahsildar. Lords, but the annexure E, my lords, there is a reply, my lords, to so that, my lords, I have replied to the notice of the Tahsildar. Lords, says that, my lords, the allegation is that, my lords, I have encroached upon the putkarab, my lords, of the Sarkari Jameen. Lords, and I have, lords, encroached upon that land. Lords, I have replied, my lords, to the notice that is given.
Please see, my lord, annexure C, page 24. The B Karab extent, my lord, is 9 guntas. 6 plus 3.
Yes.
That now comes in their sale deed also. Lord, at page 23. They can't add it to their sale deed. B Karab, my lord, belongs to the state. Therefore, my lord, question of interference. Now that they've taken possession of that property, my lord, we've issued notices to them. They've replied. We've rejected their response, my lord, and based on which, my lord, now we're trying to take possession over that property.
Lords, my vendor's property RTC.
Notices have been issued earlier, my lord, in at annexure D, my lord, on 21/8/2025. After which, now, my lord, after 5 months, we're asking them to leave.
Lords, the notice, my lords, at annexure D, annexure E, my lords, I say that, my lords, it is a land, my lords, of.
No, now you give your produce the Akar Bandh. There ends the issue. Is the Akar
No,
Bandh?
they don't dispute it. They don't dispute, my lord, that it is B Karab.
My lords, give me.
No, you place the Akar Bandh on record. There ends the matter.
Please.
Where is it?
Lords, until then, my lords, not to.
We'll have it tomorrow. You place the Akar Bandh. If it's other than B Karab, then it could be conveyed. If it's B Karab, you can't convey it.
Please, if it, lords, if it is B Karab, my lords, I admittedly, my lords, have no case.
That's why in
But,
that
my lords,
Akar Bandh settlement, the classification of Karab will be there.
Please, my lord.
If you have it, you produce it tomorrow.
please, my lords, may have it tomorrow. I'll, my lords, if it is available, my lords, I'll file it before this.
AG accepts notice. You also get that.
I'll try and place.
AG accepts notice for the respondent. Release tomorrow.
Lords, in the fresh matters, my lords.
Same stage.
Great.
My lords, with your lordships, kind leave, my lords.
Still number 60, my lords. Still
Please,
60.
my lords, may I request
Just 1
for
minute.
it on, my lords?
Just 1 minute. Just 1 minute. Just
Serial
online, please wait.
Serial
Now,
number 76. my
all
lord.
just one. All matters that have not reached dates will be assigned. Yeah, good. 45 to 47 fresh matters will be repeated tomorrow. In all matters where there are either orders of bank attachment
61 million.
or where interim order is not considered and has gone down lower in the list, you make a mention to the court officer. We will have it in the fresh matters list. Only bank
My lord,
attachment
number 50, my lord,
not considered.
writ of mandamus, my lords.
Just
Demolition
1 minute. Online, please wait. Let me discharge the other lawyers. Then I'll take up the online mention.
Serial number 49, my lords.
demolition
Morning I
matter.
had mentioned.
Correct.
No, that's all, my lords. I'm only seeking.
My lord, BDA demolition matter,
Probably the fresh
serial number
matters if
73.
possible.
Morning, senior counsel Sushila madam also mentioned, my lord. Similar matter, my lord. Fresh matter tomorrow.
No, there are 70.
Lord, 76.
Wherever, just 1 minute. Wherever interim relief is not considered and is urgent, you make a mention to the court officer. Whichever stage it is, we'll have it in the fresh matters list. That is where interim relief is not considered. If it is for disposal, whether it's covered or not, you will have to wait. Dates will be given. Only interim relief, if it's not reaching, you make a mention to the court officer, it will come higher up in the list.
61, my lord, sir. Last time also I mentioned, my account is attached, my staffs will not get the salary. That's why tomorrow may be taken.
Serial number 42.
Please.
Minor
Submission, my lord. Serial number 42. One of the annexures is missed, my lords. Can it be added, my lords? A5 has to be added. A1, A2 is there. Bank attachment is A5, 42. My lords already took it and missed it, my lords. A5 to be added. A5 to be added, my lords. Annexure A5.
Interim order to be serial number 63, my lords.
42. Petitioner is permitted to
A5 also is to be stayed.
amend the.
No, my lords, stay has to be granted with respect to annexure A5, that is bank attachment.
Stay.
A1, A2 is stayed.
No, correct. A5 will ask them to resign it.
No, this bank attachment, my lords.
Correct. In light of the, now this we have disposed of or only interim order?
Interim order, my lords.
Correct. So in light of the interim order granted, respondent authorities to rescind the bank attachment forthwith.
Serial number 86, my lord, interim order to be extended.
Wherever interim orders are there, it will stand extended.
My lord, serial number 67, my lords.
My lords.
If we have filed memo for withdrawal in serial number.
Question.
My lords, in serial number 67, we have filed memo for withdrawal, my lords.
So make a mention to the court officer, he will put it up there.
My lord.
Huh?
My lordship.
You make a mention,
My lord.
make a mention to the court
My
officer.
lord, in list number 2, serial number 3, matter has been disposed of, my lordship. Since that revenue entries have been taken place by virtue of that AC order, that they are trying to eliminate the property, I request this lordship to direct the office to issue the operative portion of that order, my lordship, today urgency, because already revenue entries have been changed in the name of that respondents, my lordship. They're trying to eliminate the only operative portions, that's all, my lordship.
Yes, online, just wait,
My
online.
lords, serial number 50, my lords, it's a writ of mandamus, my lords. May I request for it in fresh matters, my lords, next week?
Serial number,
50 in list 1, my lords.
mandamus,
It's a writ of mandamus to consider my representation, my lords.
list 1,
Please, my lords.
list in fresh matters list on.
I'm grateful, my lords.
My lords, my lord, serial number 67 in list 1, my lordship.
87.
We have filed memo for withdrawal, my lordships. I may permitted to withdraw and KIDB may be issue direction to issue the compensation amount, my lordships.
Serial number?
67, list number 1, my lordship.
We'll repeat it tomorrow in fresh matters list.
Grateful, my lordship.
My lordship, in
My lords,
87,
serial number 63, my lords.
item
Criminal
number
petition.
87,
Yes.
my lordship, and item number 87, this jewelries have been seized long back, my lordship, 4 years, more than 4 years, it's not getting released. So last time my lords had agreed to list it early. It is, but it is coming up 2-3 times. Every time it is on the lower on the list. Can you kindly put it on the top of the board or earlier numbers, my lordship? 87, my lordship. 87.
My lords.
Huh?
87.
No, they are saying if you are giving a bank guarantee, they will release it.
My lordship, the problem is the 600 crore asset has been attached by them. 600 crore worth of person, and it is a double edition. I am a partner, and I have withdrawn the amount. That amount they have treated as my income.
I'll fix a date.
Yes, my lordship. Kindly, my lordship.
Lordship, serial number 92, my lord. It's a fresh matter and matter to be remanded.
My lords, serial number 63, the Sessions Court is awaiting for the orders by this court, my lords. It was posted for arguments yesterday and today it has been posted by citing the result of this criminal petition, 63, my lords. Kindly have it tomorrow, my lords.
But the respondents in that, there's a detailed order of vacating the interim order because the petitioners was not ready to prosecute the sale. This is the trial court is not waiting for this honorable court's order.
My lords, yesterday order sheet has cited
honorable court
this
has
criminal
already been
petition and
pleased-
adjourned.
Let me submit.
Yes.
This honorable court has already been pleased to vacate the interim order because the petitioners were not ready to prosecute the sale.
Correct.
There's another writ petition filed in another court for challenging the withdrawal of special prosecutor's order. The court is awaiting for that. They have misled the court there. They've taken an order there. telling that the special PP has to address his arguments. Whereas in the trial court, arguments were already concluded by the PP.
It's a
regular
wrong
PP
submission, my lords. My submission was it's
See,
for
let us-
arguments. Kindly have it
I
tomorrow. my lords.
vacated, so you'll have to wait in the queue, no hurry.
My lords, tomorrow it is posted for arguments, my lords.
Let orders be passed. There's a penalty for you not participating. I've given several opportunities.
Lord, Melody, your lord.
Court officer,
Sir, serial number 45.
24.
court officer.
Madam.
24, 25.
I think, ಕರ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್ 23. Well, 23 ಬರುತ್ತೆ.
Court officer.
75, sir.
ಯಾರು ಯಾಕೆ ಅವ್ರು ಯಾಕೆ ತಗೊಂಡ್ರದ್ದು ಗೊತ್ತಿಲ್ಲಲ್ಲ ಯಾರು
Court officer, serial number 92.
45, 46, 47 fresh matters. ನಾಳೆ ಬೆಳಗ್ಗೆ.
Court
48,
officer,
24th ಇಲ್ಲ, 24 to 25 ಇಲ್ಲ. First set. Second week.
sir,
2020 का है ना और नंबर क्या सॉरी सर्च कब हुआ था 2020
15/4.
sir, serial number 92, sir.
First sir. 50.
Sir, 50 short date.
That's next week.
50 ಹಲೋ
Next week.
48 ಅಕ್ಷತಾ
ಅದು ಫ್ರೆಶ್ ಬರುತ್ತೆ ಅದು ಹಿಂಗದು.
ಸೀರಿಯಲ್ ನಂಬರ್ 50 tomorrow 50
Sir,
Court officer, sir.
52 next week.
Court officer, sir. Court officer, serial number 68, a short date ಕೊಡಿ sir.
51 23. 53 53 54
Sir, 54. Sir, 54, 25th.
54
25th, sir.
25th ಇಲ್ಲ ಫಸ್ಟ್
Senior counsel ಬರ್ತಾರೆ.
ಫಸ್ಟ್
Sir, Google ಮ್ಯಾಟ್ರಿಕ್ ಬರ್ತಾರಲ್ಲ ಅವ್ರು 25th ಪಡಿವಲ್ಲ ಸರ್.
ಆಯ್ತು 55 56
56 sir.
ಶಾರ್ಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇಲ್ಲ 6th 57 7th of April 58 ನಾಳೆ ರೀಚ್ ಆಗಲ್ಲ ಸರಿ ಆಯ್ತು 83 ಬಂದು ವೇಟ್ ಮಾಡಿ 60 59 60 ನಾಳೆ ಫ್ರೆಶ್ ಮಾಡಿ
ಸರ್ 61 ಪ್ರಶ್ನೆ ಮಾತ್ರ ಅಲ್ಲ ಆಗ್ತದೆ ಅಂತಿದ್ದಾರೆ ಅದು
61 ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಅದೇ ಈಗ ಹೇಳಿದ್ನಲ್ಲ
ನಾಳೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಅದು
ಬರುತ್ತೆ
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರಿ ಸರ್
ಬರುತ್ತೆ ನಾಳೆ 62 ಸರಿ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಇಲ್ಲ 23rd ಗೆ ಇರುತ್ತೆ ಆಯ್ತು 63 64
Sir, 64, 24th ಕೊಡ್ಬಿಡಿ. Next Tuesday.
ಆಯ್ತು ಥ್ಯಾಂಕ್ ಯು
65 ಯಾವ ಡೇಟ್
ಎಂಟ್ರಿ ಮಾಡಿದೆ 2 ವೀಕ್ಸ್ ಅಂತ ಅರ್ಜೆಂಟ್ ಏನಿಲ್ಲ ಅಲ್ಲ 66
ಅರ್ಜೆಂಟ್ ಇದೆ ಸರ್ ನಮ್ಗೆ
67 68 69
68. Sir, 68. Sir, 68.
2 weeks.
Sir, 68 23rd ಗೆ ಇಲ್ಲ ಅಂದ್ರೆ 30th ಕೊಡಿ ಸರ್.
ನೋಟಿಸ್ ಎಲ್ಲ ಕ್ಲಿಯರ್ ಆಗ್ಬೇಕು, ಕ್ಲಿಯರ್ ಆದ್ಮೇಲೆ ಬರುತ್ತೆ ಅದು 2 weeks 68 69 2 weeks 69 2 weeks 71
IA ಹಾಕಿದೀವಿ ರಿಲೀಸ್ ಗುಡ್ಸ್ 200 kg ಗೋಲ್ಡ್ ಇದೆ
ಸರಿ
ಹೈಯರ್ ಅಪ್ ಇನ್ ದ ಲಿಸ್ಟ್ ಬಂದಿದೆ
ಸರಿ
ನಾಳೆ ಬರ್ಬೋದಾ
ನಾಳೆ ಆಗಲ್ಲ
24th ಹಾಕಿ ಟ್ಯಾಕ್ಸ್ ಡೇ
ಆಯ್ತು ಇನ್ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ 72
73 ಯಾವಾಗ ಹಾಕಿದ್ರಿ
73 ನಾಳೆ 74
ಲಾಂಗ್ ಡೇ
75 6th ಮೂರೇ ದಿವಸ ಇರೋದು ವರ್ಕಿಂಗ್ ಇರೋದು ಮೂರೇ ದಿವಸ ಬರಲ್ಲ ಮೂರೇ ದಿವಸ ಇರೋದು 1ನೇ ತಾರೀಕು ಮೇಲೆ ಬರುತ್ತೆ 76 6th ಲಾಂಗ್ ಏನಲ್ಲಿ ಮೂರ್ ದಿವಸನೇ ವರ್ಕಿಂಗ್ ಇರೋದು
92 sir.
one minute madam, wait ಮಾಡಿ
76.
ಅಲ್ಲ ಇರೋದು 5 ದಿವಸ ಇರುತ್ತೆ ಅಷ್ಟೇ, ಬರೋದು ರೀಚ್ ಆಗಲ್ಲ. ಆಯ್ತು ಬನ್ನಿ 76 25 ಬನ್ನಿ 76 ನಾಳೆ
77 ಏನಾದ್ರು ಕೊಡ್ತೀರಾ?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗೆ
ಆಗಿಲ್ಲ ಸರ್, ಏನು ಇದು ಮಾಡಿಲ್ಲ, ಅಂತ
ಅಲೋ
ಹಾಕೋಗಿದೆ ಸರ್.
ನಾವು ಡಿಸ್ಪೋಸಲ್ಗೆ ಮೆಮೊ ಹಾಕಿದ್ವಿ.
ಸರಿ ಆಯ್ತು, ಮೇಲೆ ಬರುತ್ತೆ
77 ಪೇಪರ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ
77 ಬರುತ್ತೆ
77 ಏ ಅಲೋ
ಹಾ ಮಂಡೇ 78 79 24 ವೆಕೇಟಿಂಗ್ ಐ ಇದೆ, ಹಾಗಾಗಿ 2 ವೀಕ್ಸ್ ಆದ್ಮೇಲೆ ಬರುತ್ತೆ.
2 ವೀಕ್ಸ್ ಅಂತ ಇದೆ.
ಐವೋ 2 ವೀಕ್ಸ್ ಹಾಕಿರ್ತೀವಿ, ಆಮೇಲೆ ಏನಾದ್ರು ತೊಂದರೆ ಇದೆ ಮೂವ್ ಮಾಡಿ, ನಾಳೆ ಮಾಡಿ 2 ವೀಕ್ಸ್ ಹಾಕಿರ್ತೀವಿ. ಇಂಪಾರ್ಟೆಂಟ್ ಇಲ್ಲ ಅಂತ ಮೂವ್ ಮಾಡಿದ್ರೆ ನಾಳೆಗೆ ಎಂಟ್ರಿ ಮಾಡ್ತೀವಿ. ನೆಕ್ಸ್ಟ್ 74 ಆಯ್ತು, 81 82
82 sir, for 82 sir.
2 ವೀಕ್ಸ್ ಎಲ್ಲ 2 ವೀಕ್ಸ್ ಯಾವ್ದ್ರಲ್ಲಿ 86 ಎಂಟ್ರಿ ಮೋಡ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ ಸರ್.
86 ಅಲ್ಲಿ 3-4 ಇದ್ದಿದೆ ಕೇಸ್ಗಳು ಇದ್ರೊಳಗೆ. GM RAS ಬರ್ಬೇಕು, ಯಾಕೆಂದ್ರೆ GM KDB ಅಂತ ಇದಾವೆ, ಇನ್ನ 4-5 ಇದೆ. ಅಲ್ಲ ಶಾರ್ಟ್ ಡೇಟ್ ಸರ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಲ್ಲ ಗೊತ್ತಾಯ್ತು ಸರ್, ಅದ್ರಲ್ಲಿ ನಂದು ಇದೆ ಅಲ್ಲಲ್ಲ 14,120, ಯಾಕಂದ್ರೆ ನಾವು ಮೆಟೀರಿಯಲ್ಸ್ ಎಲ್ಲ ಹಾಕಿ ತೊಂದರೆ ಆಗ್ತೈತೆ ನಮ್ಗೆ. ಬಿಲ್ಡಿಂಗ್ ಎಲ್ಲ ಕಟ್ಟೋದಿಲ್ಲ, ಮೆಟೀರಿಯಲ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಇದೇ ಆಗ್ಬಿಡ್ತದೆ ನಮ್ಗೆ.
ನಾವು ನೋಡಿದ್ರೆ ನಿಮ್ಗೆ ಅಲ್ಲಿಂದ ಹೊರಗೆ ಹಾಕ್ಬೇಕಂದ್ರೆ ನಾವು
ಸರ್ 87 ಕೋರ್ಟ್ ಮಾಸ್ಟರ್ ಸರ್ 87 ನಲ್ಲಿ ಸರ್
ಅವರು ಅರ್ಜೆಂಟ್ಮೆಂಟ್ಗೆಲ್ಲ
2-4 ಅಂತ ಇದು ಮಾಡಿ ಅಲ್ಲ 2
ಕೋರ್ಟ್ ಮಾಸ್ಟರ್ ಸರ್ 87
ಎಲ್ಲ ಕ್ಲಬ್ ಆಗಿರೋದು, ಅದು ಎಲ್ಲ ಕ್ಲಬ್
ಮಂಡೇ ಬರುತ್ತೆ.
ಗಾಡಿ ರಿಲೀಸ್ ಮಾಡಿದ್ರು 2004 24 ಸಿಂಗಲ್ ಬೆಂಚ್ ಆರ್ಡರ್ ಗಾಡಿ ರಿಲೀಸ್ ಮಾಡಿ
ಸರ್. ನಾಳೆ ಬನ್ನಿ ಸರ್,
ನಾಳೆ
ಶಿವಕುಮಾರ್
ಅಯ್ಯಗೆಲ್ಲ ಸ್ಟೇಟ್ ಚೇಂಜ್ ಮಾಡಲ್ಲ,
ಅಯ್ಯ ಬರ್ತೀವಿ ಸಾಯಂಕಾಲ ಕೂತ್ಕೊಂಡು
ನಾಳೆ ರಿಪೀಟ್
92 ಹೇಳಿ ಸರ್.
ಕೋರ್ಟ್ ಮಾಸ್ಟರ್ ಸರ್ 87 ಐಟಮ್ ನಂಬರ್ 87 ಐಟಮ್ ನಂಬರ್ 87 ಸರ್ 87 ಆಗಿಲ್ಲ ಸರ್. ಸರ್ 87 ಆಗ್ಲಿಲ್ಲ.
ಹಾ ಸರ್ ಹೇಳಿ ಸರ್, 87 ಸರ್.
ಹಾ 87 ಅದೇ ಜ್ಯುವೆಲರಿ
ಸರ್,
ಜ್ಯುವೆಲರಿ ಮ್ಯಾಟರ್.
ಹಾ 1st of April ಸರ್ 87.
ಬಹಳ ಲೇಟ್ ಆಗಲ್ಲ ಸರ್,
ಯಾಕಂದ್ರೆ ಬೇರೆ ಡೇಟ್ ಕೊಟ್ಟಿರ್ತೀವಿ ಸರ್, ಹಾಗಾಗಿ 1st of April ಬರುತ್ತೆ ಸರ್. 87 1st of April.
ಆಯ್ತು ಸರ್.
92 ಸರ್.
82 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಿ ಸರ್? 82
ಯಾವ ಸರ್?
82 ಕೂಡ ನಮ್ದೇ. 82 ಯಾವ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
92 8th of April ಸರ್. 8th of April 92.
ಹಾ ಒಳ್ಳೆ
92 ನಂದು ಸರ್.
91 7th of April.
ಸರ್ 92 ನಾಳೆ ಬೇಕು ಸರ್, ತುಂಬಾ ಅರ್ಜೆಂಟ್ ಇದೆ ಅದು ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಸರ್.
ಹಾ ಹೇಳಿ ಮೇಡಮ್.
92 ನಾಳೆ ಬೇಕು ಸರ್, ಅದು ರಿಮ್ಯಾಂಡ್
ಲಿಸ್ಟ್ ಆಗೋಗಿದೆ 24th ಬರುತ್ತೆ.
24th ತುಂಬಾ ಲೇಟ್ ಆಗುತ್ತೆ ಸರ್.
2 ದಿವಸ ಇರೋದು ಟೈಮು.